Good morning, everyone. My name is Vicky Gala. I'm a forensic professional, work with Kroll, and I'm an associate managing director there. Thank you.
Good morning, everyone. I am Aditya Kumar, pursuing LLB from Campus Law Center, Delhi University. Thank you.
Good morning, everyone. My name is Sanjay Nawaz, and I'm also a law student from Faculty of Law, University of Delhi. Thank you.
Good morning, all of you. My name is Mohammad Razi Ansari. I am a second year law student from Faculty of Law, DU. Thank you.
Good morning, everyone. I am Deepak Kumar. I am pursuing a law student from Delhi University's second year.
Good morning, everyone. My name is Basanta Ramachandran. I am from the compliance function of Bharat Serum Vaccines, which is a pharma company based out of Mumbai. I'm here to get some insight, which will have some touch points with the pharma company. Thank you.
Hi, good morning, everyone. My name is Harsha, and I'm from Bharat Serums and Vaccines Limited. I head the compliance function at the organization. Thank you.
Hi, good morning, everyone. I am Ravina Rani. I'm a solicitor in England, advocate in India, as well as patent and trademark attorney in India. Thank you.
Good morning, everybody. Again, I suppose. I'm Kruti Kalaga. I'm a practicing advocate in Hyderabad and Telangana. I practice in the areas of corporate law at the NCLT and High Court of Telangana. I also take up ADR matters. So I'm looking forward to some great networking today and have a great day, everyone.
Good morning, everyone. I'm Ritu Rastogi, practicing lawyer in Supreme Court of India and NCDRC. It's nice to meet you again. Yesterday, we interacted with some people, and it's very nice to meet all lovely people. Thank you very much.
Thank you, ma'am. Sorry to interrupt you between. I would like to tell everyone that our honorary guest of the day, Mr. Praveen H. Parekh, the president of the Indian Society of International Law, has joined us. So can we have a huge round of applause, everyone, for Mr. Praveen H. Parekh ji. Please continue, ma'am.
And I'm managing partner of our legal firm. Thank you.
Good morning, everyone. Myself, Akshat Mahajan. I am one of the associate in RR legal firm. Thank you.
Hey, hi. This is Srividya Sridhar from Vivriti Capital Finance. I'm into the lending space and have been into the BFSI segment for as long as I have been in the industry.
Welcome, ma'am.
Good morning, everybody. My name is Matthew Phillip. I'm one of the sponsors. We are one of the sponsors, LawCube Technologies. We provide judiciary automation systems. It's a very broad term. I'm here to figure out, how we can work more with the legal fraternity. We've been with the courts. We want to see, how we can bring integration in terms of access to justice. Thank you very much. Hope to see you.
Welcome, sir.
Good morning, everyone. My name is T. Sitara Bhan. I am a part of the in-house legal team for HCL Technologies. And we're here for our second day. I'm very excited to meet and interact. And yeah.
Good morning, everyone. I am Drisha, and I am an in-house counsel with HCL Technologies.
Good morning, everyone. I'm Dhananjay, corporate lawyer and presently working with SCL Tech. Thank you.
Thank you, sir.
Good morning, everyone. I'm Srijit Mukherjee. I am the Director Legal for HCL Technologies Limited. I am here with my team today and expecting to have a good interactive session with it. Thank you.
Thank you, sir.
Hello, very good morning. So myself, Manas Jha. I pursuing BBLLE from IP University, and I am a founder of the Delhi Bachao Manch Foundation and working with the Delhi government for the law student and except of the law student. And we are organizing offline events on the Shahid Divas of the Bhagat Singh, 23 March, 23 March. So any law faculty, any advocates who join to help the law students and out of the law students. So please definitely contact me. Thank you.
Hello, everyone. Good morning. I'm Dheer Sampath. I'm a in-house sports law counsel and a practicing advocate. I currently work for Slate Sports Management Private Limited, and also I'm a football player agent in Indian Super League Football and I-League. Thank you. Happy networking.
Thank you, sir.
Good morning, everybody. I'm Anushka Mahapatra, and I'm a legal counsel with Capgemini.
Welcome, ma'am.
Good morning, everybody. This is day 2 for me as well. My name is Renuka. I work at a law firm by the name of Lal and Sethi based in Delhi. We are a boutique IP firm, so we do everything related to intellectual property. Yesterday's sessions were really exciting, so looking forward to having a good couple of sessions today as well. Thanks.
Sure, ma'am.
Good morning, everyone. I'm Vanishi from Bangalore and practicing advocate, dealing with civil and family matters. It's nice to be here. We look for more sessions. Thank you.
Hi, morning, everybody. This is Smita here, and I'm a GC, presently associated with Harman International in the capacity of legal director. Happy to meet you all, and this is the second day today, so look forward to continuing the fun. Thank you.
Hello. Hi, good morning, all. This is Atharva Vaidya from Pune. I'm here with the legal book, and we are a AI-powered contract review solution, which reviews your contract in under 3 to 4 minutes. Thank you.
Good morning, everyone. I'm Aftab Alam from Delhi University law student.
Hi, good morning, everyone. I'm Sanjeet Kaur Batra, GC with Cummins India. Good to meet everyone.
Welcome, ma'am.
Good mornings. I'm Advocate Sanjay Chawre, practicing with Kataria and Associates in Keys Hajari Chambers. Thank you so much.
Thank you, sir.
Hi, good morning, all of you all. I'm Aditya Ambrose from Bangalore. I'm a practicing advocate. I practice civil, criminal, corporate law, and I'm also the legal attorney for a food and beverage company by name Empire Restaurants. They are a group and a chain of restaurants for well over 50 years now in Bangalore, and we plan to expand in down south places like Chennai, Hyderabad, and Kerala. Apart from that, my hobbies are Western classical. I play Beethoven and Bach violin, and I'm also a sports aficionado. I play soccer and cricket. I'm very, very happy to see all of you all. Today is my first day for the conference, and I'm looking forward to networking with all of you all and having many and engaging sessions. Thank you so much.
Good morning, everyone. This is Advocate Russell Parvez. I'm from Bangladesh. Currently, I'm working with European Commission, and my portfolio is looking after the partnership management and the contract management. Nice to meet you all. Thank you.
Thank you, sir.
Hello, good morning. Shubho Shakal. This is Abu Zafar from Bangladesh. I'm a member of the Supreme Court of Bangladesh and Texas Bar Association Bangladesh. Currently, I am serving as the head of Legal Affairs Department in Summit Alliance Port Limited, which owns the largest stop dock in Bangladesh. And we are the largest energy service provider in Bangladesh. We have also investment in India also and Singapore also. Thank you all and have a good day. Goodbye.
Thank you, sir.
Hi, everyone. Good morning. I am Harpreet. I work with Kroll. So I am a senior professional. I've been working with Kroll for about 2 years now. And I have my colleague, Vicky Gala. He looks after the investigation side of the business, and I look after the BI side of the business. So he's, in fact, moderating one of the sessions today here. We are sponsors of LexTalk as well.
Hi, good morning, everyone. This is Surbi T. I am AGM at R1 RCM Global Private Limited. I have about 11 years of experience as ER professional and currently in the legal field here in the legal fraternity in this company. And I'm handling employment and industrial relations matter for this company. Thank you.
Welcome, ma'am.
Very good morning. I am Saurabh Bagaria, practicing as
counsel practice in Calcutta High Court and various tax tribunals. My predominant area is revenue laws, including both direct and indirect taxes. Thank you.
Hello, good morning, everyone. This is Rohit Soni here from Capri Loans. I am a legal counsel for a Capri Loan for a project finance business. We look out for the due diligence of project real estate project Pan India. And today is my second day in the conference, and I'm very happy to see you all. Thank you.
Welcome, sir.
Good morning. Happy to see you all. This is Prashant Narayan. I'm Senior Vice President, Ujjivan Small Finance Bank from Bangalore. I'm into banking industry for the past 20 years.
Thank you, sir.
Hi, good morning, everyone. This is Apansula from Signedesk. I'm here to meet legal counsels and legal heads of various enterprises and legal firms. Signedesk makes tailored and automated solutions like CLM and other workflow automation tools, which can help legal heads and legal counsels in managing their day-to-day contracts. So looking forward to meet you all. Thank you.
Thank you, ma'am.
Hey, good morning, all. Here I'm Guru Raj again from Signedesk. I was from a tech division, and this is my first day, and I'm one of the awardee at the end of the season today. Thank you.
Congratulations, sir. Thank you. Now we will be starting with the first addressing session of the conference, whereby we will be welcoming our honorary guest for the day, Shri Praveen H. Parekh ji, President of the Indian Society of International Law, for a detailed keynote speech. His extensive industry experience promises a wealth of knowledge as he shares valuable insights that will shape our understanding for the legal landscape. Let us acknowledge and celebrate Mr. Praveen H. Parekh's exemplary leadership and profound impact on the global stage. Please join me in extending a warm welcome to the visionary leader who continues to inspire us with all his relentless pursuit of freedom and justice for all. To welcome, sir, let me call upon stage the Director of Clickaway Creators, Mr. Pradeep Tyagi. Can we have a huge round of applause for Mr. Praveen H. Parekh, the President of Indian Society of International Law? Can we have a huge round of applause, everyone, to welcome, sir? I would request Mr. Abhishek Gaurav and Mr. Pradeep Tyagi to welcome, sir. Can we have a huge round of applause, everyone? Thank you, sir. Can we have the mic? Please welcome, sir, with a huge round of applause, everyone.
My dear friends, as a lawyer, I am used to get and sit up and speak in the court. I'm very happy, Mr. Abhishek Gaurav, Mr. Pradeep Tyagi from the ISL, all the participants in association with Mrs. Professional, powered by sponsor, and my dear participants, ladies and gentlemen. It gives me immense pleasure to address this august gathering as the President of the Indian Society of International Law. I feel honored to be associated with LexTalk World Conference. Indian Society of International Law have lot of professors and lawyers. In fact, it's not sometimes very good for both of them to be together. But I'm telling you that in ISL, we are very good, excellent lawyers and excellent professors. And lawyers learn a lot from professors. And perhaps professors also learn something from the lawyers. And therefore, we say ISL is a very good institution. And we also have the students, they come, and therefore, in fact, lots of time I learn a lot from students. What I don't know, students say, no, but this is, I said, wonderful. It's good. The students today are wonderful. They know much more than we know because, I mean, when I started my practice, etc., I didn't know a lot of things which the students of today can know. So we should learn from everyone, and I do learn, and it is very good to learn from, because there are many things which you don't know, you should know that, yes, of course, I don't know. And therefore, if I don't know, then perhaps I'll learn something of it. But these very students, I find, excellent students. They come out with excellent idea and discussion as if they can argue in the Supreme Court, they can do. So they are very good. I'm very happy that you are having this this function. And the Indian Society of International Law is a premier national institution for teaching, research, and promotion of international law, which was established in 1959, primarily due to the efforts of the late V.K. Krishna Menon ji. He has indeed been a long and fulfilling journey for the ISL that it had earned pride of place among the community of international lawyers throughout the world. This would not have been possible but for the hard work, but by people such as Judge Nagendra Singh, Dr. K. Krishna Rao, Sri G.S. Pathak, Vice President of India, Justice R.S. Pathak, Chief Justice of India, Professor Harman Singh, Professor Chief Justice Chako, Sri Narayanan Rao, Dr. Anand Prakash, Professor B.S.N. Murthy, Sri C.V.L. Narayan, Professors M.K. Nawaz, Sri G.V.G. Krishnamurthy, Sri Ramnivas Mirza, Professor R.P. Anand, Professor Rahmat Kula Khan, Mr. Dr. P. Chandrasekharan Rao, S.P. Jagota, Mr. R.K. Dixit, Mr. P. Srinivas Rao, and host of others. And that is why the objectives of the ISIL inter alia are to foster nationwide the study and development of international law, to interpret through its forums and publications the applications of international law as chiefly affected in India, to encourage the comparative study of the application of the international law in other states, and to promote research in international law. I'll request each one of you to do come to ISIL, and please come and learn from us and teach us also. Come, and it will be very, very good. And I as the president of the ISIL, request you, all of you are most welcome to come. We work from Monday to Friday, from 10 o'clock to 5 o'clock. You're welcome to come. And if you come between 1 to 2, I'll give you coffee also. Because in its endeavor, dissemination, international law, the ISIL has traditionally received wholehearted support and cooperation from the various ministries, particularly external affairs, finance, and environmental forests of the government of India. The ISIL has benefited from the guidance and support of many judges, present and former of the Supreme Court of India and Delhi High Court. The teaching wing of the ISIL was founded in 1964 to further the objective of dissemination of knowledge of international law. It is a matter of pride for the academy that its postgraduate diploma courses are highly rated, not only India, but also throughout the world. The Indian Academy International Law and Diplomacy offers 1-year postgraduate diplomatic courses in international law and diplomacy IFR, international trade law, international environmental law, and human rights, humanitarians, and refugee laws. The conference themes of this year, legal, IP, and legal tech, is very contemporary and relevant given that our legal landscape, like many aspects of our world, is constantly evolving. Today, the topic of my address is one of that is of increasing relevance and significance. The impact of artificial intelligence, AI, on the legal profession, and is titled The Role of Artificial Intelligence in the Legal Industry, Opportunities and Ethical Considerations. While AI offers exciting possibilities, it also raises ethical consideration that must be addressed for its responsible and effective use within the legal system. I would like to draw your attention to the topic that is not only relevant but also shaping to the future of our esteemed profession, the impact of artificial intelligence, AI, on the legal landscape. Living in a world driven by constant technological advancements, the legal field cannot remain immune. As legal professionals, we have historically embraced change and adaptation. Today, we find ourselves at another crucial juncture where we must navigate between the resisting these changes and embracing them to leverage to the potential of AI for the betterment of our profession and of the pursuit of justice. One of the most promising opportunities presented by AI lies in the liability to facilitate effective representations. Imagine a future where lawyers have access to vast repositories of legal data with meticulous analysis by AI. This empowers them to conduct robust arguments, drawing insights from a comprehensive understanding of the legal precedents and arguments. However, as legal professionals, we must never lose sight of the ethical cornerstone of our profession, justice. In fact, justice is the most important thing for us. When law, of course, is there, law is required. At the end of the day, you must have justice. And that justice, it is to be held, to be done by the judges, by the lawyers, and by the professors. And I will say professors are very, very, very important. In fact, in our country, we don't give so much of respect to the professors as we get in some of the other countries. But we must give them a respect, we must say, and accept, because they teach us that any lawyer or a judge who has come must have gone first with a teacher. The teacher has taught you. Therefore, we must go, and they help us a lot of their students and the teachers can teach us. In fact, students can also teach us, because the students of today are much better than what I was, definitely. And therefore, they can tell you, and then perhaps sometimes they think that, what, Parekh, you don't even know this. Of course, I don't know this because I was born in good old days. But that is true. But why not? Therefore, we must learn from these students. We should learn, and they will tell us. And there is nothing wrong about learning from anyone, and definitely not from students. And I find I learn a lot in ISL from my students. I talk to them, I call them, and they come along. What are you doing, etc. And they also feel happy, but they don't know that I've come to them as my teacher. It is good. And it is good because it's always good as long as any human being thinks that I know everything, that is the end of him. He or her, it is end. If you think you know, nobody knows everything, nobody will ever know everything. But whatever we can try to learn, it is very good. And that is why an organization like this we are doing is good. Let us understand from each other what I say, what you say, and then I will find out what I said was not correct or was not partly correct, but someone says was better, and therefore I'll accept that. Therefore, the thinking should remain, and thinking must be done by all of us. All of us, God has given this to us, to all of us. But some of us use, some people don't use, some of you use very little. But you keep on using this. God has given, and that is free of charge. He's not charging. God is not saying every month, give me some money. No. God says, this is yours. Use. And please use. And that's why I believe that I'm a student. It's much, I must know, and more I know, more and less I know, because I know that I never knew. And sometimes some students come to me, talk to me something, and they perhaps think that what is this fellow does not know this? Yes, he's right, that this fellow does not know, because this fellow was born some other earlier time. He does not know, but that does not mean that we should not learn. We should learn, and we can learn. They can learn from us, of course. Not that I don't say that only students will teach us. We will teach them more, but they can also teach us, and we should learn. And it is very good. These students, I find it very good. And one reason why I meet the students is that I look with a younger also, when I talk to the youngsters. So it's good. They talk. I've written my whole book. My thing is there are 3 more pages, but I think I can hand over and I give copies to them. You can have it. And then, in fact, as Chief Justice D.Y. Chandrachud, the Chief Justice of India, aptly stated, a healthy balance between the technology and human intervention is crucial. He emphasized that while technology can be facilitator of the change, the driver of change has been, is, and will continue to be the human mind. Human mind. Human mind. I repeat, human mind. Our human mind is wonderful. It's excellent. And let us use this human mind. And if you have I use my human mind, but if I use with all of you, each one of you, then I learn much more. You will learn much more also. Therefore, this human mind is good, and let us use. Let us not let it. And it works. The human mind works 24 hours. It doesn't stop. It doesn't sleep. The human mind keeps on working. So use us this human mind for all of us, and it is good. And nobody should ever think that I know everyone. Merely because I'm 80 years, I should not think that I know everything, because I learned someone who is 25 years telling me much more, which I can't even think. They say, you and this, Mr. Parekh, you don't even know this. Yes, my dear friend, I don't know. But that is good, nothing wrong about not knowing. Nobody can know everything. Now, by embracing AI thoughtfully and ethically, we as legal professionals and academicians can contribute to a future where this technology services as a force for good within the legal system. We can leverage its potential to improve efficiency, enhance access to justice, and ultimately advance the pursuit of justice for all. I repeat, justice for all. We are all supposed to function for justice for all, not justice for some, not justice for rich people, not justice for men, not justice for children. Everyone must get justice, and the justice must come, and all of us should think that, well, will I get? And what is justice? Justice is not what I write in the books of the law. That is not justice. Justice is what is going to be done. You'll do something just. That is justice. You must be just. So when you function, when you teach, when you learn, when you discuss, everywhere justice is there. And if you go with justice, then you are wonderful, very good. You'll be good for yourself, and it's good for all, everyone with whom you function, with you meet, with you work. And therefore, the word justice, don't use the word justice, is only known by judges and lawyers, not at all. A very young child also knows justice. And justice will say, he's doing something, but my mother is not doing me justice to me, and he will say, cry. He can fight. He say, he'll cry that, why? Because my mother is not doing me justice. Yes. Why not? He's king, but he has a method of telling that my mother, you are not doing me justice, and he's doing it by crying. Why not? So this is justice is very, very important, and that's why I always think that we should, when you do something, Is it just? Is it fair? It is good, then do. If it is not, don't do. And that justice is something we all know, but sometimes we ignore. Perhaps you want to ignore because we think what we want is something not what is justice. But justice is very, very important. And if you know the justice, you function the justice, and every day, not justice on some 1 hour in a year, from morning till evening, as long as you are not sleeping, please have a justice. And if that justice is there, then everything will be fine for you, and you will also be happy. Because at the end of the day, if you have done some justice to your people, people with who you communicate, people who meet with you, if you are doing something justice. So justice, I'm not talking the word justice of someone only with the judges and lawyers, no. Justice, everyone knows. The child also knows justice. That's why does the child says the mother, and he may be right. He's asking for justice and mother is not being justice. So therefore, I follow this and think that it is absolutely necessary and it is possible for us to know. But if you stop and say that, no, I'm a wonderful man, I know very well, I know everything. Nobody knows everything. Nobody can even know, and nobody even think that he knows everything. Because we can learn from anyone and everyone, and then we can teach also. I'm not saying that you have to only learn. You teach so that they will also learn. By embracing AI thoughtfully and ethically, we as the legal professionals and the academicians can contribute to a future where this technology serves as a force for good within the legal system. We can leverage its potential to improve efficiency, enhance access to justice, and ultimately advance the pursuit of justice for all. Justice for all, and all is more important than justice. Justice for all. Let us approach this transformative era with open minds, critical thinking, and commitment to upholding the highest ethical standards as we navigate this exciting yet challenging new chapter in the legal of the profession. I am leaving to go Vajiabad for some speech. I have to give a lecture there, so I'll be not in Delhi. So I'll be please let me know whatever everyone has spoken, and I'll certainly read it when I come back to Delhi. Thank you very much.
Thank you, sir, for offering everyone the coffee. I'm sure after this, everyone will join you at your office. But seriously, thank you, sir, for the insightful speech. It was really a matter of immense pleasure to hear you. And I would also like to take this opportunity to thank our association partner, the Indian Society of International Law, for their continuous support throughout. Please have a huge round of applause, everyone. We have opened the Hall B as well, wherein the IP topic panel discussion will take place. Meanwhile, here we are coming to our first session, which will be a panel discussion session delving into the fascinating realm of artificial intelligence in the legal industry. For this discussion, I would like to call upon stage Ms. Soumya Panda, founder at SK Panda and Associates, who's also the moderator of the panel discussion. Please have a huge round of applause, everyone, for Ms. Soumya Panda. Our second panelist is Ojaswita Srivastava, General Counsel, Africa, Middle East, and Asia Pacific at Securitas. Please have a huge round of applause, everyone, for Ms. Srivastava. Next is Mr. Anubhav Kapoor, Director at Legal Affairs at Ford India. I think he's joining us virtually. And our fourth panelist is Mr. Raghavendra Verma, Group Legal Head, Compliance and Company Secretary at ISON Group. I think he's also joining us virtually. Both of them. So meanwhile, I'll request Ms. Soumya Panda to begin the session.
Hello. So Ojaswita will join in about 15 minutes, but I think we can start with the discussion. This is essentially going to be a discussion between the audience and me, it seems. So good morning, everyone. And I'm very happy to see so many faces, especially this is a working day and we have an option to join in virtually. But joining in person for this session, I'm very thankful to you guys. So basically, coming to this topic, it is a much talked after topic, and most of us know that humanity has been talking about AI since about 1940s. But due to lack of technology and strong data collection processing systems, AI met with something known as AI winters many times. It's only in the last 5 to 10 years, AI has developed so rapidly that we are forced to integrate that into our lives. For example, I am sure that each and every one of us is using an AI tool, our smartphones, and we cannot live without it. These smartphones have multiple AI applications as well. These applications make our lives smooth. Now, with that background, the panel will throw some light on how AI has impacted operations in their organizations, made it easy, made it difficult, etc. And with that, let us get some introductions with starting with Mr. Anubhav Kapoor, if you joined us. I think Mr. Raghavendra Verma is here. So, sir, if you could just introduce yourself.
Thanks, Soumya, for setting the context. So, myself is Raghavendra Kumar Verma. I am the Chief Legal Compliance and Risk and the Group Company Secretary of the ISON Group. I take care of the entire realm of the legal, whether it's called litigation, contracting, whatever you think about the legal sphere. I take care of that and the compliances. ISON Group is into that the IT services and that BPO customer services. We are present in almost 52 countries across Asia Pacific, India, Middle East, and Africa. So we would be talking today about the role of the AI into the legal profession and how, as a lawyer, we are using in our day-to-day life, whether into the legal field or the compliance field or the risk field. So as during the course of the discussion, we will be discussing each aspect one by one. Thanks, Soumya.
Has Anubhav Kapoor also joined? He was supposed to join virtually. So, moving forward, I am Soumya Panda. I'm founder of SK Panda and Associates. I think that introduction was done. So basically, I'm a tech lawyer. I have a degree in computer science engineering, and after that, law. Expertise in indirect taxes and customs and money laundering issues. So like Sir said, we'll be throwing some light on the role of AI in the legal system via some question and answers. So maybe we can start with our first question. Given that half the panelists haven't joined, maybe should we wait for some time or should we just start? I think we should just start. So the first question is, can you share an example where an AI tool significantly impacted a legal decision or a process within your organization? And how much do you use it personally in day-to-day life?
Thanks, Soumya. This is very pertinent question for the to start with. So, I will share my experience and my experience with my colleagues who is in the same field and using the AI. So, honestly, these days we are using AI tools for our legal work more than we used to. Particularly, I take that four sphere where we are using right now. First of all, personally, I am doing in the legal research and the e-discovery part because I just mentioned that we are present in 52 countries, and keeping tab of the regulatory change is getting day-to-day difficult. So for that aspect, legal research and e-discovery tools comes very handy to me personally. And as my discussion with, as I said, that my colleague also, so who is handling the multi countries company, multi jurisdiction company, they are also relying on this tool. Second tool that I am using right now and helping me a lot, saving a lot of time to do me the quality work is the document automation. Like you say, the contract drafting, contract analytics, that giving me the analysis of where we are lacking, what should be included in the contract, something like that. So document automation, repository, how to keep the contract. Now automatically I'm getting that the reminder that okay, your contract is expiring this date, the renewal is coming, 30 days is now renewal, 60 days is now renewal. So complete contract life cycle management I am doing through the AI tool. Then come to the predictive analysis. So I was mentioning other day with you also while I talking to you that I am using a lot on the predictive analysis. Like we have a lot of case. We are 23,000 employee company. So always some cases coming in some jurisdiction like South Africa, for Nigeria, or Kenya, in UK also. So this predictive analysis, legal analysis tool give us the idea about the type of cases when we put the scenario of the situation that we are facing right now in the system. It give me almost 90 to 95% accuracy that whether I should proceed with the legal case or not. This judge is sitting on the bench. What is this judge track record to deal with this type of cases? So this comes very handy, very helpful for me, Soumya, personally. And the case management, how to do settling the case, what is the timeline, filing tools, and the repetitive task like we are the biggest debt collector in South Africa. And the routine work, repetitive document like we are sending the reminder for debt collection or normal first legal notice to the all debtor. That all go by the system automatically. We don't have to do anything on that. So that's coming a very great help to me personally.
Thank you, sir, for your inputs. So adding on to that, I think, again, all of us use AI for some sort of research. We use Google like multiple times a day. That is an AI application. So none of us over here can say, oh, I will never use AI, no matter how old you are, by the way. Because Google, everyone uses nowadays. WhatsApp, everyone uses. Lawyers, we have to research on, say, Manupatra, SEC online, for tax purposes, TIOL, Tax Sutra, etc. So, and multiple times a day. So it's like without using these AI tools, our job is not finished. Imagine how much research you would have to do if these tools were not there with you. Like our forefathers, you have to sit in the library of the court or say some other legal office the entire day and find only one case. So that is the power of AI. Personally, I feel that all of us should embrace it. And like I said, I use it multiple times a day. It does not impact my legal decision making, but it certainly enables my decision making. I decide which grounds to choose, also which grounds should be higher up in the draft compared to others, basis the search results. So moving on, Sir, with nearly 3 decades of experience and currently at Izon Experiences Group in the UAE, how is AI shaping the legal landscape in the telecommunications and IT sector, especially in terms of data privacy and consumer protection?
A lot, Soumya, a lot. You are, I will come to the data privacy part, but I'm telling you that the compliance monitoring, the telecommunication and IT sector, every day government is coming with a new regulation in each of the country. That the way technology is evolving and developing, the legal fraternity has to keep pace with that, and that every day some new law is coming in some country like uh, uh, Nigeria Communication Commission has come up with a new regulation few days back. South Africa the same way. So the compliance monitoring, we are getting a lot help from the AI system. I will not take the name of the any company here. It will not be good. I'm not promoting and advertising any company here, but I'm using that one compliance monitoring tool, AI based tool, and then I'm keeping track of every regulatory development happening across globe. So that's helping me a lot on that part. Coming back to data privacy, the way so this compliance monitoring tool is also helping me in data mapping and the classification of the data in my organization. So it's very easily identifying that this is normal data or or it is a sensitive information, and bifurcation of the sensitive information at the same time is giving that. And I'm thankful to my IT team and the service provider from whom we are taking this, have taken this services. That at the same time, they are telling me for this sensitive information, this consent form is in the system or not. Because we all know that for collecting any sensitive information, explicit consent is very much required. Is very much required. So the way they attach this sensitive information with the consent information, we immediately get the red flag. Okay, for this person, you have this sensitive information, but consent is not in the system. So we are immediately taking the step to do the compliances. So this is really helping us to compliance with the data privacy regulation. The other data privacy aspect is the privacy impact assessment. Earlier, you used to hire that consultant, outside third-party consultant who used to come to me to our office and do the privacy impact assessment. This software has automated this and giving us the result. So I'm not saying that I'm totally or 100% relying on that result. I'm taking the help of the third party consultant, but my cost has reduced because now the scope of the third party consultant has reduced. They are just verifying the report that is being produced by this AI based software. So my cost has reduced on that aspect, and my privacy impact assessment is automated now. Similar ways, you use also the consumer aspect. We are in the consumer service, you know that, and we are the largest consumer service provider in Africa region. And so so and we all experience that. You say that the Google is the AI based AI based. You all seen that how as soon as we open some software and go to through Google, we type some okay Amazon, some goods in the Amazon, and suddenly after 5 minutes, same type of brand promotion start coming to my mobile and my laptop. So this is how they are doing. They are doing that the personalized service to you using this AI-based software. So we are also using that AI-based software to do the personalized service to our consumer across Africa. So that's helping us a lot, and at the same time, like fraud. So so one of our services is the debt collection. Another is the call center in Africa, and mobile money is a big big business in Africa. Mobile money in India has come much later. I don't know. Still in India is in the but full force. But Africa is mobile money is since 2011 and 12. And mobile money, there is always there is chance of fraud. I used to handle these frauds, and AI tool very easily detect the fraud and we take that preemptive. We just do the correction as soon as you identify that there is some fraud is happening or there is chance of somebody is attempting this fraud. So in this way, I think that this tool's really helping me in my sector.
Respected panelists, sorry to interrupt in between. We have opened Hall B, wherein the panel discussion on the topic, Technology and Access to Justice, discussing how technology can bridge the gap, has commenced. So interested participants can please move forward to Hall B. Thank you. Please continue.
I like how everyone is still sitting. So I guess you still like what we are discussing. So adding on to what he said, I think in the next 5 years, the most lucrative job would be that of a CISO, Chief Information and Security Officer, because it is his duty and his team's duty to make sure proper checks and balances are there in place in each and every organization, which is compliant with the domestic laws as well as international laws. So that is going to be a very, very big job. As well as now, the second important job would be that of a data fiduciary. Now, he's the one who is supposed to protect all the data of the principal and ensure that the data that is being provided is not misused. The data which is not necessary is not even stored. So I think these two jobs is something that all of us can look forward to. Moving on. So your organization has a global footprint. How do you navigate the varying legal and ethical standards for AI use across different jurisdictions?
Soumya, I will come to that part. Before that, I wanted to hear from you because I am talking from that in-house counsel perspective. You are in the private practice, and I want to hear from you in the private practice how you guys using this AI tools into day-to-day life, and how is it helping you from your perspective?
So thank you for the question. So basically, I'm a litigating lawyer. So I don't use a lot of these fancy tools which are sponsoring this event. I use the basic tools which are like Manupatra, SEC Online, TIOL, VAT, Tax Sutra, etc. Then for tax purposes, we have a special dongle which is called Excus, which has amazing search results. As in, your tax practice is not going to be successful if you don't have that small dongle. Now, additionally, the difference, what I have seen, the difference between Chat GPT 3.5 to 4 is amazing because they opened their source, and so the changes that it had is something that I can personally actually use. I even, in fact, tried using it to sort of form an email that had to be sent to a client. And after I gave proper prompts, now I'll talk about the importance of prompts over here. The result that it fetched me was amazing. I think it did a better job than I could have ever done to help my client. Now, over here, yes, I have trained the system. I have made them understand what sort of answers qua the tax practice am I looking for, what sort of client base I have, because they have a data of not my client details, but just the name of the clients that I cater to, which is easily available in the public domain as well. So those were my personal examples. Additionally, I tried to use, I think, contracts.ai and spot draft. I think the results were not up to the mark, especially because these AI tools are designed by international organizations. They do not primarily cater to Indian market. They've not been designed to come. So this is Ojasvita. So I'll just finish what I was saying then. So these AI tools have not been designed by an Indian person, Indian organization. So they do not have Indian case laws or to quite some extent Indian acts as well. Taxation is a very different ball game. I think that's the last where AI will ever touch. So when you use any of these tools for Indian context, Indian answers, it is still very difficult to find contextual answers. If you're using it for an international legal jargon, I think it is still usable. So I hope so that answers your question.
No, that's very much answer my question because see, because as I use for my UK-based operation, I use for my South Africa-based operation. You rightly said I have never used for the India-based operation, but I use for the South Africa and UK-based operation. This predictive analysis is more its accuracy is between 90 to 95%. Human touch is anyway interpretation analysis. We have to do as a human. You cannot 100% depend on the AI-based research. Our interpretation, our skill analysis is in any way required. But I was just hoping to also use for the because in India also we have around 6,000 employee. A few cases used to come. So that's why I'm taking guidance from you. Thanks, Soumya.
So we are joined by Ojasvita, and please introduce yourself.
My apologies for being late. Gurgaon to Delhi traffic is absolutely horrible, but good to be here and good to join the panel. I'm Ojasvita. I'm the General Counsel at Securitas Africa, Middle East, and APAC.
So we've discussed some of the questions. I think the first question that I would want to ask you is, what are the examples of AI tools that you use in your organization, say day-to-day work, and has it personally benefited you? Do you use it every day?
Absolutely. So we have implemented some bit of artificial intelligence in the legal function, and we are in the process of adopting more of it. I think right now the use case is more towards contract review. That is something that artificial intelligence has been trained to a large extent. There are good tools out there that can do contract review with 95 to 97% accuracy.
Wow.
At the end of it, you have a lawyer to make sure that it is accurate at the end of it before it gets signed. But then there are also other use cases for it, which we are exploring right now, which include things like a policy bot. So across an organization, you have multiple policies, 30, 40 policies, etc. And a lot of business users have questions. Can we do something like this? Is it allowed? If we have to do it, what kind of approvals do we need? Things like that, which basically needs good understanding and knowledge of the policies. And to answer these questions, our lawyers were spending a lot of time because they have to literally go through the policy, find a clause, subclause, etc., etc. So now it's possible to actually train an artificial intelligence on the policies. And you ask them a question similar to ChatGPT. All these GPT-based AI tools are actually, very efficient in this. So you can ask it a question: can I go ahead and sell my product to X country or X client? And it will do the entire background check. It will do, what are the approvals that are required, whether there are any sanctions against that particular client or against that particular country. So there is a huge amount of use case for artificial intelligence going forward as well.
Absolutely agreed. I think the efficiency has increased in the last couple of years to about, like you said, 85 to 90%, if not more. So my next question to you, Jaswita, is as AI continues to evolve, how do you think organizations and legal professionals such as us should strategize when adopting the use of AI to stay ahead in understanding as well as leveraging AI in compliance and legal risk management?
I think the first step where we need to start is to not have a hesitation towards adoption of AI. I see that across a lot. And there are some people who are very traditional who would rather hire 5 extra lawyers than actually looking at a technological solution, even if that is more cost effective, mostly because of the lack of confidence in an artificial intelligence or in any kind of technology for that matter. So first thing is, of course, warming up to the idea of using technology. Secondly, there is this whole myth or whole hesitation that AI or using tools is going to take away our jobs. It's going to make people redundant. I think our technology and artificial intelligence especially is there to make it more efficient or make the same lawyer more productive. In the same amount of time that one lawyer can do 5 contracts.
Absolutely.
The artificial intelligence, with the help of artificial intelligence, they could probably do 100 contracts. And to give you an example, when we were adopting or we were looking at the tools, we ran a 776-page contract in the tool, and just to test, its efficiency. And usually my lawyer would take about a week to do a contract review like this. These are very complex construction contracts, electronic security contracts. And the AI tool that we use was able to do this in 26 minutes. So and with 97% accuracy. So that's the kind of level of accuracy that is there on and off the shelf, untrained, like buying from the market kind of a product. It wasn't like we were trained it on Securitas contracts or anything. So there is definitely a good use case if we start adopting it, if we start looking at it. And yes, it's going to take some time to also make sure that we have the level of comfort in terms of compliance, because there is this scare of data privacy and things like that. So there's definitely something that we need to move towards. And the longer we wait, the farther behind we're going to left. So
absolutely, totally agreed. The longer we wait, the farther behind we are going to be. So adding on to what she said, now my perspective is going to be largely out of my experience in taxation. What I see is that a lot of operations which are compliance based, which are data entry, which are filling up a form, GSTR entries, etc., where a lot of human error comes into play. And because of these small human errors, they've written 1 instead of 2, they've written A instead of B, etc., the case comes to the court. And we see a lot of these cases where just because of some procedural mistakes, substantial benefit gets denied to the assessee. I think these errors can be totally avoided if you start adopting AI as soon as possible. And as regards the job factor, I think we'll discuss that a little more elaborately. I tend to disagree a bit. I think some jobs will get affected, but more on that a little later. My next question is to Raghvendra sir. Also to you, Jaswita, actually. So how can we tackle the biases in the AI algorithm, and who should be accountable for the AI-based decisions?
Yeah, very good question, Soumya. But before that, on the lighter vein, I want to add what Ojas was discussing, that it is not going to take the job, but at the same time, she explained that she saved the lawyer cost, outside counsel cost, uh, for 1 week timeline. You hourly rate to the with the software. And I also give you example that privacy impact assessment I am doing. So is anyway going to impact the whole environment, whole ecosystem. But at the same time, because evolution is always, and whenever any technology is challenging mankind has everywhere, every time comes winner for that. So that I'm sure, but it is one lighter. Yeah, coming to your question on the biasness, yeah, that's there. That's there because in all AI-based software, AI-based applications is basically working on the basis of how it is trained. Uh, now that the chat GPT, she was mentioning that the natural process language, it is trained on that. And if we are not properly trained for particular in any litigation, if you are using that only one set of document when that type of case has been won by that applicant, and we are not putting that in the for the training of the AI application, the other part, the other side of the case also, then we are not going to get the result very fairly. So it's all depends how this AI data is trained, and it's all depend that the application that you are going to buy from the market, you should do the proper check that this and this question is very important as far as the e-discovery is concerned and document review is concerned, analysis is concerned. If this is not properly trained data, then result is not going to be fair, and if result is not going to be fair, and on that basis, if you are advising to our company or we are advising to your client, then you are going to be accountable. So I am going to be accountable if some I am advising something that on the wrong data, that obviously the advice would be wrong, and advice would be wrong, then client and my company has every right to sue me, because I would be accountable. In that case, you would be accountable if you are the outside counsel and you are advising your client. So accountability lies with the person who is advising the third party. In turn, you can have the contract with this software application provider and I sure that they are not going to change their contract as per our demand, because there is a ready-made format and they don't agree, never agree this application provider to change even a single line and comma full stop from their application, this contract. But we can ask for the indemnification from them, because there is their application that is the biased and we are using. So they are. But the buck has stopped that. I don't think that government has to come with a very tough regulation to take care of this ethical part in this in the all AI software. And I believe that on the international level, things are getting changed. Things are getting changed these days, like uh, OECD, European Union has also come with ethical guidelines on the data on that AI use on the application. So yeah, so all three are responsible. Like, we are responsible. We in turn that make responsible for this application software provider, and then government has to come with that robust regulation, so that this whenever somebody is not complying with that regulation, then there will be proper penalty, proper fine, and whatever is government thing, that would be fine. But regulator has to come with some robust regulation.
Okay. Completely, very good, valid points. Let me start by addressing or going to the point of, not being able to hire more lawyers because we are using artificial intelligence. This is actually very similar to kind of discussions probably that happened when computers were getting adopted, right? That computers are going to take away our job.
Yeah.
But the fact of the matter is, yes, probably, some things that were being done by hand are being done by computers now.
Absolutely.
And whether you like it or not, artificial intelligence is here, just like computers.
Absolutely.
So the better, the faster you adopt, or the sooner you adopt, the easier it will be. Also, on the same time, the kind of products that our companies are selling, the other functions are using artificial intelligence. The finance, the operations, the products of the company itself, or if you are working in a law firm, your clients are using artificial intelligence, and if you don't use it or you don't get it, then you're going to be left behind. So that is one of the reasons why I would always encourage for lawyers, whether in-house or whether in a law firm, to try and use and get used to artificial intelligence. On the question of bias, I think Raghavan sir, said it very well, that it depends on how the product is trained. Okay, one way to avoid biases is to train the AI yourself. So you buy Azure or whatever artificial intelligence, and you train it on the use cases in-house. So you avoid the biases that would be there on, say, something like a ChatGPT or an an open source GPT sort of a platform. So one way to do that or avoid biases is that. But even though I'm a very strong advocate of adoption of artificial intelligence, I am also a bit hesitant and reluctant in advocating for the use of artificial intelligence in delivering justice. This whole concept of trying to look at what is the trend of a particular litigation from an in-house perspective is very good, because I can look at my cases and I can tell my management that, with a case like this, the trend has been with this court, 70% chances that we are going to win, or either way, right? But for a judge to start using artificial intelligence to review all the evidence and then say, okay, this is what it should be, that is where biases will creep in. I don't believe that artificial intelligence should be used by courts or by judges, especially, to try and advocate or try to dispense justice, because every time you use the artificial intelligence, you're training it. So whatever as a judge is my bias or is my opinion will get trained on the GPT. So it's more of a precedent sort of a trend. And I think that could harm or not go very well with the idea of delivering justice. So that's my personal opinion, that everything else is good, but when it comes to delivering justice, I think we should keep artificial intelligence away and use more human intelligence.
Yes, absolutely agreed. I think she has more experience in-house and it works very well for her. For me, because I'm a practicing litigating lawyer, yes, all lawyers have biases. I am full of biases, but the judge should not have a bias when he's deciding a case, and I totally agree with her on that. Additionally, I would like to just I think most of us must have read the news about a couple of days back where 20 big tech giants in the AI, Microsoft, Stability AI, OpenAI, came together and agreed to sign an agreement where they said that they will not use AI disruptively. They agreed that there'll be certain checks and balances while utilizing these AI tools in the system. So I think that is something that organizations together can look forward to over and above governments putting in a regulation and a check, which it will, but that will take time. I think private organizations can do it faster. Additionally, these organizations can inculcate these checks and balances within their systems, with the junior most person as well as the senior up in the hierarchy. Again, stressing the importance of the CISO, because it is the CISO's duty to make sure that these checks and balances are set in place, are being utilized, and people understand what these checks and balances are and what they are for. So those are my 2 cents. Now, the most important question, which we have partly also discussed, what are the fears and inhibitions around adopting AI tools, and will it take away all our jobs? Let's start with you.
It will definitely not take away any kind of intelligent and creative work, because that is where you use human, intelligence. So anybody who is coming up with solutions, how do you solve this case? What can be our approach? That work is always going to be with the lawyers. That's never going to be taken away. The data entry work, things that are repetitive, things that are very clerical in nature, are definitely going to be replaced by, artificial intelligence and like things like that. When it comes to fears, I think there should definitely be this. I mean, it's good to adopt technology and use it, but there has to be certain parameters. Like you said, these organizations came together and they signed an agreement. But ChatGPT is already out there. OpenAI is already out there. So there are people already using it for deepfake videos, for scams. I think last month there was a scam in Hong Kong where a Hong Kong head of business was on a video call where he was told by his management in Europe that this is the amount that you have to transfer. And because he was on video, he did it. But the fact was, it was a deepfake video. It was artificial intelligence basically masking somebody else's face and,
So in fact, this agreement happened because I think we all saw that clip where Joe Biden was in the hospital lying because he couldn't do his presidential duty and all of that. So this was exactly why this agreement was signed. So
Correct. There are going to be, ethical norms that people are going to say. There are going to be governments that are going to try to regulate it. What I'm saying is the monster is already out of the bag. So it's already out there. There are people who are using it. After this agreement was signed, this deepfake cases and incidents are continuing. So there still needs to be some amount of checks and balances, some amount of people realizing that no, I should not just depend on the technology or depend on a video call. I should also give them a phone call, talk to the person, something like that to verify. So on that would be my 2 cents, in the sense that yes, we need to adopt it, but we also need to understand what are the checks and balances and be smarter than the thugs out there.
So what are your thoughts?
Yeah, so just has put very correctly. I have few things too about this use of AI, the legal profession. I'm not so. First of all, I'm very. I always advocate about the adoption of the technology. So and it is the future. It is, we cannot deny that. So if you're not going to adopt it, you will be left out. So that is no doubt. Having said that. See, when I was growing, how I used to learn when I going to my my senior, he used to give me that, okay, जाओ इस case को पढ़ लो, go read this case, and bring that this type of the similar case to me, and we used to find from that file and that, okay, this case is relevant to this litigation, this case is relevant to this case. We are learning that. So we are getting what we are learning, we are getting the expertise in that domain. Now, if this going to be done by that e-discovery and the research-based application, the basic learning of the new people who is coming to the profession, I'm just little skeptical there how they will get this skill, the what is this case, because when you are searching for the case, reading that, and then going to briefing your senior that, okay, sir, this case is relevant to this, and this fact is this that. That was very essential for developing any professional and getting very core insight of any profession. So that's going to be missed. I don't know how I don't know at this point of time. I don't have answer for that. How this will come up, I don't know. So this is one of the fear I have. Biasness we already discussed, and that and the personal touch, lacking of the personal touch. Anybody will not want. See, I am in the call center industry also. Still, and we are using a lot of chatbot to answer that. This did all these through the chatbot. You type and then getting answer, but still we feel that, oh, I should have the call. I should call the agent and talk to the agent, because this personal touch that's missing is going to have a lot of impact in the legal profession also. Client always want to talk to you, rather your virtual assistant or the chatbot. So another major fear that right now I have about using our client, using our company data to train the software. Either law firm who is training their data AI module, whether getting the consent of their client to use their data for this training, I don't think so. This is the total breach of the confidentiality, because we as a lawyer have a breach of trust, breach of confidentiality towards our clients, and we are using their data to train our AI module without their consent is total breach of the trust, breach of the confidentiality. How we are going to resolve in the legal profession? I don't think I don't think anybody can answer right now at this platform. And I through you I ask Soumya, through you I also want to get guidance from the audience there. They are the learned audience. How to tackle this breach of trust and breach of confidentiality part, because they can guide us also, because they are the senior people there sitting there. So so this the breach of confidentiality in the data privacy for the training is the biggest fear for me at this point of time. And and the expert, the junior, how to train the juniors, and when juniors are coming into the profession, whether they are properly skilled to do and help the seniors. That's the two things I'm really concerned about.
Beautifully covered all the points. I would just like to add, again, my perspective is very, as a litigating tax lawyer, I had a client who uses ChatGPT for initial letters and drafts that they want to submit to the department. Now the department confirmed the demand. So then they came to me that we have given all the answers, etc. But the department is still confirming the demand and they've not gone through that. I said, okay, let me see what you have drafted and given. So when I read, the answers are so contractual in nature. The answers are so catering to international market. So, what I'm trying to bring over here is that when it comes to taxation laws, a lot of it is decided by the practical aspects of how taxation is dealt with in India. Investigation is totally dependent on the person who's investigating. So you cannot give them a very standard English answer and not cater to their egos and the answer that they are looking for. So that is where my fear is that we may use ChatGPT, but let's not use it all too much and um, uh, so much so that it hampers our own problems even more. I think we are left with only just enough time for one question. So if the audience would like to ask any question. Yes, sir. Mm-hmm. 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 Mm-hmm.
But are not at all actually
Real.
existent.
Yes.
With a declaration stating that this is true and genuine.
Mm-hmm.
And the lawyer actually filed it in court. There are a couple of cases,
Mm-hmm.
a few more in fact,
Mm-hmm.
until it was proven to be falsified, fabricated.
Mm-hmm.
So down the line, while we are supposed to keep abreast of technological advances and changes, do we run the risk of having a lag in our research and human intelligence taking a backseat
Mm-hmm.
while being over reliant upon these kind of generative AI tools?
Mm-hmm.
For example, ChatGPT.
Mm-hmm.
Tomorrow, Microsoft brings up another rival, and they have this.
Mm-hmm.
When it becomes too tech savvy,
Mm-hmm.
do we also have cases that we have never heard of before, and in fact, even the Supreme Courts have never heard of,
Yeah.
being presented as genuine pretentiously?
So the two lawyers who actually presented this case in New York, they lost their licenses. Because using technology does not mean that you stop using your own intelligence.
Yes.
So yes, you adopt technology and yes, you use ChatGPT, but that does not mean that you start using it for research. ChatGPT is a generative AI, which is like literally trained on everything on the internet. It is not accurate. There is no claim that OpenAI says that, it is going to be accurate. So if anybody starts using it blindly, a generative AI of the internet, it's obviously, going to land you in trouble. So you need to know, like, I mean, it's kind of silly to be using ChatGPT for legal research when it is not trained. It's like doing legal research only and exclusively on Wikipedia. I mean, it's silly to be doing something like that. And on data privacy also, the concept of data privacy deals with personal data. So if it is related to my personal data, then it is impacted by data privacy laws. If it is general data, if it is anonymized data, there is no risk to data privacy. That is how artificial intelligence is trained with anonymized data. So it will take away all the details of the people and anything that can actually connect you to that individual. And it's going to train you on the actual content of a contract. For example, if there is a contract on, that contains an assignment clause, it will review 50 contracts with no names of individuals, 50 contracts that are reviewing assignment clause. And that's how the artificial intelligence gets trained. So there is no risk of data privacy law violations. And of course, if you are using technology, you still need to use your human brain. Doesn't mean you stop, I mean, it's so unethical on the part of the lawyers who got paid by the clients that they just put something on ChatGPT and they printed it out and they submitted it in the court. So they obviously were right in getting their licenses cancelled.
Actually, just to give one context, I think AI has become so advanced. Like what she said is absolutely true. But a recent study also says that even though we put data wherein we do not give personal data, AI has become so evolved that they can guess who the person is. That is, if you remember, one of the news was that the girl was not pregnant and she had not told her father, but the father got pregnancy kits at home. So that is where the this issue was highlighted, that even if it is anonymized, like she said, uh, after they get evolved to a certain degree, they can guess who it is. So that is where, relying on it too much without using your own intelligence is not something that I would ever agree to. After all, it's we who have made AI, not vice versa. I think we
Thank
can
you,
go on and
our
on,
esteemed
but
speakers, for your valuable and insightful speaking session. We'll have to stop these discussions as we're time bound, though we were loving to hear your insights. And I would like to take this opportunity to specially thank Mr. Raghavendra Verma, as ISON Experiences is our diamond sponsor. So thank you, sir, for your support throughout the conference. Thank you, ladies, for this panel discussion. Please have a huge round of applause for our panelists. Now we would be dispersing off for a 30-minute break for tea and refreshments. Let us get back fresh and mentally warmed up state to witness the other discussion sessions. So thank you, everyone. See you later. Meanwhile, we have started the panel discussion in Hall B. So interested participants can move to Hall B as well with their cup of teas. Thank you.
नहीं है ना? नहीं है।
मैं आपको मसल मॉरिशस का एजेंडा दिखा रहा हूँ जो प्रेजेंटेशन बनी है। मुझे ऑनेस्टली नहीं लगता कि मिस्टर सहगल को पहले भेजने की या भेज की जरूरत है। लेकिन मिस्टर सहगल आए हुए हैं, तो उनको आप ये दिखा सकते हो। ये हमारे आइटम्स हैं।
Ladies and gentlemen, I would request everyone to please be seated. We're about to start the next panel discussion in next 5 minutes. I request everyone once again to please be seated as we're about to start our next panel discussion. I would request everyone to bring their cup of teas and please be seated. Okay, ladies and gentlemen, we're finally back after a high tea session. Now we will witness our second panel discussion of the day on the topic exploring M&A amidst disruption and transformation, whereby we will be focusing on understanding the importance and insights of mergers and acquisitions in the professional domain. So let us welcome our panelists for this session. The backdrop for the panel. So our second panel discussion session for the day on the topic of exploring M&A amidst disruption and transformation, whereby we will be focusing on understanding the importance and insights of mergers and acquisitions in the professional domain. So let us welcome our panelists for this session. Our first panelist is Mr. Sanjeet Kaur Batra, Group Vice President, Legal and Legal Head, India at Cummins India. Please have a huge round of applause, everyone. The moderator of the session, Mr. Pathik Arora, General Counsel at Senvian India. Please have a huge round of applause, everyone, for Mr. Pathik Arora. Our third panelist, Mr. Panduranga Acharya, General Counsel at Zepto. Can we have a huge round of applause, everyone? Our fourth panelist is Mr. Nikun Savalia, Head Corporate Legal at Bayer Corp Science Limited. Let's have a huge round of applause for all our panelists.
Hi, people behind the scenes. There's so much of noise here on the back. Can we request them to come and fill the hall? Anyways, so as the topic says,
I would request everyone to please be seated and hear to what our panelists have to share.
yeah, panel discussion. Yeah. Hi, everyone. And thank you for being here. Today's topic, pretty relevant in the scenario, M&A, MS disruption and transformation. Unlike the topic that I was moderating yesterday on force majeure, where I had to try and put the fun element in it, I think M&A itself is fun, so I don't hopefully need to add any spice to it. I will just set the context before I move on to my fellow panelists. As you know, most of them, all of them actually work for large corporations or startups, and would have their own own fill as far as M&As are concerned. But just to give a context on what is happening these days as far as M&As are concerned. Until 2021-22, there was a lot of traction that we saw. This market was pretty bullish on M&A scenario. However, 23 somehow saw a huge decline in the M&A space. Of course, there have been reasons around it, mainly about high cost of capital, high financing costs. High financing cost, high cost of capital, and therefore we really saw a huge decline as far as 23 was concerned. In fact, the value of M&As almost halved to $2.5 trillion in 23 compared to about $5 trillion in 21. Not just the value, the amount of deals also squeezed to almost 20, squeezed by almost 20%. From 65,000, it came down to about 50,000 deals in 2021. And in 2023. And in addition, what we also saw is that the large deals, large deals squeezed significantly. The deals, large deals, when I say, I'm talking about, say, more than $5 billion deal, they came down significantly. I mean, came down by almost 60%, which was a huge concern also, and a huge opportunity also. Opportunity from a perspective that, which actually meant that people were looking to distribute the risks, the risks among, smaller deals, smaller acquisitions, smaller mergers. And that's what we saw in 2023. However, now, as we speak, the market is again bullish in 24. Don't ask me reasons, because I don't know if I'm completely convinced with the reasons, though the pundits say that we have reached the tipping point. There's no way we can go further. I mean, we can slide further. And maybe that's one of the reasons we'll just go up. I don't know what my fellow panelists think here, but I am not completely convinced. Especially it won't happen unless we see the cost of capital, the interest costs, financing costs stabilizing and maybe going down. Unless we see that, it is difficult for us to really comprehend what's going to happen. Though, of course, 24 until now, the scenario has been quite the same. Of course, there's been traction. People are now talking about deals, talking about larger deals, but nothing really that has really hit from a positive perspective. The larger deals, or most of the traction that has happened in 23 deals has been basically, say, energy space saw couple of, or the largest deals in terms of value globally. One was Exxon proposed acquisition of Pioneer. Second was Chevron acquiring Hess. However, you may say that was an aberration. Those were deals close to about, say, close to, or maybe $50+ billion, but those were only aberrations as far as last year was concerned. Now, let's see what happens. The other reason that we see that 24 maybe excuse me. The other thing that we see is that, there is a lot of room now for consolidation with the businesses, a lot of businesses under stress at the moment. And a lot of businesses that are trying to create value for their specific businesses, their specific segments. As you would have recently heard of, very recent example being Tata Motors, which has, segmented its businesses, EV on one side and the personal or private vehicles and commercial vehicles on the other side. So I think that's what you're going to see more and more as far as 24 is concerned. The segmenting of businesses, consolidation of businesses, and then putting some businesses to, or opening those businesses to M&A. This is, what normally is, I think, we're going to see. Now, with this, maybe I will, go to my first panelist, Sanjeet. So, Sanjeet, what, I would maybe, I'm sure you would have, in your life done a lot of M&As, cross-border, domestic. So what are the considerations or factors maybe you see, or you strategize or advise when you advise in the management on how to approach an M&A? What are your considerations, or what are your different considerations depending upon whether it's a cross-border M&A vis-a-vis a domestic M&A?
Thanks. And good morning, everyone. Pleasure to be here. And thank you all for, sparing time and attending this event. So going back to the question, M&A is a reality, good, bad, ugly, it's here to stay. M&A is never easy, whether it's domestic or it's a cross-border one. But the complications of a cross-border M&A are much different than when you're dealing with a domestic one. Because in domestic, typically you would have one jurisdiction which is involved, whereas in a cross-border or a global M&A, there are multiple jurisdictions that are involved. So the broad considerations that form the basis of the advising is one, the cultural differences. Each country has its own cultural differences. And of course, each country has its own regulatory and legal structures that have to be factored in. And the methodology of valuation, for example, what are some of the approvals that are required, whether it is the merger control, how much foreign investment is allowed in different sectors, what are the taxation, as all of you know, tax drives the crux of how a M&A deal is structured. So what are the tax considerations in different jurisdictions? And on the basis of those tax considerations, what are the deal documents that have to be finalized, that have to be executed in each country? What are going to be some of the closing conditions? And small things like, your employment terms. Each country has very different employment laws. So what are going to be some of the employment terms, closing conditions? How are retirals going to be treated? These are added layers of complications that drive a cross-border transaction. Also, normally, you would have one closing date globally, but the closing cannot happen unless you have approvals across all jurisdictions, especially when we talk of merger control filings, etc. In practically every country, you need prior approvals in all the major jurisdictions before a deal can be closed globally. So that adds a very nuanced approach. You can have a closing, but you also need to be prepared that in case you don't get the regulatory approvals, what do you do? What are your various milestones, etc., that have to be factored in to make sure that it's a successful M&A closure? And due diligence. Again, each country, you have specific business that operates in a certain way in each country. So when it's a global M&A transaction, the due diligence in each country, what are the numbers that are factored for each business? It just is a separate ball game. And some of the things that help in these transactions is, of course, having a very strong collaboration in the internal teams. You have one central team, but you make sure that all the different countries are a part of that functional team to be able to provide inputs and drive the whole process.
Yeah, sure. Thanks, Sanjeet. No, I agree. A domestic transaction vis-a-vis a cross-border is completely a different ballgame, and your approach has to be absolutely, is normally absolutely different, especially when cross-border is like spread across jurisdictions. It is no easy game to know or understand the regulations of each country. And then you have to, of course, liaise with or coordinate with various councils in each jurisdiction. You also have an objective in mind for an M&A and how it is really harnessing with the objectives that each one of the targets may have. It surely is a fun game, to be honest, at that point of time. But yeah. So with this, maybe I'll just go to Panduranga first and ask him what suggestions, Panduranga, would you actually generally give to your management or board for harnessing the real value of M&A, especially both from the operational strategy perspective and maybe key talent perspective.
Yeah, thank you, Pratik. See, in the strategy conversations, mostly general counsels are excluded, right? The point when it comes to what is the willingness of a general counsel to understand what was the strategy and what actually the objective of such merger or acquisition is concerned. Therefore, it is important for the general counsel to make sure as to align one's objective along with the organization objective. That's very important aspect. And insofar as once the objective is clear for the general counsel, the general counsels will have to like assume the risk officers and then start looking at all the risk attached to the transaction or a probable risk attached to the transaction. Obviously, general counsels are in good positions and capable of understanding the risk. All right, mergers, you will have like issues we'll have to deal with throughout the transaction, not only at the stage of strategy, but also at the time of closing. You might have to look at like documentation closing, right? Implementation agreements and merger scheme documentations, etc. Like India is all right, but in case of a cross border, it is even more complex. The important aspect that you may have to deal with is the stakeholders' interest, like shareholders' interest, right? If each of the shareholders will go into a panic mode, right? For them, it is very important to not only protect their interest, but there are certain documentations in the process which will come along, will also talk adversely to their SHA, right? What will happen to their post-merger SHA, and what will happen to their rights? Will those rights will flow from the parent to, right, post-merger scenario, when they will be holding shares in Indian company, yes or no, right? In case of a cross-merger transactions, cross-border merger transactions. But what is so important at the same time is tax implications that may arise in such transactions, right? That's very important. So if you work along with your finance tax team and also like global tax advisors in such cases, you will be able to like sail through this, anticipate these questions. Most importantly, like build your cap table, right? Swap ratios, show them, articulate it. Also like show them what if when there is a future fundraise, right? How it gonna impact the cap table, specifically what will happen to the dilution, etc. Like if you could articulate, anticipate, and present it well, I think mostly you'll be able to navigate these transactions. And interestingly, the other aspect is like in case of a acquisition, I would definitely want to see the board control, right? In like if there is a veto sitting with some investor's hands, yes or no. If that was the case, then it's a clear no, right? Red flag for me, then till the time it is resolved. Because you might invest. There can be situations that may lead to invest. I mean, in the startup scenario, if I were to speak, the acquisition could be for various reasons. The company will have a larger goal. They want to achieve those goals over a period of time. They may have funds. What they would rather do is instead of like putting a lot of efforts building by themselves, they would rather acquire a company to achieve their purpose. Or maybe investor-driven acquisitions where investor thinks like, okay, these two business collaborate well and then makes a lot of sense when if they were to like consolidated, and then it'll be better value to the investment. And in those cases also like you're forced to do such acquisitions. In those cases as well, you'll have to like look at the compliances of the company. I'm sure like there are many examples in the startup scenarios in the recent past years that those acquisitions did not get through just because board composition issues, compliance related issues, and also the bad financial management. So what I would rather say in simple words is to like make sure that the company to be acquired, target company is thoroughly due diligenced, and then you know what is the risk, and then you take a call, right? And now if it takes for you to say no, we should not go ahead about this, I think you should have that audacity to let the management know this is not okay.
That I agree. And I mean, anyway, we as general counsels, our role is very, I think, it is very simple and clear as long as we acknowledge, which is that, raising red flags. But raising red flags and then not doing anything is also not that business really demands or needs from us these days. It is about understanding the objectives, as you rightly said. And once you have really understood the objective, we, of course, try to drive a value in terms of M&A by ensuring or finding ways within the legal framework and within the regulatory frameworks that's allowed to be able to give that value to the organization that is looking for in an M&A. And yes, due diligence plays plays quite a part as far as an M&A, especially when you are acquiring someone is concerned. Yeah. So with this, Nikunj, what value do you see in implementing robust integration strategies and governance frameworks for companies to expedite value realizations and a smooth transaction for all stakeholders?
Yeah, thanks. Hello, everyone. Nice to be here with this audience and with this panelist members. Very important question, Pathik, I would say. And to me, I think this effective integration starts not only after merger process ends. It actually starts when you decide to go and acquire some of the company, because it has to align with your original objective, strategic mindset, as also the synergies you are looking forward to. And couple of points for the companies to consider is threefold. I would put it into three different buckets. One is people, second one is processes, and the third one is system. And if we take care of these broad topics, for example, if I talk about people, it starts with leadership alignment. So leadership of both the companies need to be, first of all, aligned about the vision of the combined company. If they are not aligned about the vision, number one, number two, about the synergy they want to achieve, as also the goals they want to achieve eventually. If we don't have that, I think this is where we have a problem to start with, even before merger process starts. Then comes cultural integration. And cultural integration, I think, has been a great pace, and we have discussed about cross-border merger as well. And it's not necessarily only for cross-border merger, it's equally applicable for domestic one as well. We have seen cultural differences, and I would call it cultural nuances, that can be as small as, working hours. What can be your policy for remuneration? What can be your policy for remuneration for petrol allowance or diesel allowance as well? Right. So these are the topics which comes into picture when you get into the nitty-gritty of cultural nuances. I think the important thing to do at that point in time is to identify these differences and leadership to deliberate and decide how can we bridge those differences. I think this is what is the most important. Then comes very important, and Pathik, you alluded to it, is employee engagement and how can we retain our talent. So until and unless our employees are engaged and are aligned with the overall objective of merger, I think then we will not have our employees engaged very well, as also they may not see their future as well. And which is where comes a topic of retaining key talent. So couple of topics there. One, obviously, to identify key talent, but the second is to how can we develop other talents as well. And because we are talking about synergy, we will have scenario where we may need to take hard decisions as well as far as employees are concerned. But I think if our employees are engaged very well from the beginning, and they know the objective which we want to achieve, they'll definitely be in line with organization would take decision. But at the same time, as I said, retaining talent is one, but at the same time, keeping or rather developing the new talent that becomes paramount at that point in time for leadership. Having considering this people topics, comes topic which is process and process alignment, which is easier said than done, because as I said, the processes for both the companies may be different, may not be dramatically, but I think this is where comes alignment of policies in line with the objective. Last but not the least is system integration, and system integration is broadly talking about integration of IT system and tools, and also taking stock of the redundancy, whatever we can do away with that, and also finally data migration. So I think these are the couple of topics for sure. But if we achieve these topics, then we are taking care of the broader objective of keeping our employees engaged, as also having a robust process, as also a robust IT system in place. So I think if we take care of this consideration, I think this would be really helpful in terms of effective integration. And as I said, it to start from day one, and it's not a post merger activity. I'll put it that way.
Yeah, sure. Thanks, Nikunj. I mean, I agree. Integration is I think equally important. When we normally do an M&A, our focus generally mainly is to close the acquisition or close the acquisition, close the M&A. And we generally don't tend to look beyond and see how we're going to integrate is what are the cultural differences and cultural differences. In fact, I was just reading a data a few days back, and I realized 50% or more than 50% of the total M&A or potential M&As fall either before closure or soon after closure, mainly because of people differences and cultural differences. I mean, that's the amount of weightage that these aspects prevail. In fact, I think it's getting too serious a topic I'm not used to. So, so I'll just tell you a small. So see, most of us, of course, know M&As, how M&As happen. So we'll not really, spend too much time about how M&As happen. I would rather maybe say about, maybe more interesting would be to tell our own stories about what we deal with, what we have dealt with, or what we've gone through during M&As times. I'm sure we would have, most of us have been on all the sides of an M&A. We have, we have been selling or seller, we have been buyers. I don't know how many of you have been the real targets of an M&A. And I have been one, not very, not very long ago. And I'll just give you 2 minutes of background to what had happened. I joined a company, and it's a European multinational and a relatively a newer company in India. I joined thinking I am a European company, with everything in place. 6 months down the line, the European company files for insolvency. And thankfully, we were an Indian company, a separate company, in a way, a separate entity, while we were 100% subsidiary of a European entity. But considering we were so new in the country, there was a lot of dependencies on the foreign company, or our parent company, financing, technology. I mean, you name it, you have it, types. Now we didn't know what to do. Then the insolvency professionals or liquidators came in the picture. They tried selling the entire group. They could not sell it globally. Then we hear a news that most of the European business is being sold, and we are told, "Bhai, jo karna apna kar lo to, humse na ho payega." So, and then we didn't know again what to do. We thought we would really have to file for insolvency here because we didn't know. I mean, we had no real means to believe we would be able to achieve anything significant and at a pace that we needed to. Then someone from Middle East showed its interest to acquire the India operations of the business. And then came certain conditions that what do they need? They needed a lot of IP. They needed many other things from the liquidators. Unfortunately, by then liquidators had already sold most of it off to the company to whom global operations was sold off, other than India. And then a new struggle started. We went and sort of requested the other group to sell India operations IP to us. As we were about to do something and we thought something would happen, COVID hit us. We were so new in India, we never thought we would have any reason to survive in India. There was no data rooms available. We had no idea now how to get the diligence done. And literally, we were sitting at our respective homes, requesting our team members, requesting our leadership, requesting everyone, yaar, jo bhi hai data, bhej do hame, and we'll see. And that's why we completed our diligence. It really took 10 months for completing that diligence by us. Thankfully, the group that wanted to acquire us did not pull back. But at that point, and from an integrity and ethics perspective, the question that also comes, especially when you're a target and it is a matter of survival for you. However, until you are literally sold, the day you are literally sold, I mean, where are your loyalties reside? That was the biggest question that came in. And I, being the risk officer, the compliance officer, the legal head, that there was a lot of onus on me on where will your loyalties reside with the group that you are still a part of in a way, because the company is under liquidation, it's not yet liquidated. All their loyalties should reside with someone who's acquiring you and who has also told you that you are going to be retained. But then I think that's where your professionalism, professionalism come in, and that's where is your real test of integrity versus ethics, or integrity and ethics. But I think what I really learned is that as long as you are doing things right, in the sense that you are trying to achieve or bring together, align the objective of both seller and the buyer, you are trying to derive the best possible value to both of them, and you are being pretty honest, straight, and you're just being transparent to both of them. I think that's what is going to drive you, or also tell you what kind of person you are. And I am that way, sort of. I think I did the right thing, because even after the deal was closed, and I had nothing really to do with the sellers, so to say. I was already an employee of the target, which the target was already acquired by the new group. But still, when the sellers needed to find a custodian to keep their shares until the final leg of consideration was paid, they said, we have confidence in Pathik, he be the custodian for us, in spite of I not being there in terms of any interests with them. So I think that's what really drives you as a professional, and that's what you should do primarily. With this, maybe Sanjeet, how about your experiences, and more so maybe with the regulators? Lot happening on the M&A space, and lot happening with CCI and other regulators. What has been your experience in driving an M&A from a regulatory perspective in India or maybe globally?
So let me start by saying it's not a breezy walk in the park. You have to take each step very carefully.
That's why you are hired.
And in a cross-border transaction, it gets all the more tricky because you have to factor in the laws and the judicial precedents, the common law reality of each country. And in my experience, we have to be prepared to collaborate and be consistent. We have to be prepared to provide clear information, but also be very clear about the purview of that particular regulator. So provide the information in a clear, concise manner, which is relevant for that particular regulator. During the transaction, you might land up getting a lot of calls for information, which to us might not make sense, that why does the regulator need this kind of information? But you really don't have a choice. So you have to do the needful, provide whatever information is being sought, be transparent, but also be very cognizant of the fact that there's a lot of information in M&A deals that is confidential. So when you're dealing with regulators, you have to be very clear what can be disclosed in the public domain, or you have to invoke the confidentiality provisions and request the regulator to keep a lot of information that has to be kept confidential. Also, timelines are something that you cannot control. There might be a closing that you have announced to the market, but till the regulatory approvals come, you can't do anything. So you need to have your plan A. If that plan A fails, be ready with the plan B. If that fails, be ready with the plan C, because you never know what's going to come from which corner of the world. Also, the reality of today's world is that all the regulators are talking to each other, whether it is different regulators in India, or it is, for example, the antitrust authorities in different countries. So the stand and the information that is being provided across jurisdictions has to have the fundamentals very clear. It has to match with what are the submissions being made in different jurisdictions, because take it for granted that the regulators are going to talk to each other, and the filings that you're making in one jurisdiction could have an impact in other jurisdictions. So it's like take each day, we actually say that till all the regulatory approvals come, it's taking each day at a time, and be prepared to answer whatever questions come from any corner of the world.
Yeah. Thanks, Sanjita. I think that also brings me to one very important aspect. As general counsels, we should learn to say no. No business leader would ever want to hear a no or want to hear the problems. Of course, give them solutions as much as we can, but when we really see a red flag which has which we find a real red flag, we don't find a solution to it. Learn to say no. Say, we are the bad guys anyways. So you don't have to worry about that you will be labeled as a bad guy. So learn to say no. Learn to really put all the problems on the table. Of course, you will have to decide with business. You'll have to find ways. But the starting point has to be there. And no one else would do it for you. So with this, Panduranga, how do you approach an M&A, especially keeping in mind the post-closing issues, and also maybe something interesting that you want to share in terms of your experience on a real M&A?
Yeah, I haven't done merger much, not much, but I mean, acquisitions have done, right? By acquiring the shares, asset purchase, slump sale, right? Many times. We have to, like one of the instances where we had to get to asset purchase instead of acquiring the company just because of issues that have flagged. And ultimately we wanted their particular product that they had. The entire force behind acquiring that company was because of that product. Finally, when we felt like okay, this company is not worthy of acquisition, then what we wanted was the product. So we got that entire shift change that we made to acquire that assets only of that company. Therefore, it is very important as to we lawyers have to be very smart. Let the company know as to what was the issues. Now, why it is so important is the cost of compliance is too high at times. It can actually end up to seizing the business itself. So the cost of compliances are too high, and expenses attached to it we can be very based on certain situations around it at that point in time. So hence, if you could flag them, you will be able to negotiate the consideration, and then you might save some monies, or maybe buying certain from the target company that they would comply it subsequently, because condition precedent are generally sorted, but condition subsequent are. And if you have a counsel, which I did in one of the case, we retained the counsel, right? And when the company was acquired, who was working on the other side till the time we closed the documentation. And when the target was acquired, then he was part of the target. And now his obligation is to make sure the conditions subsequent are complied, right? So that will reduce some amount of a pressure on us, right? As a general counsels were to take a call in such case of acquisitions. And most importantly, few of the acquisitions where the cash flow, there is no cash flow at all, right? What they would do to pay their salaries, etc., and maybe immediate invoices, settlement, etc., could be very challenging, right? Have we show empathy towards such companies, try fasten the transaction so that you will be able to complete it as soon as possible, so that there will be a solution provided, or else do get to an interim measure as to release some funds, right, while you do the transaction. And this call is something probably a general counsel will only be able to take, because general counsel know whether it is worthy of closing it today, tomorrow, or is we need to wait, right? If it is need to wait, then we should wait. right? We should not be in a hurry to say that, okay, we'll close it because management is pressurizing, right? At times CFO may be in a hurry, the CEO may be in a hurry. At times, your CEO and CFO may be traveling. You want to close the transactions beforehand. And I have told them, like, okay, you go and come back. We will do that later. But for now, we want that company to be like surviving till the time you come back. Let's release some funds. Okay, so releasing funds subject to you have some control on the board, right? You have agreements executed for implementation. All of those have to be in place. Cultural differences, maybe at times, wrong hiring in the target company. The quality of hire could be very bad. The process could be bad, like he was mentioning. The chances that you take as a general counsel is like most of the time you will be succeeding in terms of your documentation. But in terms of, whether this entire transaction succeeds is all dependent on like how it has been implemented. Now, why would the general counsel take interest in those areas which is not a general counsel's area? Only to save yourself from the future litigation or probable issues that may arise between the parties, right? If you put effort now, then probably you will have a better tomorrow, or else you will be like lazy today and you will have a problem, tomorrow. That's likely that happen, right? And unfortunately, like unlike matured companies, startups are not so mature. These founders of the startups are also in a hurry to make decisions very quickly, fail quickly, succeed quickly, right? And e-commerce, as I mentioned, it has great possibilities of turning around the company very quickly. Like now I will be able to like do company EBITDA positive in 6 months. It's possible in e-commerce business. Okay, I'm looking at the time. So this is what I would like to say.
No, thanks. I agree with you. Cash issues as you spoke about, and the example that I just gave you about why being the target, my parent insolvent. Well, what do you do in that stage? I did not even have money here to hire a counsel. Right. So company had no choice but to listen to whatever I said. So with this, Nikunj, any last word on your experience before maybe couple of minutes we open for Q&A before she tells us to get out?
Great. So I'll not spend much time, I think, because it's something which we already discussed, but I'll make two broad points. One, and this is from my experience, what I've seen in last 5-6 years is that normally we have that feeling that whenever we go for M&A, we always have all the time of the world to decide what we actually really want to do. And that may be true for 70-75% of the cases, but there are some cases where, for example, your industry is consolidating. So you really don't have a choice whether to acquire or not. So there is only two decisions to make. One out of two is whether to acquire or be acquired. So, and definitely, management would go with the first one. And obviously, with all due diligences, whatever is needed, company would definitely march ahead. But having said that, that's one. The second piece I want to highlight is, in spite of taking all the care of the world, right from merger process to effective integration to everything, the success of M&A deal is dependent on external factors as well, right? So not necessarily your due diligence is whatever you do, maybe 100% true or will be proven to be true in future. So we may have surprises coming up in future as well. But having said that, I think this is where comes the agility of the organization to be ready for those challenges. And this is what we have seen that happening in our case as well. And I think we are doing well, according to me. And that's when comes this, third and the integration piece, as I said. This is where it helps, because if your employees are with you, they know what you have made decision and why. Then I think it's a matter of time eventually for company to bounce back and come to a higher level. So I think this is where is I would say the journey, where if you have your people with you, I think it becomes easier, although it may be bumping ride in future.
Thanks, Nikunj. And as typical lawyers, we don't leave time and space for questions from the other side. I don't know if we still have.
We can have one question from the floor, sir.
The condition is should be an interesting question.
Hope it is. So see, in my career, I've seen where there have been M&A transactions more where there's an investor on, it could be a private equity or it could be a venture capital. They have a very specific, already a mindset that, they're going out this transaction for a specific duration. You all have been from corporates where you basically, if there's a transaction, you get married for life. So, that's an absolute difference because this what happens is when we see corporates doing any of the M&A transactions, they think for a very long horizon. Incidentally now, and Pathik, I resemble where you mentioned that you were a target, but it's for a forum at last to understand. Incidentally, now what we've seen is in such transactions, the leadership skills and I would say you already, Nikunj, mentioned about integrity and ethics, but leadership skills of the very senior people who are the ones who will continue to be helping in the business even after the acquisition also are factors which now have been considered. Do you also, when you have been through this journey, considered not only the business which needs to be acquired, but also the key people who need to continue? And are there any specific, thoughts on it and how do you do that?
Yes, I think that's a very interesting question, and that's what I meant to say. When it's my last comment.
You mean other than offering money to them? Right?
Yeah.
So I mean, as I said, so number one, when you make a decision to acquire a company, actually you are acquiring that talent base and the position of that particular company, right? A position obviously is the one, let's say, one lever to consider, but when it comes to the employee and their engagement, as I said, that becomes paramount importance because you know that what kind of people are there in the other company which you are going to acquire, and over a period of time, their integrity and let's say loyalty, as you said, loyalty to the company or the combined entity is not a very simple task. It's a difficult task to maintain over a period of time, and it becomes all the more important after merger the integration process ends. Right. So during integration, everyone is, excited, they will get roles, some may not get roles. And also I think everyone will get excited because there are concentrated efforts being done on change management. So therefore, people will definitely reach out to each and every employee in the corner. But it becomes difficult after that process ends. And which is where comes next level to say, I mean, what is your objective? What is your objective you want to achieve or the vision and the mission? If you have a vision which excites people to come to office every day, then I think then it becomes, inherently motivation comes, in addition to Pathik, as you said, money. But yes, obviously that we need for living. But having said that, we are here to work as a professional somewhere, right? But what if you are working for a company which aligns with your vision and your wavelength? And this is what is something which I wanted to.
थोड़ा philosophical हो गया, but honestly, carrot works. Right? Anyways, I think, yeah, thank you so much. Thank you everyone for being patient listeners and not asking many questions.
Thank you, Ms. Sanjeev
Soft
Kaur and
secretary.
the other gentlemen for sharing
Thank you.
valuable insights with us. Thank you, ma'am. Thank you, sir. Please have a huge round of applause for all our panelists. Can we have a group picture of all the panelists? Now, moving on, ladies and gentlemen, we will have an in-depth case study presentation on the topic of tax legal effort in Indonesia, where we will have Ms. Monica Romalina Sejabat, founder and managing partner at MRS Business Professional Consulting, whose esteemed organization is our powered by sponsor and also our cocktail sponsor for putting up this magnificent global legal and IP conference. So I would like to thank you, ma'am, for such a collaboration. And let's have a huge round of applause to welcome Ms. Monica, ma'am.
Thank you. And good morning or good afternoon, everyone, and people in the from the media also that you join with online also. Not even that you are in your country right now that listen to us, that here that we will catch up with the spectacular session for the text case, the real life of your business transaction, the real life that you're facing the government in your country that you are connect with. So once before we talk about tax, I want to introduce me that I am as a tax attorney and also that a tax lawyer. So we have a different perspective for the tax attorney and tax lawyer. Tax attorney that we will go and fight in the tax court and tax Supreme Court also. But in tax lawyer, that just for the consultation about that what's the tax case issue that we will handle successfully as your stressful and painful tax matter. A lot of the people that come to me and all of the clients that come from the multinational company that want to share about the tax case that make them very, very concerned about the every detail for the transaction. That's why we must very detail about the transaction to success for every tax matter and issue. Once you get go and continue to the tax court and the tax Supreme Court. So here we are for the tax legal effort in Indonesia. As a founder and managing partner from MRS Business Professional Consulting, our client from the American and Europe, also that from Asia, especially from Indonesia, but most of the client that for the multinational company. And that's for the business also, for the corporate, and also for international NGO that we must report to them, and then they must report to the headquarters in Washington, D.C. So our base in Indonesia first, and then our representative office in Washington, D.C., because that we must report to them in the Washington, D.C. headquarters. So here we go. It's just a quick, okay. In Indonesia tax legal effort that we have a law regulation tax legal effort and a case study that we will case in very short time. So this is the law that we will put it in the text podcast that we will share after this one, and the case study in the magazine also, because that we are very short session that for 15 minutes only. And then that for the legal effort, this is that we have the process that from the tax audit and then tax objection and then continue to the tax court if you're not satisfied with the result by your tax attorney, and then we continue at the Supreme Court as the tax judicial review. That's the final of your life. The final life of your life that when you get this decision letter that from the tax Supreme Court that finally that you got the certainty of the law by your tax issue in your company or your NGO or any the case that you have. So and then that this is the very, very spectacular session for the tax crime investigation. What's the matter of the tax crime? As you are a lawyer and me too, and as attorney that me too, that we must concern about the tax audit that can become tax crime investigation. Wow, how is it? How we come like that? If the taxpayer that your client or our client that together that they didn't know, or maybe that they suggest or advise by the someone that want to do the tax aggressive planning, they get advice from another professional that your company or that your NGO become that someone that do bad things that impact to the Tax Crime Act in Indonesia or related with the tax treaty too. So tax treaty, we talk about the international taxation. So in the Indonesia, also that in America and also that in other countries is we talk about tax treaty. So Tax Crime Act in investigation that we can see at the VAT or GST, VAT as the value added tax in Indonesia, and that CIT also the for the corporate income tax, and also the transfer pricing and tax administration. What about the whole VAT, that case that can be crime investigation? So most of the case, because that we are make a confidentiality agreement with our client that we cannot put the name of our client. So we must, as a professor also in University of Indonesia, that I will share about that. What about the case and how can it can be like a crime investigation? When you do transaction about the invoice, tax invoice, maybe you don't know that your tax invoice that belongs to someone that you didn't do the transaction. Such as that maybe your client that do this the transaction with the group. So once the other group, that another different company that you use and issue the invoice tax to the others, not the real transaction. There's a tax crime investigation that can be your session after the tax audit session. So this is for the VAT tax crime investigation. You are so bleeding at the time, the company that very painful at the time, and they are very concerned about the how much money that your company that will must pay to the country. So for the VAT, that most of the company, if your client that want to get the refund, but actually when you feel happy at the first time, hey, we will get the refund. At the middle of the tax audit, that once the government come to you and say that, hey, we will get your company go through tax crime investigation. Wow, your happiness becomes sadness at the time. You must be stressful. And the president director come to me and the CEO and all of the management there will come to me and said, how can it happen to our company? Why our previous tax attorney didn't let us know about the situation that we did the tax crime investigation? So the stressful can be by CEO right now, the stressful can be at the president director right now, and also to the tax authority. This has happened for all of the big four also, that they handle all for audit first, and then that they also that handle for the tax matter. So that's for the VAT tax crime investigation. And then the next one, that for the corporate income tax, what's that? For the tax evasion, the corporate income tax. Most of the corporate income tax that based on aggressive tax planning advice by another professional, such as that there is not impacted for the shifting from the matter, the account, the transaction that you must be that get the tax rate that higher rather than the lower rate. So the aggressive tax planning that impact to the advice that make you go to the tax evasion. Wow, what's that about tax evasion? Tax evasion is a versus of the tax avoidance. One, the tax avoidance is legal and tax evasion is illegal. This is the section for the lawyer too. That you can go, continue to the section after that, your client stipulate that you got the tax crime investigation. The next time, the decision that not in the tax authority anymore, but the police section anymore. So the lawyer that must be concerned about this situation. That's for the CIT crime investigation. For the transfer pricing, this is the big issue for the multinational company. If you know about the base errors profit shifting, if you know about tax 3D, if you know about that, about 3D shopping, that's for the transfer pricing. If you know about that Google case, that they failed, they lost, and they bleeding, they must pay to the country that is over that 5 trillion rupiah. This is a very big money. That's for the big case. So as a tax attorney, we didn't must to go to win after the section in the police department. But as a tax attorney, we must successful at the DGT first and the tax authority, and then we must facing at the tax court. The section for the police department at tax crime investigation that stipulate, yes, correct. You are as a tax criminal. That's the lawyer that must aware about the situation. It's a big money for the company. It's a big money for the corporate multinational company. So be careful about the situation. Not about that win or loss, but it's about that how big money that you must pay to the country. So this is the very concern about transfer pricing issue right now. This is a very hot issue in Indonesia and also in another country. Each country that really concerned about the regulation, especially if your mutual external client that they do transaction by the country that have the higher tax rate and they want to save to the countries that have that lower tax rate, such as that India, that Indonesia, that shifts to Singapore, that the lower tax rate, that that's the best errors profit shifting. So once your company gets stipulated that you do the tax criminal, so you have a big problem and you have a big issue for your reputation in the upcoming years. That's why that most of the multinational company that really concerned to hire the successful tax attorney. That's why that we must specific and very detailed about the transaction. So how about the tax administration crime investigation? For the tax administration crime investigation, that most of the taxpayer that they report that not all of the income they get. Sometimes they can forget or sometimes they miss the transaction because the counterpart transaction they didn't report to them for the tax annual report or the for the fiscal period for the VAT. But you can prove it to the tax authority. And the tax authority will know that you forget or you get the aggressive tax planning. We have experience. Once we get the audit by the Big Four because that our multinational client that they hire the Big Four as the auditor. So when the auditor, the Big Four, make something bad at the commercial financial report, we got the letter from the tax authority that reminder that, hey, please remember, don't give advice for aggressive tax planning. As a professional that I know what the difference between tax avoidance and tax evasion is totally different by tax avoidance and tax evasion. How to prove it? It's easy for us that if we are expert and know people that do tax avoidance or people that do that tax evasion that is illegal, that's a criminal. So such as like you can duplicate your, or maybe that you have double bookkeeping, there's a criminal also, and you can do that also that you make that transaction that not real transaction, but based on actual transaction, that's a criminal too. Or if you save your profit to the tax haven country, what for? In each country that we know that if you got the money or if you got income from the India, that you must pay tax in India. If you got income from America, you must pay tax in America. And if you got income from Indonesia, you must pay tax in Indonesia. That's a tax crime that investigation. So once you say that, hey, but it's okay in a business transaction that we can put our money or our profit shifting to tax haven country. Yes, we know that with the your corporate that want to make something that good for your liquid company, that the money you want to keep to save your money. But please, we must aware the tax that you must to pay from the source country. What's the country that you got the money? Which country that you got your income? Which money that from that you the real base transaction? That's the tax that must be aware about the situation. Not even that you said, no, we didn't do that. No, we are good people. No, based on the accountant also, my background also an accountant. So we know really deep. This is the tax avoidance or this is a tax evasion. It's so scary. Once you Google Indonesia that they fail It's so scary because that the reputation, they must pay big money to the country. That's why you must be careful. That's why I want to share about the situation. Once you fail, your reputation as a tax attorney also that not good in the future. Once you success, it's good for your reputation in the future. Why? Because this is very, very painful for your client, for our client, to get the big stipulation that we must pay to the country. Don't do that. It's a big no-no. It's a big no-no. If you don't expert, if you're not expert about this situation, don't do that, please. Why? Your client will cry. Most of our clients came to us after they handle another tax attorney. They know they will lose, but they come to us with tears, cry, sad, stressful, painful inside. So how to get in touch with them? After that, they cry in my shoulder. We are a tax attorney, not even that we advise, but me especially, I can feel that when they are feel sad, I can feel they face the stressful. I can feel they are confused. I can feel the tears in my shoulder when they cry. They know their career will be stuck if they fail. Their career will be stopped if they choose the wrong tax attorney. When they fail, it must be sad for them, and it must be a very, very nightmare for them. They cannot sleep. They cannot travel anywhere. Why? If you stipulate as a tax crime act, you cannot go anywhere. The country will stop you. If the country will stop that your visa or your passport in the airport too. So it's a big problem. And once you got success with the tax crime investigation, your client must be happy, and after happy, they become your loyal client. That's us once we success with the tax crime investigation. So my friend, all of my new colleagues in India, so I respect you. Once we have share our discussion, what happened, that we must aware about the situation. Why? We are as a tax attorney, we are as attorney or as a lawyer, we help people not only for the money, but we help people to support them to get the fair that they feel enjoy the life. Also, they not stressful anymore, and also that we support government to make it better for the regulation. After the situation that we know deeply, the regulation that didn't meet with business anymore, such as AI, such as that we have a digital transaction, we can advise the government also. That's my experience as a tax attorney. So that's why that we give support also to the government and to the multinational company. We change the system also that meet to the headquarter to make the system that comply to the regulation, not only for Indonesia, also that the country that they connect for the transactions, like in America, like in Europe, like in Indonesia, like in India, like in Singapore. So they happy. Why? Because we know very concerned about the situation. The company, our client must pay big money, and they will concern to know which attorney or which lawyer that we must hire that success they tax matter. So once you go to the tax court, please be careful. In Indonesia, we are open to you. Lawyer can go and continue to the tax court. Before, 2-3 years ago, lawyer cannot go to the tax court. But we open it everything. Yeah, me also. I am also that open and welcome to all of you, the lawyer. But please concern, remember, if you're not expert, don't do that. Why? Your client will cry. That's my experience. There is in my shoulder. I cannot give them hug because that I'm a professional. But when I know and I can see their tears, I can see they cry in front of me. They're stressful. They cannot talk anymore. I know it's very stressful. So when I see them with the condition, that's my responsibility to go to the detail, to win their case, to make them successful. And then they are very happy. We need 8 months to win the situation. But 8 months from us must be happy, but 8 months for them, they cannot travel everywhere. They cannot meet with the family because of what? Because they must stop in the country after they finish the tax crime investigation. We win based on the detail and also that we know how to win the situation. To all of my friends and the big four, please be careful about this situation. Why? When your client come to us, it's not about the competition, but they concern about who the successful tax attorney that make them feel free. We have the same case, the tax same case at that time. So the big four, they fell. They lost, the company lost big money at that time, but we win. And after that one, they know, they really know tax issue, not only about the competition, tax issue about the moral, tax issue about the psychology, tax issue that about that how you help people, how you welcome people to say, hello, how are you today? Are you good? No, if you have the big case, the big tech case, you cannot smile anymore. Cannot. I can see it in your face. I can see you're happy and or sad. That's why that the tax attorney or a lawyer also, you are not only for advisor, you are not only of their hero, but you are also their angel. That's why that we call the angel come when the sadness change become happiness. Your tears become big smile. That's us for tax attorney. That success with our multinational client by the tax crime investigation. There's a big tax case in the world. So my Nicolets, my friend, please be careful, please be aware. Once you sign the contract, remember, as your boyfriend, I remind you, please don't sign the contract if you not expect in the situation. Your client feels sad when you lose. The tears in my shoulder, it remind me that we must be expert. We must know how to help them. You must know how to support them. And also that we will be advised to the government to change the new regulation to be the better regulation also. That's from us. That's from the MRS Business Professional Consulting that we have a multinational client. We connect also to all of the big four also, so that be open to us. We can discuss about every tax case that you want to know. Send us email. Let's connect. And I can see that the people that want to meet me and they want to talk to me, thank you to come to our board, that our team report me that, ma'am, a lot of people that want to meet you in person. Okay, after my session that we can meet, and also that we have a cocktail session also that we can share. Send me email that we have that email here. Why we put the bold email here? That a lot of the hacker that come to our business email. So please come to my private email, monica.sijabat@gmail.com. That's a very safe for us to talk about that, very confidentiality. So we cannot publish that the client name because that we have the pack integrity and also the confidentiality. I hope that you understand about the situation. But by the request for the magazine and the podcast also that we will make it very confidentiality by the text case that real case. Okay, you got it? So that's us. Thank you. If you have any question, I can see that. Oh, okay. Thank you. How many questions
Can we
that we
have the
can?
mic, please?
We have one in front, the lady, the pretty lady.
This side.
All the women, the pretty lady as a attorney and lawyer. I know that it's not easy for us to become Cinderella when we have a stressful, but we must become a Cinderella, must pretty when we face a public. Yeah, I know how hard that you must fight every day. Go ahead.
Hi, thank you for your case study. My question is, how would you describe treaty shopping? Is it like legal or illegal? How would you put like under tax evasion or tax avoidance or maybe tax planning?
Okay. Can I answer now? Okay. 3D shopping. This is a very popular in every multinational country. 3D shopping that we can describe that once your client have another country that have a lower tax rate, they will go to the country that get the lower tax rate. That's for the 3D shopping. That not all the transaction based on the income tax law that can use the treaty administration. We can say that COD or COR. COD certificate of domicile, COR certificate of residence. Certificate of domicile, that's for the company. Certificate of residence, that for the individual, for the person. So not all of the individual or the company that can get the tax treaty substance. Why? There is a requirement that in the tax treaty, such as India and America, such as India and Indonesia, that you must comply with that, with the regulation. Once you didn't meet with the requirements, you cannot do that. You cannot have. So then, when they do treaty shopping with the tax lower rate, they will fail to use the lower tax rate by the tax treaty. So, such as that for the foreign tax income in Indonesia, the tax rate is 20%. But if you can meet with the requirement of the tax treaty, you just pay for the 10% tax rate only. That's for the tax treaty. So, how to describe it, how to make it well. So let's go to the tax planning. Let's go to the tax avoidance. Please be aware about the tax evasion, especially that if you collaborate with the Big Four. Please remind them, because why? After the tax authority, the government that can see that potential indicate for the crime investigation tax, they will notice who is the person that give advice for the aggressive tax planning that indicate for the tax evasion. Be aware, tax avoidance different with tax evasion. Maybe that lawyer that need to learn about it together with us, we'll be happy to share with you.
Thank you, ma'am.
Thank you.
Thank you for the insightful presentation on the topic. Let's have a huge round of applause for Ms. Monica Romelina. Thank you, ma'am. Now we will be having another quick speech by Mr. Parth Banerjee, Director and Head Legal Compliance and Regulatory Affairs at Niva Bupa on the topic Competition Laws and Social Justice. Please, ladies and gentlemen, have a huge round of applause for Mr. Parth Banerjee.
Thank you, everyone. On.
Thank you, everyone. So very bad time for any speech, so I will not give any speech. I'll try to make a bit presentation before the lunch. So can I have the presentation? Yeah. So this is about correlation between competition law and social justice. Because since morning we are hearing about merger acquisitions, tax planning, which are very big ticket items for big pockets. But at the same time, we need to understand the competition law, particularly keeping in mind the objective of competition law is largely to administer social justice. Now, why social justice? Instead of saying any word, let me play a video for you. Thank you. Hope you liked the video. So this talks about two India within India, where we have a fantastic growth story for last 30, 40 years that we have from that growth. And the competition law is one of the law which can come in aid and which is coming in aid to create equality in the society. Particularly when we look at the evolution of competition law, this law has not evolved in India, it evolved in Babylon, long back in BC. And even in Hammurabi Code, you will find that monopolistic practices are barred. The same thing actually became eminent after Industrial Revolution. And the first act that came was not in US, that is Sherman Act, it came in Canada against competition or against anti-competition. Sherman Act came in 1890, which was again succeeded by Clayton Act of 1914. And then all the European countries also started moving towards creating competition law to bust the trust, because there was exorbitant monopoly that was created across the world, which was not only stopping the growth of the countries, but even some of the corporations and trusts were larger than the government themselves. So, what is the intersection between competition law with social justice? That is the question that needs answer. So when we look at our constitution itself, or even if we look at our MRTP Act, we find that it stems from Article 38 and 39 of the Constitution of India. When we read the preamble, it says that we will ensure justice, social, political, and economic in the country. And from the video, you will understand that we are far away from it. It's a distant dream even now. So when MRTP came into picture, that point in time, we talked about big is bad. But when Competition Act 2022 particularly came in picture, we said big is large, big is good, big is pretty. And we are embracing that, okay, large corporate can exist and there can be a harmony that can be created in the society. While large corporates are there, at the same time, they will have the responsibility of creating social justice. And if you see the government policies, it is moving towards that. So some studies were done in the past. Kruznet, you may have heard about it. He came up with the first data analysis on K-shaped economy. That why inequality in the society is there, why Adam Smith failed, why Karl Marx failed. And he came up with 40 years data. And from the 40 years data, he propounded a theory that high tide lift all boats together. Then came the capital. So when the capital came, it talked about that Kruznet was wrong because actually there are other things. The income from endowment is actually more than income from salary, which we all get, or wages, etc. So income from endowment is more so whenever the income from endowment is higher than the inflation, the rich will become richer and poor will become poorer. That's the theory which was propounded in Capital and which was again substantially endorsed by Joseph Stiglitz, Jonathan Blake, and one of the interesting research, which was empirical research, which was done by Huntsman in US. He found that there, because of competition in retail sector, there was 4.8% reduction in prices. 4.8 means very little. But when it was seen that for the poorest of poor, what was the impact of it? They found that people whose family income is less than 10,000 USD, they benefited 50%. Their expenses were reduced by 50% because of this 4.8% reduction in the prices. So we have a Competition Commission of India, which is about 15 years history, because while Competition Act came in 2002, it was actually notified in 2009. And in the 15-year history, first it was a very, very difficult job for Competition Commission, and it was all about failures. Because 90% of their orders were either stayed by the Supreme Court or the High Court, and they were unable to really nail the anti-competitive actions in India. Some of their decisions were also very, very bad in the eye of law because they failed even to provide natural justice. However, when we look at 2020 onwards, they have a very strong success ratio. And this data will talk about the penalties that they have imposed on Google, 936 crore, 1,337 crore, on Amazon, on Oyo. So these are big ticket penalties that is imposed by the Competition Act for anti-competitive activities. These are some of the judgment. I will not go through it because of the paucity of time, because we are going for the lunch after this, but I will leave this presentation for any person who is interested in that, how the movement happened. However, where we stand today, are we really, can we really say that yes, the Competition Commission is doing a great job, or we are able to create what we want to do? I will give some examples to you. We all buy pharmaceutical products, right? In pharmaceutical products, if any person is here from pharmaceutical industry, they will know that there are patented drugs and there are generic drugs. In generic drugs, there are two segments. One is branded generic, another is non-branded generic. And when you see the Drug Control Act and the orders passed under that, only 17% of the drugs are under drug control. So 83% of drugs are not under any price control measures. And what is the impact of it? That in generic branded, the same formulation with the same potency is sold at 1000% or 2000% price difference. So same medicine is sold at rupee 1 and rupee 2000. So iPhone you can buy at say 5 rupees and also maybe 2000 rupees. This is anti-competitive, and Competition Act, say Competition Commission looking into it, but again, like any other government organization, it is a bit slow in moving towards it. Again, when we look into the law itself, when we talk about dominance, you all are aware about Geo 2016. So when Geo came into picture, that point in time, they came free data, free call services. And by all means, it is a predatory pricing, right? But how it was interpreted that point in time, because the law was written in such a form that if you are a dominant player, you are exercising predatory pricing, then it is bad in eye of law. Otherwise, it is not. What happened? In 1 year, Jio became 33%, has 33% of market share and became the most dominant player. So sometimes the law, that is how it is drafted, how it is interpreted, how it is followed, creates an issue. And here there is a fundamental difference between consumer interest and the structure. So there is a Chicago School of Competition Law, which talks about if the consumer interest is protected, then everything is okay. You can do whatever you want to do. But there is a Harvard School which talks about that monopoly in itself is bad in the eye of. And if you are monopolistic today or tomorrow, you will harm the economy completely. So I will leave that thought with all of you and open the house for few questions if there are any. Thank you. Yes, please. So first of all, we need to understand that the corporates are not standalone, or they are not only working in only one jurisdiction. Just before this, there was a question on tax evasion and other thing, and tax choosing treaty countries and all. So the same company may be available in different jurisdiction, and by staying in different jurisdiction, they can avoid certain impact of competition law. And those, if it is a smoke screen, that need to be obliterated. However, Supreme Court recently has passed an order by which it has limited the power of CCI to impose penalties on global turnover. So again, those things need to be looked into case-to-case basis. If it is a smoke screen by which it is a global turnover they have created, or they have doing it in different jurisdiction, then it should be broken. However, it is like as it was stated, like a tax planning, or it is a bona fide business, there is no connection between one business to another business, then the penalty should be on domestic income only or revenue only. That's my view, personal. Thank you, everyone.
It was a matter of big pleasure for us to hear your address, sir. So let's have a huge round of applause once again for Mr. Parth Banerjee, everyone. Now, we've come to the afternoon session of our panel discussion, where our esteemed speakers will speak on the topic of legal challenges in the digital era, cybersecurity, data privacy, and e-commerce regulations. Our afternoon panel will feature our speakers, Mr. Nikund Savalia, Head Corporate Legal at Bear Corp Science Limited. Let's have a huge round of applause, everyone. Our second panelist is Mr. Manoj Gujaran, Chief Compliance and Officer at Head Legal, Poonawalla FinCorp Limited. Let's have a huge round of applause for Mr. Manoj. The moderator of this panel, Mr. Nitin Bhuvania, SVP Legal and Compliances at EaseBuzz. Let's have a huge round of applause for him as well, everyone. And our fourth panelist, Ms. Nandini Nair, Global General Counsel at L&T Technology Service Limited. Please have a huge round of applause for all our panelists.
So that's great. I was sitting at right. The moderator is right place. So I think a very, very interesting topic. And it's one of the hot topic. Discussions are going around in this topic in almost all the forums which we have attended. There are entire day sessions which are happening. Before we start, I think we have made the sessions dry, so we'll make it slightly entertaining also at the same time. Thanks, LexTalk, for giving me opportunity to moderate this session. I'm Nitin. I take care of the legal and compliances at EaseBuzz. We are a payment aggregator fintech company. So I come from a digital technology company where the technology is the core of everything. So we will talk about the cybersecurity, data privacy, and e-commerce regulation. Our esteemed panelists, which is here with us, are also the veterans in their profile. So I believe we will have a very enlightening and learning discussion on these topics. So we can start the topic with a matter of point which comes out, cyber security. The first thing which comes to our mind is cyber fraud. That's right. I think how many of the lawyers have been impacted with cyber fraud? Okay, I can see someone putting up the hand. Maybe and then there's someone in the another corner. We are supposed to be one of the very educated lot and supposed to be aware of the regulations very well. But when it comes to cybersecurity, even we have been duped, we have been tampered. I come from a payment company. Every day I get WhatsApps from very different number which I'm supposed to block. Call come from a different cross jurisdiction which I'm supposed to immediately block. These calls, these WhatsApp, the video calls which comes to me is how it is reaching me and how they have got my data. It's something what we should connect to each other and talk about today. We have a very non-panelist, Nandini, who's from US and part of L&T Technology Services. So again, tech is the core. So I start the discussion with her, and the very first question which flows to her is, how do organizations navigate the evolving landscape of the cyber threats? And I spoke about few threats which is coming up, and the cyber attack. And this is an attack. Why it's an attack? Because it's a financial terrorism after all. So your money is getting duped, your profile is stalked, your data is being duped. So, and when it comes to organization level, at the org level, The query is very simple. How is it that other people are having those data, and how do we protect and how do we navigate this landscape? Over to you, Nandini, on that.
Thank you. Pleasure to be here. Yes, I am definitely from the US. So don't let the outside package fool you. I'm American mainly. It's very nice to be here. In regard to the organization, you have to have actually, first of all, a culture of understanding. Cybersecurity has been something that's been evolving. It's a constant situation for companies, corporations, multinational corporations that do work in different jurisdictions. How do you, as an organization, prepare for something like this? There are best practices, and every company should be having certain things like this. One is employee training. These are individuals who control your employees. They have the ability to bring in a hacker, be able to manipulate data inadvertently, not, on purpose. So you have to train your employees. You have to have a response plan if there is a data breach or a cybersecurity threat. You have to have up-to-date systems. One of the things that I have found working with the in-house is that as much as culturally we want to keep systems progressive and technology forward, the cost of that will be prohibitive to a lot of companies. So they will say, okay, last year's data security system is fine, but actually there are loopholes that come in. So you have to constantly update your systems and processes. You have to have an internal target plan, meaning that how do you deal with internal threats that may come through? You have to be compliant, and compliance is not something that is one day. It is every day. It's 24 hours of the day, and it's constantly evolving, keeping up to date with that. You have to have IT protocols. There's multiple different levels of things that a corporation needs to do. It is not one, it is not two, it's probably at least 50 different things that everybody has to do. And it is not a one-person thing, it's an all-employee engagement to ensure that the company remains secure.
That's great. I think learning was something important. Cost, updating with the compliance, and also technology is evolving. That's what was the mood which came out very clearly. So one of the important aspects of learning, what I have noticed is people act late in their life, especially when it comes to cyber fraud. They are delayed in their actions. We are a payment aggregator company. If I get the complaint within 24 hours when the settlement has actually not happened to the other side, I can hold the transaction, I can protect the victim. So non-awareness of the regulation, acting late is something what we have noticed has become one of the reason of the complaint not getting or victim not getting a faster, speedy resolution is something which I can talk from my experience. Rest, it need to evolve. And problem with organizations are when it comes to compliance, it becomes a cost. Let us accept it's not a cost, it's a protection, which is must. Gone are the days when you will find a regulator coming up and telling you there is a penalty of some amount on you. This is the day when the regulator will say, stop the business. We have seen that. So from there we move like to Mr. Manoj, and the question which comes to me is right now, what are the legal frameworks we have? Like, do India have those legal frameworks to protect the cybersecurity incidences? And if even if we do have, how effective are they in practice? Are they actually practiced by organizations in their legal framework, or it's just something which is written on the text books and not being practiced?
Thank you. Yeah, of course. The primary legislations are IT Act 2000, which grants statutory recognition to all the electronic transactions, which prevents unauthorized data leakage, and which also identifies, phishing, malware attacks, identity theft, and electronic theft as punishable offenses. Then you have IT rules, which puts obligations on all the entities to report all the security incidents to certain. And then you have SPDI rules, basically Companies Act, which asks the entities to safeguard their electronic documents and their systems. Then you have sector-specific regulatory requirements, which are regulated by for regulated entities regulated by SEBI, RBI, IRDA, DOT. They ask their respective regulated entities to put cyber security safeguards and processes within their entities. So these are the acts, and of course you have to practice. Gone are those days when only penalties were levied. Now there will be business restrictions. In fact, if there is a cyber attack, the data theft that may happen can lead to a lot of not only business loss, but also a ransom money that will be required to be paid by an entity. And of course, once a cyber attack happens, then the business automatically anyway stop, whether the regulator pitches in or doesn't pitch in, your business stops for I don't know how many months. We have seen various institutions whose systems were attacked, and their business got hampered for average 3 months is what I have seen. And of course, and additionally, they have to pay the ransom money asked by you don't know who is asking the money, but you have to pay it in. So that's that.
That's all right. What I understand is like we have the regulations. There are regulations. Unfortunately, very few of them are actually being practiced in org level. And I'm boldly making that statement because that was not the core which organization used to take care of, organization look into. They used to always focus on business. It became all the tech world, and the tech world brought this tech challenges. IT Act, the incidents management reporting, certain incidents management reporting, still organization avoid to report the incidents. Why? To avoid the repercussion. We have, and again, I'm repeating, regulators have understood that, and they are taking all of that into consideration now. If you have not reported incidents, it's not only your organization who has been part of that fraud or that crime. You have actually helped the entire financial terrorism which is there. And see, the regulations are there. People are not implementing it. But then how to implement it is get the organization audited. So one of the important point which became right now in the eyes of regulator is get the system audit done. Why system audit? And GCs became part of those audit. And it was surprising to me. It came to my table, as a general counsel, as a lawyer, review the system audit report. It's very surprising to me, like for a GC to review a system audit report. What I actually realized when I was going through the system audit reports, and then I started into that direction, what came to my mind was the entire system audit report is trying to protect the organization from this cyber attack, and to avoid disputes, to have records in place. We keep records in our day-to-day life for our documentation, for our agreement, what we do. In this today's world of e-commerce, where are the records being maintained? With all good respect to everyone, a lot of people don't even know where the record of the organization is being kept, somewhere in the data, somewhere tick marked, and that statement is terms and use accepted. That terms and use acceptance is a contract. Though the testing of that has to still happen in the Indian courts, but still that's a contract. The very question which come to me, and when I was reading the cyber security, the cyber audit report, the system audit report, does those contract have the timestamp? Do they have the IP address recorded? Who has actually signed the contract? The signature, the IP address, and the timestamp when the contract was getting signed, which jurisdiction it was getting signed. It all becomes very important, very critical. Someone sitting out in a jurisdiction which is very different, where the IT Act has a very different economic, in fact, those contract have a jurisdiction importance there itself becomes a questionable aspect. So it became very important. We see a lot of the CRM tool which are there, the CLM tool which has come up with e-signature, e-discovery, and all of that, which is part of the today's world. But then those basic checks need to be there, and it used to be there in our contract. Used to mention the place, used to mention the date. Where is that in the online contract?
And you must also ensure that the person who is signing the documents electronically is the authorized person or is the individual basically who's required to sign an agreement. So I think the most authentic one is, Aadhaar based OTP signature. I think that needs to be ensured for any document that is electronically executed or signed by any person. I think that improves the authenticity and reduces fraud basically.
Class 2 digital signatures. Use them. People are not using. Scribbling just on something. Even if you're scribbling, which is called a virtual signature, please have the audit trail photograph of that person being recorded so that that becomes a enough proof of you to justify that this contract was signed by this particular person and he was part of it, because everything has happened virtually. So like we are actually have to build those robust systems, those robust technology. From here, I think we should move to and take more insights from Nandini. Like how do international and laws and regulation impact the cybersecurity practices, especially in the context of cross-border data breach, which is which is happening. And her insights would be helpful because we are practicing something. Let us understand from her how the international laws and regulation impact the cybersecurity practices.
The issue actually with cross-border data breaches or cybersecurity threats is that different countries or different states actually have different laws, or they're sometimes silent on these laws, or there's different interpretations of these same laws. So it is a difficult thing to navigate when you have a data breach or cyber threat across a state line. You have to look at things in a very different light. You have to look at, first of all, what is the precedent in that specific country? Do not use your internal lens of India or the United States or Europe. You have to look at where the breach is. You have to look at where the data could have flowed to. And again, sometimes both regulations, let's say you have two different borders, two different states, two different countries that you're dealing with, they may not reconcile. So, for example, in the United States, we have different laws per state. There's 50 different states. So if we have a data breach, let's say our employee data was hacked. Now we have employees across domestic United States. Now I have to look at every single state where I have employees to understand what are my obligations, what are my requirements, what is the diligence that I need to do per state. Some states require me to notify the employee, for example, within 10 working days of the data breach. Others say 25 days. And so it is very complex. And one of the biggest things I tell to GCs, or I would say to myself, is when I've had this data breach, and I've had this here and there, is action is required immediately. Sometimes in the corporate world, one of the things I find very difficult to navigate is the slowness of the response. In cybersecurity, in cyber threats, in data breaches, there is no room to rest. The second it happens, you have to come into action. And legal becomes a critical part of solving these issues, making sure that you understand what has occurred, what are the implications, what are your obligations as a company to disclose this, whether it is, if you're a public company, for example, do you have to disclose this to shareholders? Do you have to disclose it to all employees? Or is it a subset that you have to disclose to? This is where the GC and the legal team that you may have becomes a critical element.
So again, we come out to the same point. Action.
Always,
action,
always.
Action. That's action need to be in swift. And that is what I keep telling everyone. The companies are transacting on thousands and crores of transactions a day. It's very difficult when you sit idle on that. What has happened in the past, the transaction is already settled, matured. There has been layering done by the other parties. And then you are coming forward and coming up with questioning on certain transaction. So, and we have, and this is my personal experience, what I've noticed, there is a hesitation to do action. They don't have awareness. Where do they need to complain? The government is doing their part. MHA have a dedicated helpline number to complain cyber threat, cyber fraud, which is happening with anyone. People are not aware of those helpline number. People are hesitant to reach out to them. And even if they reach out, they didn't provide the entire data, entire detail. it becomes very difficult for the organization to track it. If you come after 3 or 4 days or 5 days, just imagine a situation, the 4 day, 5 day in a life of a corporate, which is into transaction banking, is equivalent to around 3 or 4 years. If I come back to you after 3 or 4 years and talk to you something about which has happened in the past, you'll be like, Limitation Act is there. That's right. Clear? That there should be a Limitation Act. I always keep on telling nowadays, there should be a Limitation Act for transaction also. Because the problem is the transaction has gone very deep digger and they have been layering what has happened.
You also have to look at your indemnification clauses. I'm just going through something like that right now. And you want to ensure that if there's a breach, and let's say the vendor breached, or your vendor partner for some reason, what is the indemnification provision you have in that agreement? That becomes critical, because will they be liable for all costs associated with fixing this data breach or the cybersecurity issues that you have? What happens if there's a ransomware, right? So multiple issues you have to look at.
That's right. And unfortunately, we have not seen much of the indemnity helping the organization here in India, maybe in the cross-border. And that is what the learning we need to do. We need to ensure we lawyers argue so much, fight so much for an indemnity clause, and the implementation of the indemnity clause itself in real life is missing. So we as a lawyer should come forward and start asking organization to invoke the indemnity. Please invoke the indemnity. Let the cost be there. Let us take it to the court. And there are large corporates who have done that. They have been benefited. So let us get into that practice, because if you're fighting for a clause for hours, and then you're running away from the court or from the arbitrator to take over that clause, no point. I move on to Nikunj. Nikunj is eagerly waiting to answer and give us some thoughts. I'll just also give some angle to it. We spoke about something about cybersecurity. We have a data protection, data privacy act in this place. Lot of things in the cybersecurity, cyber threat, if it is not to do with the system, is linked to data protection and data privacy. If the data is protected and there is a privacy over your data, I think you will be amenable, or you will be totally you can avoid the cybersecurity threat, or as an individual, as a org. So let's take the views from Nikunj on his opinion over the DPDP Act, and how is the interest of the organization, individual, and everyone is being protected.
Yeah, thanks. I mean, before I go to data privacy, I'll have a little bit 1 or 2 topics to discuss for cybersecurity as well. I mean, although it's always external threat, but we also have encountered in last couple of years, we see that our employees are also sharing data outside firewall or an internal environment, and that's a common threat I think majority of the companies are facing. It has started from 2020 with COVID, with what right reasons and all those things, but I think we see that cases also spiking up even after COVID as well. And that's a big challenge. And I'll go back to your point, Nandini, to start. It is about awareness, creation of awareness within the organization as to what is allowed, what is not allowed. Obviously, as far as cybersecurity incidents are concerned, everyone, as you said, gets duped, and therefore they learn the lesson. But as far as this data exploitation cases are concerned, here the companies or the organization are on the receiving end. Right, so employee makes mistake, but data really goes out of the firewall system, and this is what is, I think, it's very important, and compliance professionals are definitely struggling for this kind of a challenges as well. But I think this is what is organization need to put little more efforts into, apart from awareness, for sure, number one. And I've seen companies taking stringent action in terms of sanctions also. So, for example, if I may share our best practice, if we have any data exploitation cases coming up for investigation, and if that particular person is being trained already and there are data to suggest that that particular person is trained, I would definitely go for the next level of sanction than to give a warning, for example, right? Because it's known, and even after knowing that, if it's done, I think then we need to move up the ladder in terms of our second sanction metrics. So coming to data privacy, as you said, yes, I think we have a law, we have an act, and then we are waiting for the rules. So it's like the devil in the Mummy movie, if you remember, The skeleton is ready, but flesh is yet to come. So I think we are waiting for the flesh to come, and I think it will come soon, as you all know. But having said that, I think the data protection law is I would say broadly makes a finer balance of the, let's say, interest of individuals as well as businesses as well as government as well. And this is what clearly is coming from the act. Definitely, it makes individual in a driver's seat in terms of allowing the usage of their personal data. They are the one, it respects their fundamental right of privacy and gives them a lot of power in terms of whether to share the data or not, and if at all to share, when to revise and when to delete. Equally, it casts a lot of obligations on the businesses as well in terms of the protocols. They need to have it into the system, privacy by design and default, as we call it, as also a lot of IT systems as well. So these are very fundamental for businesses to use this personal data. And last but not the least is again government as well. So it also protects, let's say, the interest of government as well. It allows data sharing in instances of national importance or national security cases as well, as also cross-border data sharing as well. So there are concepts, and I think we are definitely, if I may say, we are highly inspired by GDPR of European Union as well as CCPA of United States as well. But I think we are in right direction. We are, as I said, we are waiting for the flesh and meat to come. But I'll take 2 more minutes there to kind of go to the next level of discussion as to, having said that, what do we really need to do? Do we really need to wait for the act to come, or can we start doing something right now? And I think this is where what organizations are doing, and I think what we should do is to start taking stock of the personal data we are using, which in typical terms called data mapping exercise. And we have seen a lot of organizations are doing that exercise, and frankly speaking, MNCs are also getting surprised with country like India and the amount of personal data they end up using without even at some point in time without them realizing that. So this is, I think, the one step organization can really start in terms of being aware about the entire process. There are a lot of, let's say, systems and different ways of handling the data mapping exercise. For example, it can be interview based, but there are also robust system out there, which directly gets into your system, get access, and then finally it generates report, which gives you where your data lies. So it's a combination of these things, and then based on the budgetary consideration of the company, I think one should definitely start the process if it's not done already. So this is what I think to start with. But yes,
no, absolutely, absolutely right. We have the act, skeleton is there, the place is still to seen, but GDPR is there. I think most of the organizations are indirectly impacted by GDPR. He's talk about data mapping. Problem with the organization is there's no data discovery. Where is the data? Which is the data which is important? Is it only Aadhaar and PAN? I think our act, the Indian Data Protection Data Privacy Act, is very far-sighted. They have spoken about consent manager, and believe me, if the act gets implemented in the right direction and the way I read it, the consent managers will be who? Who will be the consent managers? It's not going someone who in the organization. It will be the DigiLocker. A large organization like DigiLocker. You don't have to give your KYC to anyone. DigiLocker will reach out to the person who needs the KYC will reach out to DigiLocker. DigiLocker will reach out to you. Look, central database management system process is being thought through in our act. Probably, and I have seen, is the only getting a tick mark from the individual is the consent. I disagree, and that is what the act is having a vision. Let us see the. I'm waiting to see the flesh of the rules, because the rules need to talk in that direction, and we are seeing a lot of things which are happening. The DG Yatra, if you see now the DG Yatra, if you use DG Yatra, they ask you till what time you want this to be there. The time period is become important. So it has already started seeing impact. So it's great to see the act there. The act talks about huge penalties, which should be there, because we as a lawyers are supposed to deter the people. And then again, I repeat, again, gone are the days there will be penalties. The days are there will be stop doing this. So it takes me to the interesting aspect, and like we were talking about the data discovery part, data mapping part. how the concerned managers need to come up. And again, as I said, all of these topics are very vast. The entire day can be spent on these topics, the discussion. But I feel like the data life cycle is key to data protection. And Nikunj, again, I think you being one of the data experts here, the data life cycle is key, the very key to data protection. We need to hear your thoughts over that.
Yeah, I mean, certainly, as I said, I think it starts, and then I'll start with data lifecycle per se, and then about, the importance of it. As we discussed, data mapping, data discovery exercise. But having said that, I think in terms of the other aspects to consider, one is obviously data minimization and purpose limitation, as we call it. I think traditionally, we don't have that kind of a mindset in terms of handling personal data, frankly speaking, not only at a corporate level but also at an individual personal level as well. We at times we have not been very mindful about our own personal data. I think we have migrated to some extent, and now we are talking about protection of our personal data, and so is the case for corporates as well. So that's why I think this is it's very pertinent to ask this question: do I really need this kind of a data? And in this exercise, I think what is very important is that although DPDP Act, as we know, is limited to digital data only, but I think what we need to take stock of is all data, including physical as well, and ask that do I really need this kind of data? And if not, I think that's the first step to clear that thing and take this redundancy out and therefore create a little less load into the system, as also manage a less risk of managing personal data. The second one is, as you said, Nitin, consent manager as well as data security. So having consent manager, as you discussed already, I won't get into that, but the very next important step is data security management. So you have consent in place, a specific one, freely given, but at the same time, then it becomes your obligation to store the data very securely. And therefore, you need to have a right kind of a digital framework, which ensures that your data, whatever you either store or process, is done very securely. And there is no data leak there, because in case of data leak, you are responsible as a corporate as well. So story doesn't end there. I think then comes the next level is about overall data governance. How are the companies managing the data governance piece overall? And therefore comes the topic of having policies and processes and kind of integrated with the system. And for global companies like us, for example, I think we would be end up complying practically each and every data protection law on earth, right from west to east. And this is where I think a robust common system, if at all, we can have. And then we have had that discussion. At one point in time, we had more than 5 different systems handling data protection related topics only. And we had a very, very hard time to kind of integrate into one. I think we are now at a state to say, okay, irrespective of the law applicable, we have one system which takes care of it. And then obviously we then go ahead and modify the nuances at a local level. So I think if we take all these topics together, these are the levers to make this data protection or the data protection implementation and compliance of it is very important. And then comes data lifecycle, because it takes care of the entire piece of, right from getting the data to processing, to sharing, to deletion. So this entire data lifecycle management, if at all it's handled, let's say perfectly, what we are doing essentially is that, we are mitigating a lot of legal risk by just, following the data lifecycle management. And even before any application or any proposal, if we go through the data privacy assessment, which is again the requirement of the law, automatically it takes care of the risk involved as also the stock of the risk. So organizations are clearly aware about the risk they are dealing with. So this is one of the topic I think which helps.
That's so true.
Yeah.
Because all of this is so much connected. And I said I'll make the session interesting, so I'll ask you questions now, and the questions can come otherwise also. How many of you want that your Aadhaar, your PAN should not be asked with you? You want to do something with the government, they ask your identity. Why your identity is checked through documents? How many want to believe in that era that you don't have to share your identity and you have to share? You are sharing it in WhatsApp, you're sharing it in mail, you're going there and giving your hard copy of identity or shares. How many of us want that to happen? I think everyone. Everyone want that, nobody should come up and ask me, share me Aadhaar, share my PAN card. Answer to is the concerned manager. The concerned manager will have your data. Whoever need my data, go to the concerned manager, take it. The concerned manager will come and ask me. It's one person who's going to deal with me. I can make him accountable. So let us hope, and all of us as an advocate, let us make this as an advocacy to have a very strong concerned management system in place. And I take this forum to speak that, because if the strong concerned manager will be there, the DG locker, which is a kind of a concerned manager, which should be, in my view, or the government has to come forward for that and answer to this. The entire life will become simple, and organization don't have to struggle for each and every data, because the data which will flow from these concerned managers will be encrypted. We will have those security features. We will have those hashtagging, which is not to be worried about.
But Nitin, as organizations who store, process, and use this data are responsible for, taking explicit consent from each customer whose data is being processed.
That's right.
If the customer asks you to delete it, you have to delete it. You have to take, even regulators are telling us to take explicit consent for each activity that you will be carrying out by using that data, even if it is forming part of a terms and conditions or a privacy policy, which is checked by the customer and is accepted by. Still, it is insisted that you have tick boxes where he is giving consent for each app permission that you want to go and access, each consent, wherever you're going to use that data, how you're going to process it. So they want tick box for each consent. So that's the expectation here.
That's
so
right.
the responsibility falls on us, actually.
That's right. And data privacy policy is there with every organization.
Yeah, and you need to also review all of your contracts. We have now implemented, I want to say at least a year, that we require data privacy, cybersecurity clauses in every single contract that we do with customers. And we get a lot of pushback on this, a tremendous amount of pushback from the business, from the customer in itself. But now that we are in this world where cybercrime is a reality, you as legal have the duty to ensure that you're protecting the company by having these clauses in your agreements. So review all of that.
And our responsibility when we are using any third-party service providers who are accessing our data, accessing our customers' data, that is the main source of attack. We have to ensure as host organizations that the security setup that we have is also ensured at the third-party service providers end. There are limitations of budget. There would be limitations of budget at the third-party service providers end, but it is our customer data, and the cost of any ransom attack is huge. Their ransomware attacks were earlier individualistic. We know defect technology, how it is hitting us. We even don't get to know whether it is a real person or it is a deep fake. We do a lot of video KYCs these days, and so we need to ensure that at the third-party service providers end also, and we need to conduct proper drills, tests at the premise of the third-party service provider. We need to carry out proper audits, and if there is any data leakage that happens from at the premises or from the server of the third-party service provider, even for that we will be responsible and we will be penalized, or there will be restrictions on us. So we need to be careful about
Absolutely
that.
right. That's what organizations should get into impact assessment report. Data privacy impact assessment, gap assessment reports are very important. Get the audit done. Probably we'll get to know where the gaps in the organization. As a DPO to my current organization, I have made it very clear, no changes in the data privacy clause unless the request is seems to be very genuine. Otherwise, we have made it clear to the teams that any change in data privacy related clause, where the consent clause has to go through the DPO. So that those checks and controls need to be brought in. And again, as I say, it's now more to do with mails. Things have to move into system. The approval mechanism should also be there into the system itself, wherein who has approved it, what is the change being approved, all that can be tracked. I think we can. Sure, please.
Sure, ma'am.
there are companies who share their customers' data, I mean, our data, especially to the bulk SMS companies. We keep getting SMSs, we keep getting calls also nowadays. Those companies have now gone on to another level. Now they are calling us. So what I feel is, and I would like to know about your take on this, is it not possible that whenever there is, I mean, after this act is implemented, after the DPDP Act is implemented, the people who do not give their consent for any further use of their personal data or whatever data, so is it not possible to have some internal controls itself that would filter those data? And because SMS and all these systems are going to stay, they're not going to go. So when these data are shared by a third party, then those third party will have a filtered list instead of, like, we used to have this DND, do not disturb. Despite the fact that I was registered, I was still getting calls, and I used to tell them that you need to check. So now they are not going to check, they are not going to do any due diligence. So the companies who are sharing my data will have a filtered list, and I will be filtered out, and only those people who have given their consent, those data can be. So for this, audit part is also, the IT audit part will become
Absolutely right. You're absolutely right. So that's why it needs to form part of the agreement that we execute
right
there, and the explicit consent that I mentioned. So
Right.
unless you as a customer give consent that you allow that third party to share your data with any bulk SMS entity, till that time the service provider should not share it. And the simple thing that we should do, I think the we whenever we enter any society, any mall or any place these
Yes.
days, that is the first source of data leakage. I think we are missing all that. We
Yes.
provide our name, we provide our address, we provide our mobile number, we provide our email ID also.
Yes.
Because it is asked, so we provide.
And
I
it is
think we should.
mandatory in the part that if we don't, then they don't process.
No, I think that's not the case. But
Companies,
there,
they do,
that
pantaloons, they do.
no, any entity. So you should be very, very clear that you are not
Yes.
ready to share your data because it's your mobile number or whatever.
Yes.
Entry will be given.
Right.
They want to check your identity, that can be checked. But I think you should not. That's the basic
Yes.
list. Bulk SMS वहीं से आते हैं और
Yes.
कहीं से नहीं आते.
And in fact,
वो
what
basic
my,
source.
what my
वो free वाला है, free.
yes,
500
exactly.
रुपए में बिक जाता है.
Right. And my concern was, and I would like to have your view on that. Well, why not develop a software that would filter out the data that they don't have the consent,
That's what-
and have only the ones who have the consent.
That's what the impact gap assessment. If you do data privacy gap assessment, will search these gaps. The audit itself will answer this. There is a gap, which is the data which is going out to any third party. The person who was actually given you the consent has given you only for 30 days for this particular for activity, nothing for else. So all of this is going to aid to it. So the
as
point
you-
is to get your audit done.
Yeah, as you mentioned, the system will ensure that where there is a consent, only that customer's data will be processed for a particular activity, wherever it is required to be
Thank you.
shared.
These telecom operators, the TRI is actually working in the direction. They have put out a recommendation. CNAP is called, I don't remember the full form. Huh.
No, the regulator in financial services has asked to all the banks to implement DPDP. So when you mean to say asked, it's like prepare the audit report, prepare the gap assessment, present to the board, what is the gap, get that remedied. And if all of this starts happening, again, we started with the point, regulations are there, it need to be practiced, it need to be adopted. I think that can answer.
DPDP rules is still 3-4 months away. It will come after elections. And I think entities will get 1 year's time to implement. So that time is required. It's not easy to implement. It's a very tough regulation for all of us, for all our entities. And, additional regulatory implication on all the entities is on the general counsels and compliance officers.
I think there is one question which is coming up,
I
and we
think
can end up
I'd
this
like
session.
to interrupt here, and I'd request everyone to please discuss over the lunch networking time because we are time bounded. So with this point, I would like to thank our esteemed panelists for their wonderful insights on this issue. And now it's time. Can we have a huge round of applause for all our panelists?
Thanks.
Can we have a group picture together of all the panelists? Ladies and gentlemen, as the global workspace evolves, there always arises some legal challenges in this evolving digital era, from cybersecurity to data privacy and e-commerce regulations, promising upon the need for having a dynamic process of addressing such challenges. And with this, I would like to thank all our esteemed panelists for their wonderful insights on this issue. Now it's time that we disperse for a lunch break, everyone, with a networking session. Please enjoy your lunch and take the floor to engage with your fellow professionals. Thank you. We'll see you everyone at 2:15 back at the hall. Thank you. Ladies and gentlemen, we're back after the lunch cum networking session. Now it's time. We will have our post-lunch panel discussion session, which will be our last panel discussion on the topic regulatory guardrails while conducting investigations. Before we embark upon the most awaited and exciting moment of this conference with the distribution of the Lex Falcon Global Awards. For this, I would like to call upon stage Mr. Nitin Bhuvania, SVP Legal and Compliances, EaseBuzz. Please have a huge round of applause, everyone, for Mr. Nitin. Ms. Sushma Shankar, Senior Legal Counsel at Accenture Solutions Private Limited. Please have a huge round of applause for Ms. Sushma Shankar, everyone. Moving forward, I would like to call upon stage Mr. Vicky Gala, who is an Associate Managing Director in Forensic Investigation and Intelligence Practice of Kroll, a global risk consulting firm. He has led 100+ complex investigations during his work span of 18 years, and a few of such matters have those been extensively covered in the press. He will lead this session today and touch upon various regulatory guardrails that he has experienced while conducting such investigation. Please have a huge round of applause, everyone, for Mr. Vicky Gala. I would request the panelists to please start the session now. Thank you.
Hello. A nice time of the event when we've just done with lunch and we have to keep a charming face to present the audience on something which is more interesting. Thanks for, first of all, giving us this opportunity to speak on the dais. In my career of investigation that I've been doing since 18+ years, what I've been always been told as a buzzword is, please keep it confidential. And on the other hand, my clients and us as consulting firms have to adhere to a lot of regulatory inquiries. We need to adhere to a lot of regulatory compliances. And hence, it becomes like a paradox where you try to maintain confidentiality. And on the other hand, you need to do disclosures. So, that's the context that we want to just get this and understand this better. Thanks for the panelists. My stalwarts are legal professionals. So although I am a chartered accountant, I'll try to be more talking about the legal side of it. Let me just break down this session more with, I'm saying, just an open discussion with, not need to be a moderator driven, but more to be more conversational. And the first one to start with is, do we only do investigations? No. The investigative mindset is also when you are actually into a transaction, what we term as investigative DD. Even in those, there are so many points which needs to be kept in mind from a regulatory standpoint. Whether you've got right approval from CCI, whether you've got an approval from the SEBI, whether you've got approval from multiple regulatory bodies. So I think the first question, which is there, is for Sushma. You've been for a while working with Accenture. In your experience on a specific transaction, how do you see we have been, you've been able to achieve the requirements of various regulatory bodies?
So see, not many people know about investigations, especially corporate investigation within due diligence. All of us must have heard about due diligence, right? So there are various kinds of due diligence. You have the financial due diligence, the legal due diligence, and then the operational due diligence, right? So when it comes to the financial due diligence, what do? We look into the financial stability of the company, the financial health of the company. And then when it comes to legal due diligence, what is it that we do? We kind of, do an assessment or evaluate whether the target company has complied with certain applicable laws and regulations. One, how is it doing at the organization level in terms of operations?
although it is one aspect of operational due diligence, about employment, the kind of contracts we enter into with the clients, the kind of leases we enter into. So there are various aspects of, the evaluation which we look into when it comes to legal due diligence, right? Having said that, what is investigation and due diligence? That's the biggest thing, right? So when do we actually get into investigation? Investigation is a deep dive of, due diligence. You get into a systematic, evaluation. So in due diligence, at the most, we may ask the target companies to share the documents to evidence the fact that they've been complying with certain things, right? We don't get into deep. So what do we do in investigation? Say, for example, if I have to take a label or compliance, while setting up a company or an entity, when we're establishing an entity, we have to have an SNE registration, shops and establishment registration in place, right? So, during the due diligence, we've been shown that the company has done the compliance. Now, what happens is there's a lot other compliances which follows with this in terms of maintaining registers, in terms of displaying certain things. Now, how do you know that this is being done, and then that you do not foresee any regulatory action upon this, target company for non-compliance? So you get to know only when you start investigating. So there is an investigative agency, I don't know how many of you know about it, who are, deeply involved in mergers and acquisitions, who kind of, do this. So they get into the investigating part of it.
Absolutely. That's for our bread and butter.
Yeah.
Yeah, but Nitin, it'll be good to, if you can add an example to it in your career, you've been through any of such matter, and how you've taken it forward.
Thanks, Vicky. And I'm also chartered accountant, so I was fortunate to be an lawyer by heart and by passion. So yeah, one of the biggest example which I was part of, and I was fortunate enough to be part of that M&A, which was an acquisition of Diwan Housing Finance by Piramal Group. So I was part of the core team, core people who were handling that diligence. And Susma rightly pointed out, financial diligence is something which one can understand from the audited balance sheets and the data which is available in the public forum, or whether there is some manipulation done in the balance sheet. But when it comes to legal due diligence, it's a totally different ball game. And why do I say that? Is the diligence report has to give that thought process, that view, that there are things which are legally compliant, the checks in the box are tick, but there are things which have been missed. And what is the impact of that being messed up? So in my experience, and we're talking about experience part here, I was doing the DHFL due diligence, and we had, again, a large investigative agencies, the Big Fours and the specialized firms who were doing that investigation. The main question was, like, we can see a lot of circular transactions. Are those circular transactions backed by any documentation? Can we understand what is the layering done on those transactions? Is there like, you have to get deeper into that, and it's become difficult when you are actually doing a diligence of an entity in such space, which is into a different problem. It becomes very difficult, and checking out whether the agreements are in place. The employees who are there in the org will always say that all of them is there. What is there is not, like, you are not able to say. You ask for a sample check out of it. Those two is only not available. Again, you get deeper into it. So it's a very interesting area, and M&A, especially diligence, is the most important thing in M&A, because actually the person who is putting in the money or who is getting absorbed, the cultural part and all of that. But when it comes to legal, it's like larger snakes. In finances, you may be like, I'm paying something, but is it worth of that much what I'm paying for it? The legal diligence bring out all of that. A very, very basic example Susma gave, that whether shops and establishment certificates are there. For a large organization like DHFL, every branch need to have that. So, and when we did the acquisition, every branch certificates need to be changed. So even this is a part of the due diligence, that what all actions you need to take after acquisition of the company. All those signboards need to be replaced. The local regulations related to local laws need to be followed. So it's interesting assignment which I was part of. one of the largest deal which went under the IBC, though we had the court approval and all of that, which was there. But again, the DD plays a very important role.
Excellent. So this is good, when you hear about transaction. Now, I think more than half of the time that we spend for our clients has been more towards investigations. And that half of the time that we spend on investigations have a lot of branches to it. But primarily, it would be employee misconduct. It could be more related to, maybe a harassment issue, so on and so forth. So, again, Shushma, I want to understand from you whether, what do you mean and what are the type of issues that you have seen, especially when it comes to investigations in your career? And, it'll be good to know about how did you dwell with it then?
Yeah, so I just want to call out, I would be giving certain instances. So this is not with the current company which I'm with, but I've seen it in the past and
Absolutely.
basis my experience. So when we talk about investigation or corporate investigation, first thing which comes to our mind is employee misconduct, right? Corporate investigation, misconduct. Misconduct is one, harassment is one, discrimination is one. Now, having said this, there's certain other dynamics, which goes into this, which when we sit at a company, we kind of experience these kind of, issues or concerns, you may say. Now, you have I've seen this instance, like in the past, where two employees were walking together, entering the facility, and they've had a disagreement, right? So this one employee pushes the other, right? So there's an injury caused to another employee. And then in such cases, right, what does the company need to do? Immediate termination or you investigate, right? So there's an investigation which goes into, followed by a notice or whatever it is. And then I've seen an instance where employee running away with the asset of the company, where, he was being discussed about his performance. People are talking about his feedback. You have him, the supervisor and the HR, and then the employee suddenly, nobody has a clue or an idea that this employee is going to run away now. So, he runs away with the asset, not even the asset of the company, it's the asset of the client. And then goes ahead and files a police complaint saying that, the company harassed me. So there's a different tangent altogether into it. And there again, you cannot investigate this because some third party has already been involved into this investigation, although you're conducting some amount of internal investigation. So these are the scenarios which we see, when we are working in large scale companies. So if I may ask you, out of your experiences, what are the compliance, requirements which you need to do, especially, like I said, when you see certain acts, do you do an immediate act of termination, or, you get into an investigation? How depth is your investigation, and what is the outcome of the investigation, right?
Excellent. So, I think it very suits the topic of a regulatory guardrail. You mentioned about an FIR, you mentioned about connecting with the law enforcement agency. Maybe the individual has, although would be a privy to a specific information, would have done wrong in the eyes of the organization, but still he has taken up I would say the safeguard of reaching out to the law enforcement authority. So I know it's a very classic case. I think it's a very good one to know. It's primarily where, number one, in such matters, you may need to show the independence. The parties who are involved in that specific matter should generally not be, or should definitely not be, a part of the investigation. Regardless of whether things have gone wrong or right, the first thing that any organization should keep in mind is the independence factor, which can be done by an external third party, or which could be done by an absolutely within the organization by someone who is not a part of that entire transaction. Second thing is, termination, in my view, should not be the direct recourse, because termination primarily gives, again, open ideas for the other person to, go to the other forums and courts and, ask for a injunction, ask for a claim. It's important that there is a mechanism in terms of the disciplinary action that needs to be taken by an organization. Parallelly, an investigation needs to be done. And don't be surprised that there would be multiple such regulatory bodies who you may need to reach out to and inform about what has happened.
and get that complete investigation done, and then it's a true and fair report. It's basically telling fact finding about what happened, and then based on that, discipline action has been taken. So I think that's the way to
No,
look at.
that's absolutely right, Vicky. Just to add, we as a GCs have to also ensure that POS Act is there. If there is a harassment case, return need to be filed. Annual return need to be filed. The IC committee has to come, and in the return you have to mention how many complaints have been received. Investigation plays important part because the Act talks about doing an investigation by the IC in a certain manner, and all of that need to be recorded, documented, and the complainant need to get all types of protection and support. So termination is no way a answer for an harassment or investigation when it comes to organization. And probably the regulatory guardrails, there are regulation, there are law. We need to do a lot of filings with MCAs also for different aspect. I think recently there is another filing required for MSME, for like with who all are MSME vendors. So even these part becomes very important for like considering what are the regulatory guidelines, and being non-compliant or filing up a data which is not correct, not right, itself become lot of issues when we're talking, just not talking about due diligence, M&A, acquisition. I don't think anyone will be ready to put up a money or acquire something which has such issues or such challenges.
Especially, sorry, on this, corporate investigations, the ICC thing, there's another compliance which we need to do on the disclosures, right? So that we've started the investigation, we've commenced the investigation, and then another disclosure to say that, the investigation has completed. So that's another.
Yeah, regulator has put the entire framework. If you get into the IC mode, you have to do the entire reporting. So that those guardrails are in place. It need to be implemented. It need to be followed and adhered. And we as a GC, as a guardian of the organization, as a lawyers, external lawyers who are advising the organization, need to make the organization aware of. This is the next written filing to be done. If any such incidences have taken place, take it from the appropriate authority in the organization. Reach out to not only the directors, reach out to those in charge. The HR head need to be reached out for certain action, and that same thing can be again, the same thing can be again confirmed or accepted by the directors. So this is some kind of practices we as a GC need to follow, especially when it comes to external counsel in law firms. They need also keep their clients made aware of what are the guardrails which are required. And when you talk about regulators, it's N in India.
So reputation is one important thing which goes with the compliance, right? So
Absolutely.
compliance is a key thing for a company. You need to, and it's ongoing. And then there are multiple compliances which follow a single compliance.
I just want to keep one point maybe to the forum at large. Many of you, since you all have been in this fraternity of legal fraternity and have been counsels, many of you would have faced challenges where for the same matter, for the same type of work that you do, you may have various reporting for various regulatory authorities. Like I can tell you an example where I was doing an investigation which was regulatory driven. There were submissions to SEBI, submissions to income tax, submissions to GST, submissions to ED, submissions to others, and all had their own reasons of doing it. But I'm sure as a council, you would have also come across multiple such regulatory and law enforcement bodies where you would need to keep them updated about what's happening. In fact, there are regulations which say listed companies need to update SEBI on time-to-time basis. So I think, I have myself seen an absolute uptick in terms of how this has to be, I would say, how this has to be reported. There are multiple regulatory and law enforcement agencies where this has to be, they have to be updated about. Maybe if someone can just show some example, maybe Nitin can give an example.
Oh, absolutely right. There was a situation which I recently faced, and maybe that's not directly related topic, but let's talk about it. Every agency was reaching out to us, every agency in this country, for certain merchant who had done the transaction. And we were like, everyone, GST investigation, income tax, ED, SFIO. So, and it was like same repeated, same point, answering to everyone. So probably the point is like what we need to understand, everyone has a role to play. We don't disagree with that, but there has to be a central mechanism which need to be a custodian of all of this data, what we are giving them. And it becomes a big pain with the in-house compliance team who has to address all of this. In every notices, every issue need to be reported. Uh, when you get into this investigation mode, maybe you take it approach like GST department is only trying to look after the tax evasion part. The other department is going to look after the other part. Everyone has a role to play, but it becomes a lot of compliance burden, and ultimately it leads a cost factor which comes into the place. So when you talk about regulatory guardrails, SFI has a different role to play. The EDs have a different role to play. CBI has a different role to play. So all of these agencies should have some common point of interacting with each other. And I think Department Income Tax has started doing that with GST. What we are seeing now, they are getting the GST data, which is there. So that will control a lot of these issues and challenges of handling multiple law enforcement agencies in issue.
Absolutely. Excellent. I think that works well. Interestingly, we are just not bound by the India laws. Being in India, and I can talk about your company, you all are NYSE listed. They have extraterritorial laws which goes outside the jurisdiction of their country. Like I could say a US FCPA or a UK Bribery Act, where the laws are made in some other country, but are applicable for India. And it needs reporting. If something has been identified, like I worked on investigation which needed a reporting, being in India, needed a reporting in the US. So, it's when we see ourselves, we don't see ourselves only with the lens of one country. It's one where we see organizations now who have been multinationals and who have their reporting obligations across the globe, is where I see that there have been a lot of other regulatory requirements globally which come into play. What has your experience been?
That's rightly said. So you just do not look into the eyes of one country, right? So especially when we are a multinational company, you need to look into, various applicable laws, local laws of a particular, country from where you're operating. At the same time, the other laws like the US FCPA and the UK Anti-Bribery Act. Having said that, now what is corruption to a particular country may not be corruption to another country. How do you define corruption? That's one thing. Secondly, on the compliance, while is it that, as a company, you can have a set of standards and policies in place to make sure you comply with all of these things, and you have a compliance framework in place to make sure wherever your companies operate, out of whichever countries, that you make sure that the compliance have been met. But the challenging aspect to it is with your partners, with your third parties, with whom you contract with whom you engage with. How do you make sure that these third parties are also compliant with all of these things? That's one of the challenging part. Another challenge is on, as I said, on the local compliances, right? So it all depends upon the local variances in terms of addressing compliance with respect to corruption as such. So again, I would like to put that to both of you, right? In your experience, if these are the challenges which we see in a multinational company in terms of compliance or a regulatory framework, especially with respect to anti-money laundering laws, what would be your, advice on how to overcome this?
So, when it comes to extra jurisdiction matters and the compliance of the other country need to adopt it, GDPR is a classic example. DPD has come up here, but in fact, all of us were following GDPR. Indirectly, it was implementing us because if you have a foreign jurisdiction, any client who is in the foreign or individual who is doing transaction with the banking enterprise, foreign, the GDPR need to be adhered to. Especially the same goes with anti-bribery. When these entity you get engaged with this outsourced entity, they have those clauses in the agreement. Either you be very robust enough, take out those clauses, put it to the team members that this need to be adopted, send it to the relevant team that this is which is being agreed upon. Not many times people are working in silos. The legal department has agreed on certain provisions. The department, the ops team, especially when it comes to something related to anti-bribery, which is whose function, or there is a particular officer appointed for that, he is not aware in this particular contract this has been agreed. So it becomes very important within the organization also to make the people aware for other extrajudicial regulators what has been agreed in the contract, how those laws are creating an impact on us. And again, making people aware is also critical. People bring with certain set of experiences from different industry. They come, listen to them in their experiences, make them aware that what is it going to impact. When you talk about NSE listed, then their listing regulations are different than what the listing regulations we need to follow. And we need to be adhere to both the regulations. It becomes very difficult at that point.
I give this mantra to my clients: what you can't do, you cannot get it done by anyone else. Very clear from terms of ethics. What you can do can be done by anyone else. But what you can't do, if the ethos of an organization is very clear, that what you can't do in terms of anything, in terms of bribery, corruption, in terms of activities which may come under a PMLA, I think it's very clear that it cannot be done by others. Now, how do we pass it on to others? It's very important. Again, substance over form. Do we only keep a training, or we really actually make them ensure that they understand it better? Do we only put the clause in the agreement, or we actually have a round-up session with them to explain what does that mean? Do we only do a specific audit of doing a site visit there, or we actually sit with them and understand their issues and try to find out solutions? So as an organization, I really suggest my client that if such things come your way, there are third parties or vendors which are which may be privy to such issues. Let it be India laws or let it be extra jurisdiction laws. I think the ethos of the organization can define how better you can do. And if the ethos are very clear with a zero tolerance, it applies to everyone.
I would like to add on to this, going back to our topic on investigative due diligence, right? And then about extra, if I have to link them, especially when you're into mergers and acquisitions, where you're acquiring an entity. Let's say you're acquiring a regulated entity. Okay. A regulated entity offers services in a regulated space to multiple clients across the globe. So one, you have the industry relevant compliance, which needs to look into. Another, you have to look into the local laws. So there are two whole big aspects which we need to look into from a regulatory framework. And if you are required to, acquire this particular target. So if I may say, a regulated industry like a pharma company, which we are acquiring, or an oil and gas industry, which we are acquiring, or a nuclear company, which you are acquiring, right? These are all big things. So there's many things apart from a mere due diligence, which we do, right?
Totally.
Not just looking into the documents as regards filings, but then whether one, you're capable of complying with this, whether you can take up this because you're going to be in that regulated space, one. Secondly, have this entity complied with all of this being in that regulated space? You need to investigate that. For that, you need to understand that industry very well before you get into the
That's right.
acquisition.
So a lot of us are M&A experts here. I personally feel the core of M&A lies in due diligence, nothing else. Nothing else. The core of M&A is in due diligence, and due diligence should be so robust, so strong enough in the entire M&A. 90% of 80% of the time should be spent over due diligence and their findings. And if that is done in the right manner, I'm sure no M&A deal would reach to a conclusion which is hanging around here and there. Diligence findings are there that need to be clarified, that need to be open and discussed. And it's a human nature. Organization hides stuffs when they're getting sold, when there's M&A happening, there's certain value which they want to drive. And the other side wants to search something in there so that the value can be negotiated better. But this is the part of the process, and that need to be followed and adhered to. If someone is doing a M&A activity on a name or with certain understanding which is based on financials, not getting into the investigative mode, I think the deal maker should know better that those deals have not seen the light, or they have actually failed, or it leads to litigation in the court. So it's a very important aspect. 80% of your time in due diligence from all the legal angles, all compliances, regulatory aspect was very important point, which say if you tend to acquire a regulated company, okay, everyone knows they need a yes from the regulator, but after the yes, you will be part of that compliance. You need to adhere to all of that, and this is a very important point. Uh, IRDA, like people want to acquire insurance company. The very fundamental factor, once you acquire insurance company, you give almost a blank undertaking to IRDA that promoter's liability will be unlimited. The promoter need to be made aware of that. Not many times we have seen the promoter is like, no, let's get into insurance business, and this company is available in the market, and it's a very cheap. They have suffered some losses, we'll manage it. Whether your promoter know that you have to also give a similar undertaking to IRDA, where your liability will be unlimited. Something we as a GCs need to bring out. And all of this aspect comes out very clearly when you get into investigation, when you are aware of your deal expertise, and especially regulated industries deal makes a lot of difference when who is the acquirer and target company.
Yeah, another example is like, do all mergers and acquisitions survive, or do we achieve? We've seen the latest instance, what has happened with Sony and Z, right? I'm sure they would have done enough due diligence, enough investigations. But what happened during the course of the merger agreement kind of changed, uh, you know, what they were supposed to achieve, right? So there were certain closing conditions under the agreement which were kind of unresolved, including the disagreement in, involvement of the CEO in the regulatory affairs. So all these things are also essential. So how much ever due diligence and investigation we do, whether this go through is also dependent upon certain factors as to what happens during the course of this acquisition and the course of merger.
Absolutely. I somehow very much agree with you. Can someone pass on the mic to her?
We can hear you. Very important point. Very, very important. There is no proper set of regulations. What manner diligence need to be done? What need to be checked? People are just, some people have gained expertise, but they are just following a traditional ways of learning certain way of certain things and trying to, obviously, basic checks, I'm sure everyone is aware of, but there has to be a framework of doing that diligence. When it comes to regulated entity, there is a framework. When you go out slightly out from the regulated entity, I don't think there's a framework, and it's a very important point wherein the entire process practice need to be adopted. Different bodies are there. When it comes to accounting, you have ICAI. When it comes to company secretarial work, you have ICSI. But when it comes to legal diligence, I am not aware if anyone can help me out.
So I think I think, I would like to answer your first question first. Should there be a uniformity in the way or a specific set in way a due diligence can be done? I have a little different opinion. Let me give that way to you. See, I have seen those transactions where the value is already decided. It is very clear that the transaction will happen through. And everything which is a problem gets entered into an SHA saying that if it's my past liability, I'll take it up. And I've also seen those which are extremely compliant driven, who go through all of these things. And if they don't go well, even after 1 year of negotiation, like you can take an example of Sony and Z, after 1 year of negotiations and discussions and approval and everything, still the deal may not fall through. So there are extreme, I would say, areas. What in this can be done from a uniformity standpoint is the various legal aspects and the various regulatory requirements, which could be, I would say, quite stoned in terms of these are to be done. But other than that, it is quite relative on how the transaction, or I would say, how would someone take up that transaction.
Probably her question is more, is there any body? What I understood.
You're
To
talking
my
about
knowledge, I
regulatory
don't
body.
know. I'm not aware of whether
Yeah,
there is
we
any
don't have a
body.
body as
We
of
don't
now.
have a
Body.
regulatory body.
Yeah.
See, having said that, all the companies who acquire, like the buy side, who acquire the target companies are very, very cautious because there's certain amount of risk which you are assuming, right? There's financial risks, there's legal risks which you're assuming while you're acquiring an entity. So it's not, so when it comes to due diligence, you kind of do all possible due diligence, like your fraud detection, misappropriation of funds. So all this has been done, but you need to be even more cautious that during the course of the agreement also that things have been
Yes,
met.
that is my concern. For example, initially you performed due diligence, right? There was nothing that came out in checks.
Yeah.
But during the process,
Exactly
if
what
there
I
is an
said.
involvement of money laundering, then how are you going to regulate it? There should be enhanced due diligence in that case.
So how are you going to regulate it? It is up to you whether to continue. That's what Sony rightly did, right? They terminated the merger agreement, which means they do not want to go ahead with the acquisition, right? So it's good that they found it during the course. Now, what happens after the merger is being done?
That is
That's a
basically one
different
particular
yeah.
case. But
So you
in
still
ge-
again can sue them.
Right.
You have the
So
legal course of
NCLT, if it is
action.
an NCLT approved merger, and
NCLT, yeah.
There is a
yeah,
body,
the NCLT approved
NCLT.
merger, then you can, especially to that part, can be handled in NCLT, because when the merger process is ongoing and when the matter is reached to the court, and then both the parties need to give similar undertaking. Any point which has been not addressed rightly in the SHA, or which goes the misrepresentation of reps and warranties, can be taken up into the NCLT matter. It happened with me when I was doing the DHFL transaction. There were certain findings which were different on the day when we were about to reach to a conclusion. We raised that point that these numbers are slightly different from what was being expected. There's a stamp duty aspect which came out in the entire process. Though you have those capping of M&A stamp duty of 50 CR in India, but then there is, when you are acquiring a company which is backed by mortgage lending. So this transaction should also, the NCLT gave auditors like no stamp duty impact today, and the court had the power to do that. So, and in fact, after getting the NCLT order, we had to go for an amendment because there's an interpretation issue. So if we talk about when it comes to M&A hardcore and it goes into court approved process, there is a procedure. But the point I agree with you is what is there a body to, or do we have enough write up on in what mechanism that diligence process itself should run?
We don't see the answers there.
Yeah. Thank you so much.
Yeah. I just give another different twist to this investigations. We talk about regulatory bodies, but not necessarily only regulatory bodies. Even when you conduct an investigation, there are other bodies who would want to know, because our investigation will define their judgment, like a statutory auditor. A statutory auditor, for them to know about the internal controls in place, or to know about the true and fair of the statement and how the management has reacted or responded to a specific query, is also there. So, we would say regulatory guardrails may not be there directly, but through the Companies Act and through the requirements of what has been mentioned for our statutory auditors, they also play a very important role when investigation has been conducted.
You mean to say then there should be a qualified report by the auditors, qualified report by the auditor. No promoter will agree to get a qualified report. They will push the auditor to the last level to not get a qualification in the report.
Yeah, I think it's about the awareness. It's about the awareness about this matter, because that's they are bound to do. Whether the company has taken up the right steps, and it could be a matter which may not necessarily fall into a for a qualification, but may fall up into a specific requirement which has been taken care of the company.
To this point, India is distinct. Like we have auditors coming to us by providing us notice. So we know when the auditors are coming to audit us, so that we are well prepared, and we know what is being audited. Now, what happens in foreign countries, there's something called as dawn raids, right? So the auditors come and visit the company without even giving you a notice. That's when the investigation happens, right? The regulator comes and then, there's a list of non-compliance, and then the corporate actually starts looking into the, non-compliances, and then there's a whole lot of investigation as to why this non-compliance.
So interesting. If it is flowing from a regulation, accepted. Otherwise, in contract, one of the point which is mooted the most, other than those indemnity, limitation, or liability, is the inspection and right to audit. Every other side, the counterparty will object on this particular point related to right to audit and investigation. So if there is no regulatory backing to the investigation we're talking about, contractually, they will ask you only one point. You will give us a notice, not even 10 or 48 hours, 7 days notice, 10 days notice, during business hour, all of that. If you look at contractually, the auditor is
You need
supposed
to correct the irregularities, right?
exactly, that's what the point. So there need to be regulations around that area also.
Absolutely. Excellent. Yeah, so I think yes, one more came to us as one was regulatory bodies, and now we came about from an audit standpoint. Now let me add something to it. Investigations that I used to perform, or my me and my colleagues or my people in the fraternity that used to perform maybe 10 years ago, and when they do it now, I see a lot of difference. One of the differences that I see is because of the applicability, or about coverage in the DPDB laws. Because when earlier the investigations were performed, there were, because of lack of, I would say, knowledge about it, and awareness about it, investigations at times resulted in resulted in, I would say, identifying or using some data which they should have not used from a company standpoint. But now with the laws coming in, this is going to be more regulated, and this is going to be helping us to take a right direction, which will allow us to do it in only one manner. What is your thought on that, Sushma? And maybe then you can add, because you already had a session of earlier before that. So maybe even you can add
I
that.
think that was the point which missed in the data privacy session, which was there. Yeah, previous session, which was there. So it's not only people showing resistant when you are doing investigation. This is a challenge because it has to be done by professionals. And the professional, when I say, then he need to be bound by the professional indemnity or professional liability, which is the obligation towards that. So it becomes very difficult in situation when you are reaching out to a client in the investigation industry, and I on the other side of it, they want certain detail. I'm not happy to say that detail, and there are regulations. The data privacy regulation is also one of the regulator. So those aspects, those provisions, those guardrails need to be built in. I think all of us use those virtual VDR, virtual data room, when you get into M&A transaction, wherein the data is put on the VDR and only certain people have access, and the entire VDR is monitored. Every log is maintained. So there are tools, there are technology which need to come up and help us to do the investigation. And I'm sure AI is also going to play a part there.
Classic example of how data privacy can be misused in an investigation is like an investigation is happening, and the person who is in the part, who's part of the investigation says that I refuse things to be recorded. Right? The outcome of the investigation is a different thing altogether, right? When things have not been recorded, each party can again go ahead and allege that this was not told by me or this was told by us, right? So there's again a dispute going into it. So misuse of laws or misuse of regulations, how much ever guardrails you have in place, also needs to be taken into consideration.
I think yeah, I think we need to pivot it to a last, and I think it's time for us to conclude. We need to pivot it to the righteous way how you can do it. In my work, I would say, in my experience, I'll just conclude it by saying that yes, there are regulatory guardrails. These regulatory guardrails are robust. It's just that they need to be unified so that we don't report to a lot of agencies, as you mentioned, again and again. But these guardrails help to give a equal opportunity for both people who are doing the investigation and also for people who have been subject to it. And it's absolutely no harm in giving that opportunity to others as well. And what can be done is let the investigation be done the way they are done, and that can done by professionals. But on the other hand, we have legal experts who would help us support and assist in completing the investigation and doing a right disclosures to multiple authorities. That's it. Thank you very much, and happy to have some questions if there are any, or we would be happy to answer on the mic to her. Any questions?
I think I would like to thank all the panelists for such great presentation and their views and insights. It was a perfect showstopper of the day. Ladies and gentlemen, put your hands together for all our panelists. Can we have all of you for a group picture, please? Ladies and gentlemen, after a period of waiting for long hours, the final moment has arrived, for which we've waited for so long. To brace yourselves for the unveiling of the first round of the Lex Falcon Global Awards. Please give a huge round of applause, everyone. Get ready to be swept away on this tidal wave of achievement and inspiration as we announce the names of those talented legal professionals who've not just reached but soared beyond the pinnacle of adding excellence in the global legal industry. The wait is over. Let the celebration of greatness commence. Let's have a huge round of applause, everyone, for our upcoming recipients of Lex Falcon Global Awardees. But before that, I would request each one of you to please come near to the stage for a group picture. I would request everyone to come beside the podium for a group photograph. Please join us, everyone, with a huge round of applause for all our participants. Ladies and gentlemen, please be seated. Do brace yourselves for the unveiling of the first round of the Lex Falcon Global Awards. For this, I would like to call upon stage the Director of Clickaway Creators Media LLP, Mr. Abhishek Gaurav, to confer the awards to the recipients. Let's have a huge round of applause, everyone, for Mr. Abhishek Gaurav. The Inspiring Corporate Legal Team of the Year in Intellectual Property, Labor and Employment, Regulatory and Compliance goes to Hyundai Motor India Limited. Please have a huge round of applause for our first awardee, ladies and gentlemen. Hyundai Motor India Limited is awarded as Inspiring Corporate Legal Team of the Year. Let's have a huge round of applause. Let's applaud them, everyone.
Thank you. I think it's a great honor to be here. I can definitely see a lot of familiar faces, so it's a great honor to receive the award in the presence of so many dignitaries. Thank you, my friends. Thank you.
Thank you, sir, on this well-deserved award. Now we have the award ceremony in the Rising category and the Rising Corporate Council of the Year in Contracts Law, Data Protection Laws, and Corporate Compliance goes to Anushka Mahapatra. Let's have a huge round of applause, everyone, for Ms. Anushka Mahapatra. I would like to congratulate Ms. Anushka Mahapatra on this well-deserved award, ma'am. Let's cheer them, everyone.
Thank you, everybody. Yeah, as the award says, it's a rising. I'm still rising. I'm still learning, and this 2 days has been a very learning sessions for me, especially in the data privacy and IP. So thank you, Lex, for all this opportunity.
Thank you, ma'am, and once again, congratulations. The next category is the Rising Law Firm of the Year in White-Collar Crimes, Banking and Finance, Family Law, Arbitration, and Conciliation. And the award goes to Apotheos Law Chambers. Let's have a huge round of applause, everyone. Many congratulations for the well-deserved award, sir. Apotheos Law Chambers, everyone.
Thank you so much for giving us this award. We are a very young law firm. Just 3 years back, we started. We started from scratch. First generation lawyers had no hands to hold, but still, we're trying to make it in this industry as much as high as possible we'll go. And it's been a really good journey up until now. Worked in different law firms for 7 to 8 years. Really worked hard to start our own firm. when we were able to, it's like a dream come true. Every single day we get up and we think that we have to just keep striving to achieve our dreams. And this moment right here, I think, is one of those dreams that we strive for. So thank you. Thank you so much, Lex, for giving us this.
Thank you, sir. The pleasure is all ours on this well-deserved award. The next category is the Rising Law Firm of the Year in Alternate Dispute Resolution, Real Estate, and General Corporate Practice. And the award goes to Counsel and Counsel. Let's have a huge round of applause, ladies and gentlemen, for Counsel and Counsel. Many congratulations.
Uh, Thank you very much, Lex. This is indeed an opportunity for me to tell you that Counsel and Counsel is a firm which I started just in July. Prior to that, I was a partner with some law firms. I was GCs, and I wanted to start a law firm which do not have any targets. So, the concept is a little different, and that's why the name Counsel and Counsel. So thank you, Lex.
Thank you, ma'am. The next category of the award is the Rising Lawyer of the Year in a Law Firm, Criminal, Family, and Litigation. And the award goes to Dhanuja M.S., lawyer at BKM Associates. Let's have a huge round of applause, everyone, for Miss Dhanuja M.S. Once again, congratulations, ma'am, for this well-deserved award. Let's make some noise, everyone.
So good afternoon, everyone. First of all, thank you, and I'm forever grateful and thankful for Lex for conferring me with the title today. Being a first-generation lawyer, awards like this is a real encouragement, and thankful to my family, friends, everyone. Thank you so much.
Many, many congratulations, ma'am. The next category is the Rising Sports Law Council of the Year in Sports Law, Arbitration, and Mediation. And the award goes to Mr. Dheer Sampath, Manager, Legal Compliance and Operations at Slate Sports Management Private Limited. Let's have a huge round of applause, everyone, for Mr. Dheer Sampath.
I would first of all like to thank Lex for giving me recognition in such a niche area of practice because choosing or being a sports lawyer is never easy because if you want to get into a sports industry, you have to find a very niche area of practice. And also, I would like to thank all my family, my friends who have supported me till this journey. So thank you so much, everyone.
Once again, congratulations, Mr. Dheer Sampath, on this well-deserved award. The next category, ladies and gentlemen, is the Rising Lawyer of the Year in Litigation, Arbitration, Corporate, and Commercial Law. And the award goes to Ms. Krithi Kalaga, Independent Practitioner. Let's have a huge round of applause, everyone, for Ms. Krithi Kalaga.
Hello, everyone. I would primarily like to congratulate all the awardees here today. Thank you, Lex, for the award. And I think more than anything at this stage where I'm considered a rising lawyer and having just set up independently, I think this is more than an encouragement that I could get at this point. So thank you so much.
Thank you, Ms. Krithi, for this well-deserved award. The next category, ladies and gentlemen, is the Rising Corporate Legal and Compliance Team of the Year in Banking and Finance, Regulatory and Compliance, Risk and Corporate Governance. And the award goes to Legal and Compliance Team of Poonawalla FinCorp Limited. Let's have a huge round of applause, everyone, for the legal team of Poonawalla FinCorp Limited. Many, many congratulations for the whole team for this well-deserved award. Can we have a few words from you, sir?
I expect to Lex Falcon, LexTalk for organizing this special event, and thank you for considering us, eligible for this award. And we at Poonawalla FinCorp will be in providing end-to-end best-in-class digital experience to all our customers. So we provide from legal and compliance all the support to the company to excel and keep the trust of our customers. Thank you.
Thank you for your kind, sir. The next category, ladies and gentlemen, is the Rising Legal Counsel of the Year in Litigation, M&A, and Technology. And the award goes to Ms. Madhavi Lakhotia, Manager Group Legal at Centrum India Group. Let's have a huge round of applause, everyone, for Ms. Madhavi Lakhotia. Can we have a few words from you, ma'am?
Thank you, Lex, for this recognition. I would like to thank especially my mentors at Tata Industries and Centrum India Group, without which this wouldn't have been possible. And I would like to thank my family and my husband for always being so supportive. And congratulations to everybody else. Thank you.
Congratulations to you too, ma'am, for this well-deserved award. Now, I would like to thank Mr. Abhishek Gaurav for conferring these awards for us. Thank you. Thank you, sir. Now, I'd like to call upon stage the ex-additional advocate, General Senior Central Government Standing Counsel and Advocate at Record at the Supreme Court of India, Honorable Mr. Narhari Singh, to please confer the awards for the fellow recipients. Please have a huge round of applause, everyone, for the Honorable Mr. Narhari Singh to confer the awards for us. The next category, ladies and gentlemen, is the Rising Independent Lawyer of the Year in Arbitration and Litigation. And the award goes to Mr. Neeraj Salotkar, Legal Associate at CNS Juris. Let's have a huge round of applause, everyone, for Mr. Neeraj. We would like to hear from you, sir.
I would like to thank Lex Falcon for this award. I would also like to thank my parents and my family members. And I would like to thank CNS Juris and Murtaza Cherawala sir for being such a good mentor. Thank you.
Congratulations, sir. The next category, ladies and gentlemen, is the Rising Corporate Council of the Year in Contract Management. And the award goes to Mr. Nitesh Mani Tiwari. Let's have a huge round of applause, everyone, for Mr. Nitesh Mani Tiwari. Can we have some more applause, everyone? A few words, sir.
Hi, everyone. I would like to thank Lex Falcon for recognizing me and providing me chance to be here. And I'm overwhelmed to be personally present here. I would like to dedicate this award to my parents. Without their support, I could not achieve anything in my life. Next, I would like to dedicate this award to my brother, my sister-in-law, and my best friend Vaishnavi, who always support me, who taught me that what strength I'm having. At last, but not the least, I would like to thank God for fulfilling my dreams and answering my prayers. Thank you so much, everyone. Thank you.
Congratulations. The next category, ladies and gentlemen, is the Rising Law Firm of the Year in Media and Entertainment. And the award goes to Priyanka Chaudhary and Associates. Let's have a huge round of applause, everyone, for Priyanka Chaudhary and Associates for this well-deserved award.
Hi, everyone. Firstly, congratulations to everybody. Your work just inspires us to do better. PCA Legal is just a one-year-old law firm. We just successfully completed 1 year of our ops. And it's such a great motivation to receive this honor. And I want to thank the jury, everybody who was nominated, the organizers. Thanks a ton. It really is a great motivation and inspiration to see such great work and such great accomplishments. Uh, Charges us up to do a great job and try to be here next year as well. Like to thank the team, the mentors, the hard work that everybody has put in. And yeah, hope to see you all next year too. Thank you.
Same here, ma'am. The pleasure is all ours. Thank you. The next category, ladies and gentlemen, is the Rising Independent Lawyer of the Year in Intellectual Property, Patent and Trademark. And the award goes to Ms. Ravina Rani, advocate and solicitor. Let's have a huge round of applause, everyone, for Ms. Ravina.
Thank you, everyone. And I would especially like to thank Lex for giving me this award for this recognition. I would like to thank my parents who have always supported me, and without them, I would not have reached here. And I would like to especially thank my in-laws who have come here to attend my ceremony, and my fiance who is virtually watching this. Thank you, everyone. Thank you so much.
Congratulations, ma'am. The next category is the Rising Independent Practitioner of the Year in Criminal Law, Family Law, and Consumer Laws. And the award goes to Ms. Samriddhi Majumdar, advocate at Calcutta High Court. Let's have a huge round of applause, everyone, for Samriddhi Majumdar.
Hello, everyone. Good afternoon. Thank you so much for this amazing opportunity. I'm honestly humbled. Thank you.
Thank you, ma'am. The next category, ladies and gentlemen, is the Rising Managing Partner of the Year, M&A, Sports and Esports. And the award goes to Mr. Tushar Khateria, founder and lead counsel at Khateria Sports Law Offices. Let's have a huge round of applause, everyone, for Mr. Tushar.
Hello, everyone. I hope you are all doing really well. First of all, thank you so much to the Lex for recognizing the practice which I am doing right now. I like to thank to my parents. My father is here, and my friend also Yash. For thank you so much for being for today's night because it's very special for me. And yeah, and also congratulations to all the awardees. So yeah, and people who want to work into the whatever field they like to do, so just go for it. And because the passion, the love that you have for your expertise is the only thing that will drive you for a longer duration of time. So yeah, thank you so much, everyone.
Thank you, Mr. Tushar, for motivating all of us. The next category, ladies and gentlemen, is the Rising Independent Practitioner of the Year in Litigation, Arbitration, Corporate, Commercial, and Service Matters. And the award goes to Mr. Utkarsh Kaushik, barrister and advocate. Can we have some huge round of applause for Mr. Utkarsh Kaushik for this well-deserved award?
Good afternoon, everyone. Firstly, congratulations to my fellow awardees. It's a great achievement and an honor, and I congratulate all of you. Thanks to LexTalk for organizing this brilliant event. I've not only enjoyed picking the brains of some of the finest legal professionals here, but then sessions and the panel discussions were very informative. Thank you. This is a huge honor and a recognition much needed for young practitioners like me. Thank you so much.
Thank you, sir. The next category and the last category in the Rising category, the Rising Lawyer of the Year in a law firm in taxation goes to Ms. Vedika Agarwal. Let's have a huge round of applause, everyone, for Ms. Vedika Agarwal.
Firstly, I would like to thank God. Secondly, my parents. And thirdly, Lex for believing in me. And I would like to congratulate to all the awardees. Thank you.
Thank you, ma'am. Thank you, sir, for joining us and conferring the awards. Thank you so much. Ladies and gentlemen, brace yourselves as it's time for the result of the exciting news that I shared with you all yesterday. One of the event exhibitors, Pro Vakil, who are giving a huge giveaway, that is the iPad, to one of our lucky winners. So I would like to call upon stage the team of Pro Vakil to unveil the winner of this huge gift.
Hello, everyone. So hope you all had a great conference today. So the giveaway winner for the iPad is Miss Vidhi Jan.
Have a huge round of applause for Miss Vidhi Jain for this bumper giveaway by our event exhibitor, Pro Vakil. Can we have some more noise, ladies and gentlemen? I would like to congratulate Ms. Vidhi and would like to thank our event exhibitor, Pro Vakil, for this bumper giveaway. Thank you. Thank you for supporting. Thank you. Now, ladies and gentlemen, I would further like to call upon stage Ms. Monica Romalina, founder of MRS Business Professional Consulting, who is a powered by sponsor and also our cocktail sponsor to confer the further awards for us. Miss Monica Romalina. Let's have a huge round of applause, everyone, for Miss Monica. The next category, ladies and gentlemen, are in the emerging category. The first award in the emerging category is Emerging Corporate Council of the Year in Banking and Finance, Corporate Litigation and Logistics. And the award goes to Mr. Abhimanyu Narula, Regional Legal Manager, Blue Dart Express Limited. Let's have a huge round of applause, everyone, for Mr. Abhimanyu Narula. He's receiving the award in the Emerging Corporate Council of the Year. Congratulations, sir.
Good afternoon, everyone. I would like to thank you, everyone present here, my family, my friends, mentor, and last but not the least, Lex, for having that trust in me. And this recognition will help me strive more efforts and hard work towards achieving a better name in the industry. Thank you.
We are sure for that, sir. The next category is the Emerging Legal Counsel of the Year in Criminal Litigation and Taxation. And the award goes to Mr. Aditya Paul Ambrose, Legal Attorney at NKP Empire Ventures Private Limited. Let's have a huge round of applause, everyone, for Mr. Aditya for this well-deserved award. Many, many congratulations, sir.
First of all, a huge thank you and to the Lex World team for having recognized me for this award. You know, it's not easy picking up talent from down south. Talent is dense in down south, and I come from Bengaluru. I'm a first generation lawyer. I'd like to dedicate this award to my father, mechanical engineer. He said, I do not leave you. I do not want you to pursue the same course or the same stream that I am doing. Follow your passions and follow your pursuit. One of the awardees had said, go after your passion, go after your pursuit. So that's what I did. And this is where I'm standing here today. I thank the entire advisory board team of Lex World once again. Congratulations to all the award winners today. And it was an amazing conference, mesmerizing to say the least. Thank you all.
Thank you, sir. The next category, ladies and gentlemen, is the Emerging Independent Lawyer of the Year in Litigation, Real Estate, and Taxation. And the award goes to Advocate Sakshi Singhal, founder at Sakshi Law Associates. Let's have a huge round of applause, everyone, for Miss Sakshi Singhal.
Hi. First of all, I would like to thank Lex Falcon for recognizing our efforts, hard work, and achievements, especially in this field. And then I would like to thank my parents who are here with me today. And this will serve as a constant motivation for us to excel in future also. Thank you.
Thank you, ma'am, and all the best with it. The next category, ladies and gentlemen, is the Emerging Corporate Council of the Year in Corporate Commercial, Health, and M&A. And the award goes to Mr. Ahmed Sharabash, Senior Legal Counsel at Visita. Let's have a huge round of applause, everyone, for Mr. Ahmed.
Well, I think I'm a little bit tall for being an emerging legal counsel. Thanks a lot, Lex, for this amazing event. I really enjoyed all the panels. It's my first time here in India, and it's definitely won't be the last time. I've been dealing with a lot of Indian legal practitioners for the past 10 years by working in Egypt and Saudi and Emirates. Thanks, everyone, and congratulations to all the awardees. Thank you.
Thank you, sir. The next category, ladies and gentlemen, is the Emerging Independent Lawyer of the Year in Criminal Dispute Resolution and Family. And the award goes to Amardeep Chandra, Independent Practitioner at Amardeep Chandra Advocate and Associates. Let's have a huge round of applause, everyone, for Mr. Amardeep Chandra.
Thank you, LexTalk. It's very happy moment for me. And in this occasion, I would like to thank my family members and LexTalk. Thank you.
Thank you, sir. The next category, ladies and gentlemen, is the Emerging Lawyer of the Year in Bankruptcy, Insolvency, Criminal, and Litigation. And the award goes to Mr. Apurva Agarwal, partner at ASV Legal LLP. Let's make a huge round of applause, everyone, for Mr. Apurva Agarwal. I think he's not here with us right now. So moving on. The next category is the Emerging Independent Lawyer of the Year in Arbitration, Environmental, and Litigation. And the award goes to Ms. Bhumika Kapoor, Independent Legal Practitioner at Chambers of Bhumika Kapoor. Let's have a huge round of applause, ladies and gentlemen, for Ms. Bhumika Kapoor.
Well, thank you, LexTalk World, for this recognition. It truly means a lot. And it definitely is a motivating factor for young budding lawyers such as myself to push boundaries, strive for legal excellence, and maybe contribute positively to society and the fraternity at large. Thank you so much.
Many, many congratulations, ma'am. The next category, ladies and gentlemen, is the Emerging Independent Lawyer of the Year in Corporate Commercial Taxation and Maritime Law. The award goes to Mr. Chiranjeev Tandon, advocate at Tandon and Associates. Let's have a huge round of applause, everyone, for Mr. Chiranjeev Tandon.
Hello, good afternoon, everyone. Thank you, LexTalk, for recognizing the efforts that we put in. And I think this is pure blessing of God, parents, and my family. And at the last, I would like to congratulate all the awardees. Thank you so much, sir.
Thank you, sir. The next category, ladies and gentlemen, is the Emerging Legal Tech Expert of the Year 2024 in Corporate Commercial Data Protection and Privacy and Technology. And the award goes to Ms. Deeksha Mishra, Contract Specialist at Accenture Solutions Private Limited. Let's have a huge round of applause, everyone, for Ms. Deeksha Mishra. Many, many congratulations, ma'am.
Hi, everyone. Thank you so much, Lex, for the felicitation. I'm very grateful to be part of an organization that combines technology with human ingenuity to solve the world bigger problems. So I'm very grateful for my organization, Accenture. I'm also very, very grateful, and I dedicate this award to my parents and to my husband, who's right here, for always believing in me and always letting me know that it's not okay to settle for anything less than what I deserve. So thank you, everybody, and you have a good night today.
Well said, ma'am. Thank you so much. The next category, ladies and gentlemen, is the Emerging Lawyer of the Year in a law firm in litigation, regulatory and compliance, white collar crime. And the award goes to Mr. Harsh Singh, the Principal Associate. Mr. Harsh Singh.
Hello, everyone. I would like to express my sincere gratitude to my family, my friends, Vidhi Shastras, my law firm, and last but not the least, LexTalk World for this opportunity. I'm truly grateful. Your recognition inspires me to continue the pursuit of my passion with greater enthusiasm. Thank you.
Thank you, sir. I would like to thank Ms. Monica for conferring the awards for us. Thank you, ma'am. Thank you so much for your support. I would like to tell everyone that we are having a 10 minutes break. And I would like to request everyone to please stay tuned and brace yourselves as our honorary guest, Mr. Justice Rajesh Bindal, Mr. Justice Pankaj Mittal, would be shortly joining us. Thank you so much. See you after the 10-minute break. Ladies and gentlemen, I would request, without any further ado, and can bring your cup of tea coffee to the table, as we'll be shortly joined by honorary guest, Honorable Justice Rajesh Bindal, any moment with us. Mr. Justice Pankaj Mittal, the Supreme Court of India, Shri R. Venkatramani, the Attorney General of India, with us as our chief guest. Honorable Dr. Lalit Bhasin, President of the Society of Indian Law Firms. So please be seated with a cup of tea and coffee, as we are shortly joined by our chief guest and honorary guest. Thank you, everyone. Ladies and gentlemen, please be seated. And I would gladly like to inform everyone that Honorable Dr. Lalit Bhasin, the President of the Society of Indian Law Firms India, has joined us as our chief guest. Please put your hands together for Honorable Dr. Lalit Bhasin, everyone. And we're starting up again with the award ceremony. Without any further ado, I would request everyone to please be seated. I would request everyone to please be seated and witness the Lex Falcon Global Awards ceremony. Sir, I would request you to please join us on stage to confer the further awards for us. Everybody, please put your hands together for Honorable Dr. Lalit Bhasin for us. The coming up categories are in the emerging category. And the next category, ladies and gentlemen, is the Emerging Independent Lawyer of the Year in Administrative, Real Estate and White Collar Crime. And the award goes to Mr. Himanshu Arora, Advocate at Office of Arora Advocates. I would like to request Mr. Himanshu to quickly come up on stage and confer the award. Ladies and gentlemen, I would request everyone to brace yourselves as our honorary guest, Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India, and honorary guest, Mr. Pankaj Mittal, the Supreme Court of India, has joined us. Can we have a few words, sir?
Hi, good evening all. I would first like to thank LexTalk World for this enriching experience of 2 days. And I also am a poet, so I have written a few pieces for the legal fraternity. I'll just be saying one line from my piece called Vakil Saab. It says, civil ho, criminal ho, corporate ho, ya service ho. हर तरह का मैटर करना आम होता है. Thanks to the population of India. ज़्यादा हो, थोड़ा हो, हर वकील के पास काम होता है. Thank you very much.
Thank you, sir, for your kind words. The next category, ladies and gentlemen, is the Emerging Independent Lawyer of the Year in Matrimonial, Divorce and Family Laws. And the award goes to Ms. Janvi Dandekar, Advocate and Counsel. Please put your hands together for Ms. Janvi Dandekar. I request Ms. Janvi to quickly come up on stage and confer the award.
Thanks to Lex Falcon for this award and congratulations to all the awardees. Hope we all rise like the falcons in our careers going ahead. Of course, I've been in this practice for 8 years now under a very renowned senior. And without that experience, I wouldn't be here starting out on my own. So thank you so much. This just proves that something's going right. Thank you.
Thank you, ma'am. And thank you, Honorable Dr. Lalit Bhasin, for conferring the award for us. Ladies and gentlemen, I would request everyone to stay tuned and brace yourselves to welcome our honorary guest, Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India with us, and our honorary guest, Honorable Mr. Justice Pankaj Mittal, the Supreme Court of India, who has joined us. Thank you, sir. We would like to welcome upon stage the Director of Clickaway Creators, Mr. Abhishek Gaurav and Mr. Pradeep Tyagi, and Honorable Dr. Lalit Bhasin to welcome sir as a token of respect and a privilege. Ladies and gentlemen, put your hands together and welcome our honorary guest for the Let's Talk World Conference. With a career spanning decades, Honorable Justice Bindal has tirelessly served the cause of justice, upholding the rule of law and ensuring equitable access to legal remedies for all. Ladies and gentlemen, give a huge round of applause for Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India. We would like to welcome you, sir, with a huge round of applause. We would now like to request Honorable Justice Pankaj Mittal, whose contributions to the legal profession extend far beyond the courtroom. He has been a tireless advocate for judicial reform and the advancement of legal education, mentoring countless young lawyers. Ladies and gentlemen, put your hands together for our honorary guest, Honorable Mr. Pankaj Mittal, the Supreme Court of India. Let's have a huge round of applause, everyone, for our honorary guest, Mr. Pankaj Mittal. Now, ladies and gentlemen, brace yourselves as I would like to welcome the honorary guest, Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India, for giving us a valedictory address on the topic, the use of technology in courts. Let's have a huge round of applause, everyone, for Mr. Justice Rajesh Bindal for his valedictory address, sir. Ladies and gentlemen, we are pleased to announce that our Honorable Shri R. Venkatramani, the Attorney General of India, our chief guest, has arrived. Let's have a huge round of applause, everyone, for Mr. R. Venkatramani, the Attorney General of India. Thank you, sir, for joining us.
A very good afternoon. I think I will not take much time in addressing different dignitaries who are present here, because that will take time and there are chances of my missing any name also. It's always better to play safe. So the subject is the use of IT in court. We have been using a lot of IT in court for our in-house purpose and for the services which we are providing to the litigants and the public at large. I think I'll share with you some of the areas where we are sharing the information and which is available to the lawyers, to the litigants, to the public at large, which is useful for all of you. And what I have felt while I have been to many law colleges and all that, a lot of people do not know about the services being provided. That is why they are not able to access those services. Those are in public domain otherwise. So first is, you just see, there is a mobile app. You will see this logo, e-court services. The moment you go to that, click that, you will get this home page. On this home page, if you see the top of it, you will find district court and high court, both are mentioned. So that means you can access the cases of district court and high court on the common one app. Now, second, if you see the row, search by CNR number. CNR number is a unique number for every case in the country. It's a 16-digit number. First two are depicting the state, second two the district, then next two the establishment, the next six are the case number, and last are the year. Four numbers are of the year. So unique for the country means it can't be duplicated. It is not duplicated. If you have that, you just enter that, you will get the case details. If you don't have that, now next you are seeing scan QR code. We have the QR code also on every case file. If you have that, then you only need to scan that. You need not furnish or admit or add any data in that. So next is, this is two I have already told you. Now this is the case number record. CNR is case number record. We have entered this case number record here. This I have already told you. This is how it is divided into 16 digits. Once you enter that, you get the case details. Now you have the case details. First hearing was there. Next hearing is, stage is there, which court. Then you are seeing the first black slide is QR code. Once you click on that, you get the QR code also. You can just take a printout and put it on your file, and then for future, you can only scan it. Then the petitioners, advocate, respondents, which act is there, subordinate court information if any is required, case history is there, case transfer details, may one court to another. If the case is transferred, that detail is also there. And then last is the interim orders. Now I am clicking on this case history. If you click the case history, you get all these details. When case was registered, filing number and all that. Then last is QR code. You have to take a printout of this and put on the file, and then further is scanning of QR. Now thereafter, we go to the, these are the details. Then we go to the orders. Now we have clicked the interim orders. Interim orders, if you click, you get the details of all the orders which have been passed in that case. And you click on any one of them. We clicked the first one, and you get that order. So you have the availability of all the orders passed in that case. I'm not saying 100% orders are being uploaded. There may be some little lapse also, but you get majority of the order. Then there is another feature. You go to the top of that screen, home page. There is a column add case. You click that. This case is added in your cases. Suppose you have 10, 20, 30, 40 cases pending in court. You can maintain your diary here only. This is connected with our website and live update of all your cases. So this case we had added, this has come in your list. Now, suppose you have multiple cases. Now you don't have the time to add all these cases. You depute some of your staff members to add all these cases. He had added in the mobile, and then he can export it to anyone. You go to the left side, 3 bars, then go to this export, click it, and then this goes to the, just a minute. Then it comes, that screen will come by email, drive, or this device. So entire data of that case will be transferred to any of the place you want. Then there is another column. First was CNR number, second is the case status. If you click that, you get all this drop menu. Now you can search the cases by these parameters also. There is one case number is there, because sometimes you find the CNR number is not mentioned, some case number is mentioned. In the High Court, especially the CNR number you will not find. Then file number is there, party's name, FIR number also. Then advocate's name, then case type, caveat, pre-trial applications. These are all features from which you can search your cases. Now, with this case number, case status is there. Another is the case status. Yes, this was the case status. So this is how you have entered a case. By title and all that, you get all these details. Thereafter comes the e-court website. I will show you that live only, in fact. Because that will be more interesting, because this, in fact, in computer, it was a little difficult. This is a mobile app. Yes. So there is a website titled known as e-courts. If you click that, is it not right? Just see. This is the first page you get. You see the first line, there is some link of e-committee, NJDG. NJDG is the National Judicial Data Grid. Largest data repository of court cases in the world. You don't have anywhere. Then Supreme Court, High Court, District Courts. Now you see the court complexes, High Court pending cases, High Court disposal of cases listed today, per day. This is live. Then all this information is there. Now if you go to, firstly we go to the Supreme Court website. If we go to the Supreme Court website, it will take us to the Supreme Court, this home page. Now there are a lot of blocks you are seeing here, what you can find on the website. Cause list is there, case status again, with all these details, different parameters are there, daily orders with number, judgments, office report, caveat, e-filing, board is also live. And then all this further information is there, their virtual clock, justice clock, showing the pendency of cases and all that. Then ESCR I'll show you separately, DGSCR also, NJDG's data I'll show. So this is all different kinds of information which is available if you go to the Supreme Court website. If you go to the High Court's website, you get this, if you click the High Courts. Now all high courts are on the left side. You click the Allahabad High Court. You go to the website of the homepage of the Allahabad High Court. If you go there, now lot of services there. Again, you have the various information which is available for Allahabad High Court. You can access that information. On the left side menu is there, judges, cause list, display board. Your case status report is there. Cause list is there. Suppose we click the cause list. And we go to the Lucknow bench, daily cause list. Listing date is not coming. So this is how it can be. The date is not coming, only next working day. But this is how you can access it if you fill up the date. For the district courts, this home page will come. Now this is what it is showing you is the map of the India. Now these are all states hyperlinked. If you click to Rajasthan, now you will get the plan of Rajasthan. Again, all districts shown, these are all hyperlinked. You click Barmer. You reach the district court website of Barmer. This is how these are all hyperlinked. And on that website, you get a lot of information about that district. And in that, you also get the details about the judges who are on leave on that particular day. That information is also there. That is very convenient if some litigant has to go from outside. Now, I was seeing another thing. Information I just wanted to share with you, not on this. Now, if we go to the bottom of this home page of e-court services, what you will find is there is a one-click form for advocates. It's a long list of forms which are normally used in courts. Formats have been given in that. So this is to just help the lawyers. There are a lot of help videos because there are a lot of services being provided, which many people, many litigants may not know. There are a lot of videos, educational videos for that help. So you can find out what is there. Basic introduction to e-court site, then district court website site is NJDG portal is there, and cause list, parties name, how you have to access the various sites. So this is there. You can always take help of this. Then there is another manuals are there, so that may not be. Now we go to another site. This is very relevant. ESCR. Now, if you click this website, you get this home page. You just enter the CAPTCHA. This is where you reach. Split of second basically to access this site. Now what this site has 36,366. You see on the left side before the judges, judgments of the Supreme Court. And in the judgments, what you can do is, this is the column, free text search. Like any best search engine we have in this search, and then search within search also, you can shortlist all these cases. Whatever you want to do, you want to have the cases of for GST where the GST is there. So you got 54 results where GST is mentioned. First line, you can only see the first judgment, yellow, highlighted, it is GST. Then next also, you cannot see that, where GST is used. Oh, sorry. So you can again shortlist also that. What more you find in this is, on the right side, this is block. Which are the 13 judges' judgment? Only Keshwanandan Bharti. This is the little problem of technology because I am myself technologically challenged. So similarly, you will have the judges, the judgments, 11 judges strength, 9, 8, 7. Good old judgments, you will find 8 also. So then again 5, 4, 3, 2, 1. All different judgment, the number also is mentioned. Now you want to search this. By judge's name, you know the name of the judge only. This is list coming. You're going to have a long list. Any name you click, you will get the judgments of that judge. I will click the name of my brother sitting here. So down, yes. So you got 22 results. So out of 36,000 judgments, how much time it takes to search these? Then you know some citation year. This is how you can search because SCR citation is there, and now you see new citation we have devised for the court is 23 INSC, Indian Supreme Court 1029. This is the neutral citation we have given to all the judgments, all High Court, all Supreme Court judgments are now on this neutral citation. So this is how you can search this. This is now act also is there, then date of decision is also there. And if you want to see by SCR only printed version is used to be, you can fill up that also you can search. Now this was one part. Now the second part of it is where you click here, you get the word High Court also. Now if you go to the High Court, you have 1,25,94,311 judgments of different High Courts on this web portal. And on the right side, where you'll see all High Courts, the number is also there. Different High Courts, like Bombay has 15 lakh judgment on this portal. Similarly, different High Courts have lakhs of judgments on this portal. Now here also same system. You can have any free text search for any judgment of the High Court, judge-wise also, and then whatever way you want to search, all fields, all options are available. This is the, I think, area which is not known to many of the people, the litigants or maybe some of the lawyers, because law colleges also did not know about it. This is all free. The plus point of this is anybody can access all this. Now another service which is provided by us is, which is for the litigants. I will show that slide there only, just a minute. जस्ट लाइव दिखाता हूँ। अच्छा इसको there is another website which is called National Judicial Data Grid. Okay. So this is how you access this, and what you get on this is the depository of all the cases throughout the country, different courts. Now, what it is showing is, if you say here where NGDG is mentioned, district and taluka courts in India, how much cases are pending? This is live basically. About 1 crore and odd civil cases, 3 crore and odd criminal cases, total are 4 crore 48 lakh cases are pending throughout the country in district courts. Then pendency is also mentioned regarding your old and new cases. Then you have the information, how much cases are pending, the duration of their pendency, up to 1 year, 1 to 3 and all that. So for what purpose, appeals and all that, a lot of information is there in that. How much cases listed last month, how much decided. So a lot of information is there in this. From there also, this is the pending dashboard will come. Then dispose of also is there. How it is, the cases are disposed of. And if you see, no doubt, there are delays. But if you see this chart, bar chart, 37% cases were disposed of within 1 year. 1 to 2 years is 17%, 2 to 3 years 10%, 3 to 4 years 6%. There is very less number of cases which take long time. Lot of cases are disposed of within 3-4 years only. But whatever is there. So this was regarding the district courts. If you click the Supreme Court part, so you get the information about the Supreme Court cases. Now this is again live. Pending is 62,000 criminal, civil, then 16 criminal and total pending. Then you see the institution and disposal of last month only. And then current year also. Little bit, I think we are disposing of the old cases also. Then you see the cases pending also. You can see 9 judges are 6 cases, 11 and all, no further cases pending. And 3, 5 and 7 judges also, the cases are pending. And if you click this, you will get the title also of those cases which are pending for consideration by a larger bench. So you can always have an idea what are the issues involved which are pending consideration before the larger benches in case you have any such issue. So now you can go to the High Court also. Some problem. High Court also has similar kind of information, so because it's not opening. Now there is another benefit area where we have this is a portal digital SCR. There also you can find out all the cases as reported in the SCR with volume and all that, as you mentioned, the citation. So this is another area where you can always Then besides that, how we serve the litigants. We have e-Seva Kendra available in all courts where you can get any information, like an information counter basically in all courts. This information of the court-related matters and orders are available at all common service centers in the country. Common service centers in the country are about 5.50 lakhs and there are about 6.40 lakhs villages in the country. So almost every village has a common service center. So this is available there also. Now, if you see, there is e-Tal, a government website, how much access people have on the government websites. The figures for this is mind-boggling. If I give you the figure on our website, how much access is there? This is in this from January 24, I mean 1st January to 7th March only. The total transactions on the district court website were 43 crores. And High Court, it was about 3.83 crores. How much messages, I'll just show you that also. How much message we have sent to the litigants and the lawyers are 2.58 crores. And email sent are about 3 crores to the litigants and the lawyers. Now, how to get that? I'll show that also to you. And there are information kiosks also, automatic machines available in all courts, multiple, where you can access your information. A lot of services are provided in that. This is the service where you can get the message or email of all the orders or the information update about your cases pending in the court. One is that you have to get your mobile number and email ID entered in the system when you go to the court. There is a system you have to ensure the staff has to ensure that you are the litigant because information is not to be given to any third party. So you go and get your information added about mobile number and email ID. Automatically, every case update information orders will come to you by SMS and the email. Now, that is one part. If you want to pull any information, then you have to only send this message, e-courts, then CNR number on this mobile number. 9766899899, you send it, within seconds you will get the response, what is the status of the case. Now, if you want to have some idea of about all these, if you go to the, now this help video I have shown to you. This is the work in progress I'm just sharing with you. I think this will change a lot of things, will help the judicial system also and the lawyers also in assistance in the court. Recently, our chief had shared with us, so I'm sharing with you. This is work in progress. This will be in the public domain only. This is Vidhi Gyan Sampada. What we will have is, we have the different acts starting from the constitution. You will have all the entire legislative history of that act. When the amendments are made, all amendment acts at the same place. And you can see the history of any provision, any article in that how it was amended, number of times, when it was amended, what is the amended provision. Then constitutional debates of every article and relation with that. So you can link it if you want to have good search because all these constitutional issues require that also. Then you will have the Law Commission and Parliamentary Committees reports on various issues. So you can also, these are all in searchable modes. Then we'll also give the link to open source journal articles which are there available on the website. So subject-wise, you will be able to search. And this will have, again, multilingual support for content because that is required now. So this is how we are in public domain, created all these facilities to help the litigant and the lawyers and the all legal fraternity wherever they are working. But internally, we are using a lot of things, AI and all that, for improving our system for court case management. That's a long down story. May not be of that relevance to you, but idea is to provide good service and expeditious disposal of cases, case management, all that. So thanks for inviting me, giving me an opportunity to share what is happening in court. Thank you.
Thank you, sir, for ensuring equitable access to legal remedies for all. Let's have a huge round of applause, everyone, for Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India. Now, I would request Honorable Dr. Lalit Bhasin to honor Shri R. Venkatramani, the Attorney General of India, with us as our chief guest. Ladies and gentlemen, please have a huge round of applause for Shri R. Venkatramani. He is a distinguished legal luminary with an illustrious career in the field of law. Known for his profound expertise to justice, he stands as a guardian of legal principles, contributing significantly to the legal landscape of the nation. Ladies and gentlemen, Shri R. Venkatramani, the Attorney General of India, with us as our chief guest. Let's have a huge round of applause, everyone. Sir, can we have a few words from your end, please?
You see, Mr. Venkat Ramani is much beyond being the Attorney General of this country. He is a great scholar, a great jurist, a great academician whose first love is legal education. And he's devoted so much of his time to promote and strengthen the legal education system, along with the legend, late Professor Madhav Menon. Therefore, please put your hands together to give a great to Mr. Venkat Ramani. Attorney General's position is the only constitutional position for any professionals in our Constitution. That shows, you see, the significance of the legal profession, which has been recognized by having a position like that of Attorney General, being a lawyer, read with Article 22 of the Constitution, which says that every accused will be entitled to have legal assistance, legal profession. So that is the significance of our profession, the only profession which is recognized in our Constitution. And Mr. Venkat Ramani is the constitutional head of the legal fraternity of this country. Big hand.
When Mr. Lalit Bhasin invited me to speak in this wonderful congregation, I had some reservations. Firstly, let me say that I have no claim to have any greater knowledge or experience than any one of you. And secondly, to be in the midst of a very unique set of people, unique in more than one sense, and to have the courage to share one little knowledge and experience, I think maybe sometimes open to question. Nevertheless, Lalit Bhasin is a great organizer and a wonderful organizer. He can bring people from all over the world and gather them on matters of common concern. And I thank him for asking me to be part of this evening today. My regards and respect to the honorable judges of the Supreme Court Judge, Justice Mindal and Justice Pankaj Mittal. And as we try to engage oneself in the unveiling of what Supreme Court has been trying to do by opening up its e-windows in more than one sense and more than one way, I think they are part of that very enterprising engagement. And as people of my generation who have not only grayed in hair, but also crossed certain ages of learning quickly, but the Supreme Court doesn't leave us in that kind of repose. And so we almost every day use our iPads for learning, arguing, knowing, interacting, and also doing a bit of game work. So it's a wonderful journey for many of us now. Having said that, to greet a confluence of special sets of legal fraternity is a great pleasure. Special sets in the sense of a class of legal talent who are closer to the world of challenges and problems than the distant participants like us, who are the sound and fury of the legal profession. The class of legal talent who are here are integral to the motions of law and justice in a more fundamental way, and of no less in importance and accomplishment than a visible player in courts and tribunals. The forum LexTalk world as they gather seems to be gathering momentum year after year, and I wish it becomes a world-class congregation. I say no, not only because of patriotic reasons, but from a deep sense of the need for perennial engagement of larger segments of the legal fraternity and the community also, in promotion of values of fairness, equal regard, and a vigil and attention in harnessing technology and its use for enhancement of human welfare. More than 30 years ago, students from Max Planck Institute in Munich, dressed as white mice, protested outside the European Patent Office and canvassing that there shall be no patent on life. This happened in the context of issue of an application to patent the so-called Harvard onco mouse that was genetically engineered to serve as a test animal for cancer research. Well, the US Patent Office had cleared the patent. In Europe, the commercial exploitation was to be scanned under principles of public order and morality. Utilitarian understanding, however, became the watchword for clearing the application. Later, the Patent Office was engaged in dealing with application relating to genetically modified plants and then to copies of human genome sequence that codes for a muscle relaxant. Moral objections to patentability were kept aside. The web of issues relating to technology now virtually run through all aspects of technology, from crime detection and investigation, to health welfare, to communications, to transportation, use of natural resources, and to justice administration as well. The engine of creation in each one of us, I repeat, the engine of creation, each one of us, which is so fundamental to human flourishing and elimination of social disparities, can receive its best host primarily in private engagement innovations, which emanate when private curiosity and freedoms mingle. While governmental engagement in certain areas such as defense or cyber security are non-negotiable, creativity demands freedom. The challenge, however, is creativity for what? Creativity for mere personal or unregulated commercial considerations? Creativity blind to sustainability? Creativity which can render us as victims or slaves to technology? These are questions that will ask all of us to be in constant debate. We cannot be a world without minds, and the balance between being mindful and progressive may not admit of simple solutions. Forums such as LexTalk will be platforms for meeting of minds from different ends of the professional spectrum to generate socially relevant frameworks or principles. This will be the future of legal debates. Writing about the new challenges in genetic engineering, the British philosopher Mary Hancock said, I quote, "Technology has made all kinds of things possible that are impossible or unimaginable in an earlier age? Ought all these things to be carried into practice? These are the most general ethical question to be asked about genetic engineering, whether of plants, animals, or humans. The question may itself take two forms. In the first place, we may ask whether the benefits promised by the practice are outweighed by its possible harms. This is an ethical question posed in strictly utilitarian form. It entails looking into the future, calculating probabilities, and of course, evaluating outcomes. Benefits and harm are not self-evidently identifiable values. Secondly, we may ask whether even the benefits of the practice seem to outweigh the dangers, it nevertheless so outrages our sense of justice or of rights or of human decency that it should be prohibited, whatever the advantages. I quote. Technological disruption, that it is now talked about, can silently alter the foundations of societies. The holy grail of technology, as Rajiv Malhotra says, is artificial intelligence. Charles Darwin might have winked at his proposition of survival of the fittest if called upon to assess the expanding frontiers of artificial intelligence. Mr. Malhotra seems right in talking about the following battles vis-a-vis artificial intelligence. One, battle for economic development and jobs. Battle for power in the new world order. Battle for psychological control of desires and agency. Finally, battle for the metaphysics of the self and its ethics. Battle for India's future. These are very important battles, and I do not know whether one can have an outline of all these battles by artificial intelligence itself. These are important heads of debates. We cannot, as responsible members of legal fraternity, remain as mere passive consumers of debates. Our active engagements will bring the necessary balancing element. I consider evenings like this and congregations like this are such balancing elements. We are equally concerned with the administration of justice. While we talk about expedition in dispute resolution, dispute resolutions are becoming complex and caught in many procedural webs. We are still far away from simple and inexpensive dispute resolution. The world of tribunals and their functioning are riddled with issues, primarily due to management lapses. Every special task tribunal is caught in administrative and human resource deployment issues. Then the use of tribunals such as NCLT to matters not originally designed to apply, namely real estate resolutions, or the wide net of money laundering, etc., call for urgent attention. As I said, private initiatives in all walks of life are indispensable. A fully regulated state has been shown to be unworkable. At the same time, global thoughts on the failure of the free market in not being able to address elimination of economic inequalities and the gaps in governmental ability to deal with unemployment and other forms of deprivation are matters of undeniable importance. Each one of you here represent the face of private initiatives in industry, commerce, and new forms of public services. And each one are building blocks of a free society. In 2007, the New York Times Magazine featured a long article gushing about how historians of the future will look back on the 1990s at the time when neuroscience began to transform the American legal system. The article described how new brain scan technology and how this will eventually answer the elusive questions of just what are our deeply shared beliefs upon which the legal system should be based. Brain scan imaging and the information it reveals are indeed marvelous. Nevertheless, it is said that the excitement over law and neuroscience has not led us to great hopes. Perhaps the same can be said about every aspect of marriage between science, technology, and law. If only science could give us categories or something to measure Or if you could find the right configuration of experts, lost problems would probably resolve. But it is not to be so. When you borrow structures from science, the adaptive process breaks down, and it does so for several reasons. The most obvious reason is that we do not understand the science we're importing and applying very often. As a result, we do not allow law to evolve in a very effective and nuanced fashion. We are always in a hurry. We have learned that there are no ultimate doctrinal structures in law because there are no ultimate questions asked so far. But we reach a stage when we begin to ask very ultimate questions about what law can do in the face of what humans are doing in the rest of our lives. The two fields seem to be divided in one sense, but they are united in a fundamental sense. So today, if technology has begun to open many issues within itself, how do you find regulatory principles outside technology? Or do we locate regulatory principles within technology and science themselves? They're very important questions that I think we need to understand and grapple with them as we move ahead with technology virtually occupying every aspect of our life from morning till evening. We open up our day with WhatsApp and we end our day with WhatsApp. But if it's going to be so, if the use of technology for ease of life, the use of technology for bringing about elimination of inequalities on the one hand, on the other hand, the use of technology that can lead us in many ways beyond what we can imagine is a big question to be asked. And therefore, the ability to law to enter in very important areas of life in the past has been slow and probably not the adaptive method. We only looked at laws of contract in a very restrictive domestic sense. We looked at international law, again, from narrow domestic senses. The Cold War, after the Cold War, we had the breakdown of Soviet Russia. And today we no longer live in that area. Our commons is called the knowledge commons, but it becomes part of the world. No country or no nation can say the knowledge commons belong to us. Nothing belongs to any nation or any people whatsoever. Everything belongs to all of us. If everything belongs to all of us, knowledge commons, I think, is the fundamental thing where we bring about important changes to eliminate inequalities. And if we do so through use of law and science, I think that will be the greatest wonder that we can pat ourselves on our back. When constitutions began to look at domestic problems, they had very narrow ideas. Each constitution looked at its own nation as a unit in isolation. But today, we cannot look at it like that. So we need to have not only resources commons, but also knowledge commons. And knowledge commons can come only we break down all barriers within us. And that's where perhaps the knowledge commons in law will probably take us as quickly as possible into a world where the resources commons will be shared by each and every one of us. And I think today, when people say that the knowledge commons cannot be shared, we live in an antiquated world. The knowledge commons must be shared. One very well-known American academic, Jeremy Waldron, picked up a very important idea from a Roman jurist. He said people in ancient trade, Roman, they went to Rome to trade, but they carried with themselves their own part of the law. So we all have our own part of the law, but there are certain principles that are common to all humankind. So we've reached a stage when many principles, which will have to be necessarily become common to all humankind, will take over what's called the dark area of our bronze and iron ages of history. We need to go into a golden area where this dark area will have to probably stay away. And how do you go about doing that? And it's a very important challenge. And it is not merely stated and then answers will not come like a jukebox. Answers will come only by constant engagement, constant deliberation, and more of deliberations and thought processes. As in this context, I think kind of congregation like this make enormous sense. We need to probably have more and more platforms of enduring value and vibrant importance. So let's create as many platforms as possible where we swear to ourselves that the resources commons and the knowledge commons, which are driven by fundamental principles of fairness, equality, and equal regard, will be the future of our legal fraternity. I think all of us can do that. And let me once again thank Mr. Lalit Basin for giving this very important evening opportunity for me. And let us continue to share our thoughts and values towards moving a fair society. Thank you so much for your attention.
Dear sir, I'd request you to please stay here for a while and with great honor and admiration, present the Lifetime Achievement Award to Honorable Dr. Lalit Bhasin, the President of the Society of Indian Law Firms with us. So it's a great honor and admiration to present the Lifetime Achievement Award to Honorable Dr. Lalit Bhasin. To please present this award, I would also like to call upon stage Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India, and Honorable Mr. Justice Pankaj Mittal, the Supreme Court of India, to present this award to none other than Honorable Dr. Lalit Bhasin, everyone. Please have a huge round of applause for this Lifetime Achievement Award. The President of the Society of Indian Law Firms, India, Honorable Dr. Lalit Bhasin. Thank you, everyone. Now let's start with our award ceremony again, everyone, for which I would like to request our honorary guest, Honorable Mr. Justice Rajesh Bindalji, the Supreme Court of India, to confer our awards further. Ladies and gentlemen, the next category is the Leading Independent Lawyer of the Year in Construction, Arbitration and Litigation. And the award goes to Ms. Risha Mittal, Founder and Managing Partner at Law Chambers of Risha Mittal. Let's have a huge round of applause, everyone, for Ms. Risha Mittal. And to confer this award, I would request Honorable Mr. Justice Rajesh Bindalji to please confer this award to our recipient. Let's have a huge round of applause, everyone, for the well-deserved recipient.
Thank you, LexTalk. And I would like to thank my parents, my daughter, this is for my daughter, and my family, my father who's here with me today. And getting this recognition in construction arbitration is a big achievement, especially when we see how construction arbitration has really grown over time. And even with the advent of and the changes in the arbitration law, we see how it's become so time effective, and which is why I think the development and growth of this legal and litigation and our arbitration industry has really, I think, taken all the young lawyers. So thank you, Lex, for this encouragement. And thank you, sir. It's a great honor.
Thank you, ma'am.
To
Thank
receive
you.
an award from you, sir.
The next category, ladies and gentlemen, is the Leading General Counsel of the Year in Corporate, Commercial, Debt and Equity Funding and Public Policy. And the award goes to Mr. Pratyush Ambuj, General Counsel, Head of Public Policy and Government Affairs at Everywhere as a Service Private Limited. Let's have a huge round of applause, everyone, for Mr. Pratyush Ambuj. I would request Honorable Mr. Justice Rajesh Bindalji to please confer the award to our well-deserved awardee. Let's have a huge round of applause, everyone. Thank you, sir. The next category, ladies and gentlemen, is the Inspiring Independent The next category, ladies and gentlemen, is the Inspiring Independent Lawyer of the Year in corporate and commercial law, and the award goes to Dr. Avinash Podar as an independent lawyer. Let's have a huge round of applause, everyone. And I would request, sir, to please confer the award to our awardee. Thank you, sir, for this well-deserved award. The next category, ladies and gentlemen, is the Leading Technology Transfer Professional of the Year in Technology Transfer, IP Litigation Patent. And the award goes to Dr. Amresh Panda, Head Technology Transfer Office, KIIT TBI at KIIT University. Let's have a huge round of applause, everyone. Thank you, sir, for conferring the awards for us. And congratulations, Dr. Amresh Panda, for this well-deserved award. Can we have a huge round of applause, ladies and gentlemen? Moving on, the next category, ladies and gentlemen, is the Leading Technology Transfer Office of the Year in Technology Transfer IP Patent. And the award goes to KIIT TBI Technology Transfer Office, KIIT University. Let's have a huge round of applause, everyone. And I would request Honorable Mr. Justice to confer the award to our awardees. Thank you, sir. And thank you, Honorable Mr. Justice Rajesh Bindal, the Supreme Court of India, for facilitating our awards. Now moving on, I would request Honorable Mr. Justice Pankaj Mittal, the Supreme Court of India, to welcome on stage and facilitate our awardees. Let's have a huge round of applause, everyone, for Honorable Mr. Justice Pankaj Mittal, the Supreme Court of India. And next up, we have the awardees in the Inspiring category. The category is Inspiring Independent Practitioner of the Year in Real Estate. And the award goes to Advocate Meenal B. Khona. Let's have a huge round of applause, everyone, for Advocate Meenal. And I would request Honorable Justice, Mr. Justice Pankaj Mittal ji, the Supreme Court of India, to confer our awards for our well-deserved awardee. Thank you, sir, for conferring the award. Sorry, we are running out of time, so we cannot give you the time for thank you speech. Our concerned person is waiting outside at the media bite section for all the awardees for their thank you speech over there. Thank you, and thank you for your cooperation and understanding. Thank you, everyone. The next category, ladies and gentlemen, is Inspiring Managing Partner of the Year in Corporate Infrastructure, Regulatory and Compliance. And the award goes to Mr. C.R. Dua, the Chairman of Dua Associates. Let's have a huge round of applause, everyone, for C.R. Dua to please come up on the stage and confer the award by our honorary guest, Honorable Mr. Justice Pankaj Mittal. Let's have a huge round of applause, everyone. The next category, ladies and gentlemen, is the Inspiring Dispute Resolution and International Trade Lawyer of the Year. And the award goes to Shiraz Patodia, Senior Solicitor at Dua Associates. Let's have a huge round of applause for Shiraz Patodia, the Senior Solicitor at Dua Associates. We would request Honorable Mr. Justice Pankaj Mittal to confer the award to a well-deserved awardee. Let's have a huge round of applause, everyone. The next category, ladies and gentlemen, is the Inspiring Law Firm of the Year in Arbitration, Civil and Commercial Litigation. And the award goes to CNS Juris. Let's have a huge round of applause, everyone, for CNS Juris. Thank you, sir, for conferring the award. Next up, ladies and gentlemen, is the Inspiring Independent Lawyer of the Year in Arbitration, Corporate, Commercial, White-Collar Crime, Ms. Dara Boina Yadav, Advocate at Supreme Court of India, Arbitrator Certified IIAM, Messrs. Prism Legal Associates. Let's have a huge round of applause for Mr. Dara Boina Yadav. Thank you, sir, for this well-deserved award. Many. Next up, is the Inspiring Constitutional and Taxation Laws Expert of the Year, and the award goes to Dr. Venkata Krishnamurthy, who is the Senior Designated Partner at Legalist Solutions LLP, Hyderabad. Let's have a huge round of applause, everyone, for Dr. Venkata Krishnamurthy. Our concerned person is waiting for all our awardees at the Media Byte section outside. Thank you for cooperating, everyone. The next category is the Inspiring Managing Partner of the Year in IP Protection, Counseling and Strategy. And the award goes to Ms. Gunjan Pahadia, Managing Partner at ZSIP Advocates LLP. Let's have a huge round of applause, everyone, for Ms. Gunjan Pahadia. Mr. Gunjan Pahadia, the Managing Partner at ZSIP Advocates LLP. Let's have a huge round of applause, everyone. Next up is the Leading Law Firm of the Year in Intellectual Property Trademark, and the award goes to Trademarks. Let's have a huge round of applause, everyone, for Trademarks. I would request our Honorable Mr. Justice to please present this award to Trademarks. I would like to congratulate all our awardees. I would also like to thank our Honorable Mr. Justice Pankaj Mittal to join us here and confer the awards for us. Thank you, sir, for facilitating our awardees. Next up, I would like to call upon stage Honorable Shri R. Venkatramani, the Attorney General of India with us, the chief guest, to facilitate our awardees with this prestigious Lex Falcon Global Awards. Let's have a huge round of applause, everybody, for Shri R. Venkatramani, the Attorney General of India. The next category, ladies and gentlemen, is the Inspiring Independent Lawyer of the Year in Real Estate and Corporate Laws. And the award goes to Jana Govardhana Maheshwaram, Principal Consultant at Samara Juris. Let's have a huge round of applause, everyone, for Mr. Jana Govardhana. I would request, sir, to please confer the award to our well-deserved awardee. A huge round of applause, everyone. Next up is the Excellence in Service Award in Public Interest Litigation. And the award goes to Karthikeyan M, the Senior Central Government Panel Counsel at MK Associates. Let's have a huge round of applause, everyone, for Mr. Karthikeyan M. I think he's not present here. So moving on, let's have the further nominees. Inspiring Corporate Council of the Year in Securitization, Alternate Dispute Resolution, and Defense Litigation. And the award goes to Mr. Kumar Raman Srivastava, the Senior Deputy General Manager and Legal Head at SOM Group of Companies. Let's have a huge round of applause, everyone, for Mr. Kumar Raman Srivastava. And I would request our Honorable Attorney General of India to confer our award. Let's have a huge round of applause. The youngest budding lawyer with us. Thank you, sir, for your kind gesture. Now moving on, the Inspiring Intellectual Property Lawyer of the Year in IP Litigation, IP Strategic Advisory and Advocacy. And the award goes to Lakshmi Devi Somanath, partner at Intellectual Property Practice at Surana and Surana International Attorneys. Let's have a huge round of applause, everyone, for Miss Lakshmi Devi. Next up is the Inspiring Corporate Council of the Year in Banking and Finance, Regulatory and Compliance, Risk and Corporate Governance. And the award goes to Manoj Gujaran, Chief Compliance Officer, Head Legal and CSR at Poonawalla FinCorp Limited. Let's have a huge round of applause, everyone, for Mr. Manoj Gujaran. Next up is the Inspiring Corporate Council of the Year in Corporate Transaction. So the award goes to Ms. Meenal Parswani, Head at Legal Risk and Compliance at Trustee Company Limited, SBI Cap. Let's have a huge round of applause, everyone, for Ms. Meenal Parswani. I would request, sir, to please confer the award. Next up is the Inspiring Managing Partner of the Year in Arbitration, Banking and Finance and Construction, Taxation. And it goes to none other than Ms. Monica Romalina Sejabat, Managing Partner at MRS Business Professional Consulting, who is also our Powered By and Cocktail sponsor. Let's have a huge round of applause, everyone, for Ms. Monica Romalina Sejabat. I would request, sir, to please confer the award to our Powered By sponsor, MRS Business Professional Consulting. Let's have a huge round of applause, everyone. I would like to thank our honorary guest, Next up is the Inspiring General Counsel of the Year in Banking and Finance. And the award goes to Prashant Narayan. Let's have a huge round of applause, everyone, for Mr. Prashant Narayan. Can you please quickly come up on stage and confer the award? Next up is the Inspiring General Counsel of the Year in Private Equity, Venture Capital and Funds. And the award goes to Mr. Prashant Agarwal, General Counsel, Legal Head at SAR Group of Companies. Let's have a huge round of applause, everyone, for Mr. Prashant Agarwal. So can you quickly come up on stage and receive the award by our Attorney General of India, Sri R. Venkatramani. Next up is the Inspiring Independent Lawyer of the Year in Telecom, Media and Technology. And the award goes to Mr. Rajkumar Warrior, the Independent Lawyer. Let's have a huge round of applause, everyone, for Mr. Rajkumar Warrior. Sir, can you please quickly come up on stage and receive the award by our Honorable Attorney General of India, Sri R. Venkatramani. Next up is the Inspiring General Counsel of the Year in Corporate Law, Litigation, Competition Law, and Data Privacy. And the award goes to Saikat Sarkar, Global General Counsel at Eicher Motors Limited. Let's have a huge round of applause, everyone, for Saikat Sarkar. The last award in the Inspiring category is the Inspiring Legal Head of the Year in India in Dispute Resolution, M&A, Risk and Corporate Governance. And the award goes to Sonal Sharma, Vice President Legal at HCL Technologies Limited. Let's have a huge round of applause for Ms. Sonal Sharma on this well-deserved award. With this, I would like to thank our Honorable Attorney General of India, Sri R. Venkatramani, our chief guest. Thank you so much, sir, for conferring the awards for us. It is our privilege to have you here with us. Let's have a huge round of applause, everyone, for the Attorney General of India, Honorable Sri R. Venkatramani. Now I would request Honorable Dr. Lalit Bhasin to come up on stage and please confer the awards for us, sir. Let's have a huge round of applause, everyone, for Honorable Dr. Lalit Bhasin. The next award, ladies and gentlemen, is the Leading Corporate Legal Team of the Year in Corporate Commercial Data Protection and Privacy, Advisory and Dispute Resolution. And the award goes to the Corporate Legal Group, HCL Technologies Limited. Let's have a huge round of applause for the team of HCL Technologies Limited. And I would request, sir, to please confer the awards for us. Let's have a huge round of applause, ladies and gentlemen, for the whole team of HCL Technologies Limited. Next up is the leading in-house lawyer of the year in corporate commercial data protection and privacy, technology transactions, advisory, and dispute resolution. And the award goes to Srijit Mukherjee, Director Legal at HCL Technologies Limited. Let's have a huge round of applause, everyone, for the Director Legal at HCL Technologies, Mr. Srijit Mukherjee. Next up is the Emerging Lawyer in a Law Firm of the Year in Intellectual Property, Media and Entertainment. And the award goes to Ms. Niharika Gaonkar Naikar. Let's have a huge round of applause, everyone, for Ms. Niharika. Congratulations. Next up is the Emerging Independent Practitioner of the Year in Criminal, Family and White Collar Crime. And the award goes to Nirmal Preet Singh Hira, Principal Attorney at HP SHF Legal Attorneys and International Legal Consultants. Let's have a huge round of applause, everyone, for Mr. Nirmal Preet Singh. Next up is the Emerging In-House Lawyer of the Year in Intellectual Property, Litigation and Trademark. And the award goes to Pazal Arora, Legal Counsel at Wimzo Games Private Limited. Let's have a huge round of applause, everyone, for Miss Pazal Arora. Next up is the Emerging Corporate and Commercial Lawyer of the Year. And the award goes to Pranay Sohini. Let's have a huge round of applause, everyone, for Mr. Pranay Sohini. And I would request Honorable Dr. Lalit Bhasin, sir, to please confer the award, the Lex Falcon Global Awards, everyone. Next up is the Emerging Corporate Counsel of the Year in Corporate Regulatory and Compliance and Contract Management. And the award goes to Ms. Preeti Chokalingam, Senior Legal Counsel at Vanteva India Private Limited. Let's have a huge round of applause, everyone, for Ms. Preeti. All our awardees are requested to please wait outside for the media bites. Next up is the Emerging Corporate Counsel of the Year in Corporate Law, Labor Law, and Data Privacy Law. And the award goes to Ms. Priyanka Anand. Let's have a huge round of applause, everyone, for Ms. Priyanka Anand. Next up is the Emerging Independent Lawyer of the Year in Dispute Resolution. And the award goes to Razel Mehdi Parvez, the Independent Lawyer. Let's have a huge round of applause, everyone, for Mr. Razel. Next up is the Emerging IP Practitioner of the Year in Intellectual Property, Trademarks, Media and Entertainment. And the award goes to Ms. Renuka Rajan. Let's have a huge round of applause, everyone, for Ms. Renuka Rajan. I would request her to quickly come up on stage and receive the award from Dr. Lalit Bhasin, sir. Next up is the Emerging Corporate Legal Counsel of the Year in Real Estate, Corporate Laws and Regulatory Compliance. And the award goes to Rohit Dhanpal Soni. Let's have a huge round of applause, everyone, for Mr. Rohit Dhanpal Soni. I would request Sir to please confer the award. Next up is the Emerging Independent Practitioner of the Year, Criminal and Corporate, Commercial Litigation and Arbitration. And the award goes to Mr. Sahil Salvi, the counsel at Bombay High Court. Let's have a huge round of applause, everyone, for Mr. Sahil Salvi, the counsel at Bombay High Court, for this well-deserved Lex Falcon Global Award. Next up is the Emerging Independent Lawyer of the Year in Litigation, Arbitration and Corporate. And the award goes to Saloni Gule, founder at SMG and Company. Can we have Ms. Saloni quickly come upon stage and receive the award from Honorable Dr. Lalit Bhasin. Let's have a huge round of applause, everyone, for Ms. Saloni Gule. Next up is the Emerging Independent Lawyer of the Year in Litigation, Criminal, Civil, Data Protection and Cybersecurity Law.
I am tempted, you see, to say that it's such a pleasant sight to see so many ladies receiving the awards.
Let's have you.
On the eve of the International Women's Day, I think it's a big tribute to the talent and competence of our lady lawyers.
Thank you, sir. Thank you for motivating all the women in the house. Next up was the Emerging Independent Lawyer of the Year in Litigation, Criminal, Civil, Data Protection and Cybersecurity Law. And the award goes to Ms. Samriddhi Arora, the Independent Lawyer. Can we have Ms. Samriddhi Arora to join us on stage, please? Next up is the Emerging Corporate Counsel of the Year in Taxation, and the award goes to Mr. Sandeep Raghavan. Let's have a huge round of applause, everyone, for Mr. Sandeep Raghavan. He is the Emerging Corporate Counsel of the Year in Taxation to receive the Lex Falcon Global Award. Next up is the Emerging Independent Lawyer of the Year in IP, Litigation and Real Estate. And the award goes to Ms. Sanya Arora. Let's have a huge round of applause, everyone, for Ms. Sanya Arora. Can we quickly have upon stage Ms. Sanya Arora, the Emerging Independent Lawyer of the Year in IP, Litigation and Real Estate, to confer this well-deserved award. Let's have a huge round of applause, ladies and gentlemen. Next up is the Emerging Independent Lawyer of the Year in Litigation. And the award goes to Ms. Surbhi Singh, the advocate at Supreme Court of India. Let's have a huge round of applause, everyone, for Ms. Surbhi Singh. I think she's just coming. Okay. Let's welcome Ms. Surbhi Singh, advocate at Supreme Court of India, everyone, as the Emerging Independent Lawyer of the Year in litigation to receive the Lex Falcon Global Awards. Next up is the Emerging Legal Advisor of the Year in Litigation, Civil, Family and Educational Institutions. And the award goes to Ms. Venishri Rao, Legal Advisor and Panel Advocate at DLSA. Ms. Venishri Rao. Next up is the Emerging Legal Educator of the Year, Administrative Litigation and Educational Institution. And the award goes to Vinita Pundar, Campus Director, IPSAR Group of Colleges, Karjat. Let's have a huge round of applause, everyone, for Miss Vinita. I think she's not present in the house. So I would like to thank taking it on the behalf of Miss Vinita Pandil. Now, I would request everyone to please be seated. Sir is still here with us. We can have a one-on-one meeting with him, but I would request everyone to please be seated. And I would like to thank our Honorable Shri Dr. Lalit Basin, the President, Vice President, the President of SILF with us. Let's have a huge round of applause, everyone, for Honorable Dr. Lalit Basin. And I would request everyone to please be seated. Now I would request the Director of Clickaway Creators Media LLP, Mr. Abhishek Gaurav, to please join us on stage and confer the award. Legal Influencers of the Year, the finalists were Law Putra, Legally Legitate, Legal Bate, and Legal Rights. And amongst these finalists, the award goes to Law Putra as the Legal Influencer of the Year. Let's have a huge round of applause, everyone, for Law Putra as the finalist receiving the award in the Legal Influencer of the Year. I would request, sir, to please confer the award. Next up is Leading In-House Lawyer of the Year in Litigation Management, Contract Management, and Legal Compliance Regulatory Affairs. And the award goes to Abu Zafar Obidullah Chaudhary. Let's have a huge round of applause, everyone, for the Senior Manager and Head of Law, Summit Alliance Port Limited, Bangladesh, Advocate, Supreme Court of Bangladesh, to join us here and receive this award. Next up is the Leading Managing Partner of the Year, Corporate and Transaction Advisory, FinTech and Financial Fraud. And the award goes to Mr. Ashish Srivastava, Managing Partner at Equicorp Associates LLP, Advocates and Solicitors. Let's have a huge round of applause, everyone, for Mr. Ashish Srivastava. Can we have upon stage Mr. Ashish Srivastava to receive the award from our director, Mr. Abhishek Gaurav. Next up is the Leading Law Firm of the Year in Tax Law. And the award goes to Ace Legal. Let's have a huge round of applause, everyone, for Ace Legal to receive the award from our director, Mr. Abhishek Gaurav, the Lex Falcon Global Awards. Next up is the leading independent practitioner of the year in litigation and taxation. And the award goes to Amit B. Singh, advocate. Let's have a huge round of applause, everyone, for Mr. Amit to receive the award in the leading independent practitioner of the year in litigation and taxation. Many congratulations, sir, for receiving the Ed Falcon Global Awards. Next up is the leading digital dispute resolution specialist of the year, offshore, contracts, family office, and property litigation. And the award goes to Miss Anisha, director at Aston Weir Law Company, London, and head of mediation, Assertive Group, Switzerland. So I think she's not here. Next up is leading corporate counsel of the year in regulatory and compliance, and the award goes to Ms. Divya Lakshmi, ethics and compliance, privacy and info security at Eli Lilly Services India Private Limited. Let's have a huge round of applause, everyone, for Ms. Divya Lakshmi to receive the Lex Falcon Global Awards. Next up is the leading independent practitioner of the year in arbitration, mediation, and litigation. And the award goes to Gizem Yilmaz, founding partner at Topers and Partners Consultancy Law Firm. Let's have a huge round of applause, everyone, for Ms. Gizem, who came all the way from Turkey to join us here for the Lex Falcon Global Awards. I would request, sir, to please confer the award. Can we have some noise, ladies and gentlemen? Next up is the leading legal tech expert of the year in innovation management, strategic application development, security architecture. And the award goes to Mr. Gururaj B. Shetty, head of emerging tech at Signedesk, who's also our sponsor. Let's have a huge round of applause, everyone, for Signedesk and for Gururaj B. Shetty, the head of emerging tech, who's receiving the leading legal tech expert of the year award. Let's have a huge round of applause. Leading corporate counsel of the year in competition, antitrust, corporate, commercial, and litigation. And in this category, the award goes to Mr. Hemant Makkar, legal and corporate governance at Hyundai Motor India Limited. Let's have a huge round of applause, everyone, for Mr. Hemant Makkar to receive the Lex Falcon Global Awards in the leading corporate counsel of the year. Next up, ladies and gentlemen, is the leading lawyer of the year in criminal, corporate, commercial, bankruptcy, and insolvency. And the award goes to Mr. J. Ashwin Bhai Bhagdev, practicing advocate at Gujarat High Court. Let's have a huge round of applause, everyone, for Mr. J. Bhagdev to receive the award as the leading lawyer of the year. Next up is the leading corporate counsel of the year in litigation management and anti-corruption. And the award goes to Mukta Gupta, senior counsel, legal and compliance, India-US enterprise risk management in Strides Pharma Science Limited. Let's have a huge round of applause, everyone, for Mukta Gupta to receive the Ed Falcon Global Award. Next up is the leading independent lawyer of the year in anti-corruption and white-collar crime. And the award goes to N. Annapurna, Messrs. Annapurna Advocates and Association, to receive the Lex Falcon Global Awards. Let's have a huge round of applause, everyone, for Miss N. Annapurna to receive the Lex Falcon Global Award. Next up is the leading corporate counsel of the year in litigation management, and the award goes to Narendra Singh Khichi, Chief Manager Band 2 at ICICI Bank Limited. Let's have a huge round of applause for Mr. Narendra Singh to receive the Lex Falcon Global Award. Next up is the leading independent lawyer of the year in arbitration, dispute resolution, and taxation. And the award goes to Mr. Nikhil Kumar, partner at R&B Legal. Let's have a huge round of applause, everyone, for Mr. Nikhil Kumar to receive the Lex Falcon Global Awards 2024. Next up is the leading corporate counsel of the year in white collar crime. Next up is the leading corporate counsel of the year in white collar crime, banking and finance, and the award goes to Mr. Prakhar Srivastava. Let's have a huge round of applause, everyone, for Mr. Prakhar Srivastava. Next up is the leading managing partner of the year in litigation and ADRs, and the award goes to Mr. Pranil K. Sonavane, managing partner and standing counsel at KLS Legal. Let's have a huge round of applause, everyone, for Mr. Pranil. I think Mr. Pranil is not here. So moving on, leading legal counsel of the year in anti-bribery and corruption, and the award goes to Mr. Prateek Sharma, Director at Legal and Compliance. Do we have Mr. Prateek Sharma here with us? I would request to quickly come up on stage and receive the Lex Falcon Global Awards. Next up is the leading independent lawyer of the year in media and entertainment. And the award goes to Ms. Priyanka Vinay Chaudhary, founder at Priyanka Chaudhary and Associates. Let's have a huge round of applause, everyone, for Ms. Priyanka Vinay Chaudhary. Next up is the leading legal educator of the year in environmental ecology and IP technology. And the award goes to Professor Aparna Uma Raman, visiting professor and expert educator, India and Singapore, global legal policy consultant and director at ANSP. Let's have a huge round of applause, everyone, for Professor Aparna. Next up is the leading corporate and commercial lawyer of the year. That goes to Ronak Ajmera, partner at JSA. Let's have a huge round of applause, everyone, for Mr. Ronak Ajmera to receive the Lex Falcon Global Awards in the leading corporate and commercial lawyer of the year. Next up is the leading independent practitioner of the year, and the award goes to Sakar Sardana, independent legal practitioner, Chambers of Sakar Sardana. Let's have a huge round of applause, ladies and gentlemen, for Mr. Sakar Sardana as the independent legal practitioner. Thank you for your cooperation, everyone. Next up is the leading independent practitioner of the year in criminal litigation and real estate. And the award goes to Mr. Sandeep Chaudhary, Advocate on Record, Supreme Court of India. Let's have a huge round of applause, everyone, for Mr. Sandeep Chaudhary, who is receiving the Lex Falcon Global Awards. Next up is the leading corporate counsel of the year in intellectual property, labor and employment, regulatory and compliance. And the award goes to Satish Kumar T, legal and corporate governance at Hyundai Motor India Limited. Mr. Satish Kumar, I would request you to please come up on stage. Thank you for cooperating so much to all our awardees. Next up is the leading independent lawyer of the year, corporate and commercial law, and the award goes to Mr. Siddharth Bhatli, the independent lawyer. Mr. Siddharth, please receive the Lex Falcon Global Awards. Next up is the leading law firm of the year, dispute resolution family, Tran Legal and Mediation. Let's have a huge round of applause, everyone, for Tran Legal and Mediation. Tran Legal and Mediation, the leading law firm of the year in dispute resolution and family. Next up is the Legal Tech Company of the Year in IP, Patent and Trademark, and the award goes to Trexo Global. Let's have a huge round of applause, everyone, for Trexo Global. I think we don't have them with us right now. Leading Lawyer of the Year in Arbitration, Dispute Resolution and Litigation goes to Varun S. Ahuja. We have Trexo Global. Let's have a huge round of applause, everyone, for Trexo Global. Next up is the Leading Lawyer of the Year, Arbitration Dispute Resolution, and the award goes to Varun S. Ahuja. Let's have a huge round of applause, everyone, for Mr. Varun S. Ahuja, who's the partner at Ahuja Law Offices, to receive the award in the Leading Lawyer of the Year. Next up is Leading Corporate Counsel of the Year, IP, Data Privacy, Compliance. Thank you, sir, for joining us and conferring this award to Mr. Varun S. Ahuja, partner at Ahuja Law Services, as the Leading Lawyer of the Year. Next up is the Leading Corporate Counsel of the Year in IP, Data Privacy, Compliance, and Contract Management. And the award goes to Mr. Vidhi Jain, Senior Legal Counsel at Medanome Labs Limited. We really would like to congratulate all the winners and would like to apologize for this hustle at the very last moment because we are time bound, and thank you for your cooperation. And the last 3 awards are left. Please, I would like to request everyone to be seated and cooperate with us. Next up is Leading Corporate Counsel of the Year in IP, Data Privacy, Compliance and Contract Management, and the award goes to Ms. Vidhi Jain, Senior Legal Counsel. I think we're done with that. Really apologize again. Next up is Leading Corporate Counsel of the Year, Corporate Commercial, IP and Risk and Corporate Governance. And the award goes to Viral Tripathi, Senior Vice President, Legal and Compliance, Panamax Infotech Limited, a part of Bankai Group of Companies. Next up is the Emerging Lawyer of the Year in Bankruptcy, Criminal and Litigation. And the award goes to Apurva Agarwal, partner at ASV Legal LLP. Let's have a huge round of applause, ladies and gentlemen. And thank you for bearing with us. And last but not the least, I would like to request to come up on stage Mr. Sandeep Surana, partner at Surana and Surana International Attorneys, to receive the award in the Leading Lawyer of the Year in a law firm in white collar crime. To receive this award, the LexTalk Global Awards. Thank you and congratulations to all our awardees. And with this, we come to the end of day 2 and the award ceremony, the Lex Falcon Global Awards. Thank you so much, everyone, for bearing with us. I hope you enjoyed these 2 days as much as we did, and that you're taking away a lot of knowledge and strong networks. Till then, I would request everybody to have a networking session during our cocktail reception.